Counsel for a petitioner filed a memo for withdrawal of the petition. Memo is placed on record. Hence, the petition is dismissed as withdrawn. Hmm. 61. The learned counsel for petitioner submit that the default bail has been granted to the petitioner, and as such, this petition has become infructuous. The submission is placed on record. The petition is dismissed as it has become infructuous. 60? 2 weeks. ಅವ್ರು ಬರ್ಲಿ ನೋಡೋಣ ಅವ್ರು ಬಂದಾಗ ನೋಡ್ತೀನಿ ಪಾರ್ಟೆಡ್ ಇದೆ. Then why did you move it? Why did you move it? Why did you move it? When there are office objections, when you are unable to comply, why did you move it? 2 weeks kodi. 18th. You are consuming the space of other petition agalla. Move ಮಾಡ್ತೀರಾ ನೀವು ಕಂಪ್ಲೈನ್ಸ್ ಇರೋಲ್ಲ ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ತೀರಿ ಕಂಪ್ಲೈನ್ಸ್ ಗೆ. Compliance ಇದ್ದು ಮೂವ್ ಮಾಡಕ್ ಹೋಗಿ better unless they are complied. Don't entertain the memo. Compliance ಇದ್ದು don't entertain memo unless they are complied. ಉಳ್ಕಿವೆಲ್ಲ ಕಾಮನ್ 1 week 2 weeks as per the ಕೊಡಿ. The learned counsel for petitioner filed a memo for withdrawal of the petition. Memo is placed on record. The petition is dismissed as withdrawn.
They 1, 2, 3 have granted bail subsequent to rejection of
Let it be. Our object notice ತಗೋಬೇಕು. Different grounds will be there. ಅವ್ರು ಆಮೇಲೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಅದಕ್ಕೆ ನಂದು ಇನ್ನೊಮ್ಮೆ ಎಂಟರ್ಟೈನ್ ಮಾಡ್ರಿ. No sir, that will be considered on merits only. 1 week ಎಲ್ಲ ಅವನ್ನೆಲ್ಲ ನೋಟಿಸ್ ತಗೊಳ್ರಿ ನೀವು. HCGP 21 to 33. The learned counsel for a petitioner called out absent. There is no representation list after 2 weeks. Learned counsel for a petitioner called out absent. List after 2 weeks. Yes. (161) statement disclose that you have committed sexual assault against her will. 161 statement clarifies it. And you are arguing that 161 statement. Sir, page number 23. Nodi, 161 dated statement dated 29/3.
First statement. There are two statements.
29/3. Even she has given a statement that under fear she could not disclose it to anybody earlier. And medical report disclosed that hymen was not intact. She has undergone sexual assault.
Not when she left the company after the accused. But Lakshmi take the rules. ಯಾವಾಗಲೂ 2-3 ತಿಂಗಳಿಂದ ಹೇಳ್ತಾನೆ ಅವಳು. But whether that is with okay and that 29 discloses. Only in the first statement, and the other point of time, Lakshmi take the rules. 164 section. Also, generations are made. After 1 month.
161 initial statement disclosed that though there is no penetration sexual assault, the other assault was there. He kissed her, he touched her entire body, embraced her, all are there. He enticed her by threatening that he's going to marry her and take her to Mysore against her will. What do you want then? What else you want?
She is not minor, it's 17.
17 years is minor. 17 years as per Folks Act, she is a minor. She may be able to understand the facts, but having knowledge of her minority, if you submit it, then I'll record it also. 164 statement prevails, I'll record it. Though if there is 164 statement, there is no need for further trial then. Further trial avashyakate nahi illalla. It should be given important straightway, it should be accepted. It should be tested during the course of the cross-examination, Alva. As you test 161 statement also, 164 statement has got better, to that extent it has. 161 compare madre, 164 statement has got a better reliance initially. But again, it is subject to cross-examination. Request list. ಏನ್ರಿ ಎಲ್ಲ ಬರೇ 376 ಬರ್ತಾ ಇದಾವೆ. All on 90% matters are now only 376. 376 POCSO coupled with 354. ಬೇರೆ matters ಇಲ್ಲ. Where we are heading? Learned counsel for petitioner called out absent. Which after 3 weeks. .1 ಕೊಡಿ. You have filed the petition about 2 months back. Still, you are not in a position to comply the office objections. You have been granted 4 adjournments. You are not even prepared, and you are in a habit of seeking adjournment. Why? What was the need? Then you do one thing. After getting that document, you move bail petition. Till then, yeah, we will dismiss the bail petition. There was no need for this petition to be kept on the file of the court. Even see, ನೀನ್ apply ಮಾಡಿದೀನಿ ಅಂತ ಹೇಳಿ 5th time ಬಂದ್ ಹೇಳೋದು importance ಅಲ್ಲ. 2 months back you have filed petition. Office has raised immediate objections. and you are not prepared to comply the office objections. ನಿಮಗೇನು ಅರ್ಜೆನ್ಸಿ ಅದ್ರಿ ಮತ್ತೆ 439 ಕೆಳಗೆ ಹಾಕ್ತಿರಿ, ಅರ್ಜೆನ್ಸಿ ಇರೋದಿಲ್ಲ ಮತ್ತೆ ವಾಟ್ ಈಸ್ ದಿಯರ್ ನೆಸೆಸಿಟಿ ಟು ಫೈಲ್ ಸೋ ಹರಿಡ್ಲಿ? .1, the learned counsel for petitioner placed time. Already 2 weeks time was finally granted for compliance of the office objections, and again time is being sought as a final chance. Reach the matter next week, and if the petitioner fails to comply the office objection, matter shall be listed. 41 just adjourn. Also
number 2 and 3.
you not complied the office objections, sir. ನನಗೆ ಗೊತ್ತಿಲ್ಲ why you impleaded. When you implead you must pay process fee. Order ಆಗಿದೆ, process fee ಕೊಡೋಂಗಿಲ್ಲ. Office has raised objection, it is not posted for orders. In fact, it is posted for compliance of office objection. It is not for, it is only for 307. Who has asked you to implead respond number 2 then? You implead respond number 2 and don't want to take steps, and you find fault with the court. Only 3707 ಇದೆ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡ್ಬೇಕು? Why, what, who has compelled you to implead? Who has compelled you to implead? You have got impleaded voluntarily. If she is impleaded in the trial court, I will not exempt. I take it. She is there in the trial court also. Whatever it may be, she was a party before the trial court. She was a party before the trial court. Order to clearly disclose. So let there be notice. PF code. So whatever it may, whether it is allowed or dismissed, we are not concerned. We are not going to that matter at this juncture. Respondent number 2, you have impleaded. She was a party before the memo code. ಅವ್ರು ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡಿದೀರಾ, ಲೆಟ್ ಹಿಮ್ ಫೈಲ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಮೆಮೊ, then we'll consider it. ನೀವೇ ಇಂಪ್ಲೀಡ್ ಮಾಡುವ ಅವಶ್ಯಕತೆ ಇತ್ತ ಇಲ್ಲ ಮೊದಲು ನೀವು ವಿಚಾರ ಮಾಡ್ಬೇಕು. ಅದನ್ನ ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ಮುಂದೆಲ್ಲ ಕತೆ ಹಿಂಗಾಯ್ತ್ರಿ ಹಂಗಾಯ್ತ್ರಿ ಈಗ ನಾನು ಬಿಡ್ತೀನ್ರಿ ಅಂತಂದ್ರೆ, ಅವಶ್ಯಕತೆ ಇದ್ದಾಗ ಮ್ಯಾಂಡೇಟರಿ ಇದ್ದಾಗ ಇಂಪ್ಲೀಡ್ ಮಾಡಿ. ನೀವು ಇಂಪ್ಲೀಡ್ ಮಾಡದೇ ನಾವು ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡ್ತೀವಿ. ಇವಾಗ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ ಮೇಲೆ ಏನಾಗ್ಬೇಕಾಗಿ ಕೊಡಿ. 44, 45 ಎರಡು ತೆಗೆದಿಡಿ. ಅದಕ್ಕೆ ನಾನೇನ್ ಮಾಡ್ಬೇಕ್ರಿ? ನಾನು ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೆ? ನೀವು ಅಲ್ಲಿ ಮಾಡಿದ್ರಿ ಅಂತ ಹೇಳಿ ಐ ಆಮ್ ನೋ ಕನ್ಸರ್ನ್ಡ್. ಆ ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಆಗುವವರೆಗೆ ಇದನ್ನ ಪೆಂಡಿಂಗ್ ಇಡುವ ಅವಕಾಶ ನನಗಿಲ್ಲ. ನೀವು ಕ್ವಾಶನ್ ಕೇಳಿದ್ರಿ, ಅದಕ್ಕೆ ಬೇಲ್ ಪಿಟಿಷನ್ ನಾನು ಗ್ರಾಂಟ್ ಮಾಡಿದೆ, ಹೆಲ್ಡ್ ಅಪ್ ಮಾಡ್ರಿ ಅನ್ನಕ್ ಬರಲ್ಲ. ಅವ್ರು ಕ್ಯಾನ್ಸಲೇಷನ್ ಕೇಳಿದಾರೆ, ದೇರ್ ಪಿಟಿಷನ್ ಇಸ್ ಟು ಬಿ ಕನ್ಸಿಡರ್ಡ್, ದಟ್ಸ್ ಆಲ್. Sir, petitioner Nataraj HC, the learned counsel for petitioner called out absent the counsel for respond number 1 and HCGP for R2 present least after 2 weeks. Huh. ಏನಾಯ್ತು? ಅಲ್ಲ ಅದ್ರ ವಕಾಲತ್ ಹಾಕಿದಾರಲ್ರಿ ಅವರು, ಇದ್ರಲ್ಲಿ ಎಲ್ಲಿ ಕೇಳಿದೇನೋ? ಇದ್ರಲ್ಲಿ ಏನೋ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. He has filed power, he has also filed objections for respondent number 2 regarding cancellation. Signature varies. Huh. ಏನಿದೆ ಕೊಡಿ. Is there any stay? Stay ಕೊಟ್ಟಿದ್ದಾರೆ from 26/9. Till then. There is a clear breach of bail conditions. On 15/8 you did not appear. Stay was granted on 26/8 as per your own content. 15/8 you did not appear, that was the affidavit. Thereafter 17/8 he has issued notice, 18/8 he has issued notice, then you did appear. I'm not, 1 day to ill day to ನಿಮಗೆ ಏನು ಎಕ್ಸ್ಪ್ಲೇನೇಷನ್ ಕೇಳಿದೀವಾ? You did not appear, you did fail to comply the conditions ಅಂತ ಅಷ್ಟೇ ಹೇಳಿದ್ದೀನಿ ನಾನು. What is the reason? ಅದನ್ನು you will have to explain during the course of hearing, not at this juncture. The learned counsel for the learned HCGP filed a copy of the affidavit submitted by the IO. Is the matter after 2 weeks. Learned counsel for petitioner called out absent. Just after 2 weeks. ಹೇಳಿ 41-45 ತೆಗೆದಿಟ್ಟಿ ಅಲ್ಲ 42-45 ಎರಡು ಕನೆಕ್ಟೆಡ್ ಅವ, ಅದಕ್ಕೆ ಜೊತೆಯಲ್ಲಿ ಹೇರ್ ಮಾಡೋಣ ಅಂತ ಹೇಳಿ ತೆಗೆದಿಟ್ಟಿ. ಒಂದ್ ಹೇರ್ ಮಾಡಕ್ ಬರಲ್ಲ, ಇಟ್ ಇಸ್ ನಾಟ್ ಫೇರ್. ಎರಡು ಕೂಡಿಸಿ ಅದ್ರಾಗೂ ಅವ್ರು ವಕಾಲತ್ ಮಾಡ್ತಾರ, ವಿಲ್ ಹಿಯರ್ ಇಟ್ ಹಾಕ್ತೀನಿ ಅಂತ ಹೇಳಿದಾರೆ, ಅದಕ್ಕೆ ತೆಗೆದಿಟ್ಟಿದ್ದೀನಿ. Learned counsel for petitioner absent, no representation, list of the two.
Previous said some of the things should go on. Question of identity of petition. After the learner's decision index application, the learner's step of the prosecutor of principle. You have to also attention to the of the act. Then the appeal is provided. Proceedings are good to what we have. But I want the provisions of Criminal Procedure Code, Article 21 of the Constitution, the first case is that of the Minister and the workers union. I know this Minister and the workers union very much. It is detailed about the liberty and for all. No matter the question arose on the previous statement, whether the appeal provision will take away the jurisdiction of the court. Under section 438, 439, about 438 are both one is in anticipation, one is after detention. And both sections are concurrent in nature. Section 4 or section 10 or the honorable judge. Around this provision of appeal or the provision to deny bail have been around shown in several other recent enactments, including that of unlawful activities prevention act, around section 43D(5) of the unlawful.
In fact, we are not concerned about denial of the bail, granting of the bail. That is not the, and right of liberty, you have got 100%. Whether under the enactment, there is a opportunity was given to challenge that order or not is the only issue.
439, whether I am entitled to invoke 439.
Whether you are entitled to invoke 439 or you are supposed to come under section 15 of the act. Only two issues are to be considered.
My submission is that under section 15 of the act will not take away the powers of the constitutional court. On which side also there are some data. Whenever the bar of civil court jurisdiction is mentioned,
Hello, the bar of the civil court jurisdiction is different. Here, when a specific provision is made,
that's not our bar, a specific provision under the state act. Civil court jurisdiction insofar as it relates to granting of exemption, wherever the financial implications are there was said. The bar may not take away the jurisdiction of the High Court to issue it.
so writ jurisdiction is entirely different.
Because it confers power upon the High Court. No matter one judgment I am able to get is 2021 CH-27 Union of India versus K.A. Najib. I saw the court library also here, but it is not there in 2021 PSCC 713 Union of India versus K.A. Najib. Wherein, my lord, their lordships of the Honorable Supreme Court has held that nothing can, my lord, deprive the powers of the Honorable High Court, Constitutional Court. That there is the examination of.
Then a statute has no relevancy to a constitutional court.
Yes, my lord, the Honorable Supreme Court interpreted section 44 C5 of the UAPA Act. UAPA Act. So my submission is that, my lord. It is not difficult for me to convert the petition into.
Yeah.
I can come before your lordships. I come before your lordships. And on a lordship, I Court of Karnataka. On a different ground. One more submission I want to make is that, my lord. Entire KPIA Act or Money Laundering Act, similarly worded on sections, are, my lord, concentrated to competent authority. Whole action will have to be yesterday, the judgment also another court statement is there. The effect that it is a competent authority who has to initiate action, not the police. When the police jurisdiction has to discuss that judgment. But here,
See, that is I may concur whether a special officer is designated by the state, whether special court is designated, those are different things. This KPID Act is received the assent of the president. It is not only the governor's assent, it is the president's assent. And it has got, section 16 has got a overriding effect.
section 16 has got an overriding effect.
Section 16 that any order passed by any competent authority under this act, KPID Act, is appealable.
Yes.
And your petition specifically asserts that you are aggrieved by the rejection.
The word agree does not mean that it is an appealable order.
See, I'm not talking about appealable, but it doesn't, section 16 doesn't say what are appealable, what are revisionable orders. It simply says that any order under this act, under the act, any order passed by the competent authority is appealable. That is the one aspect.
So that my submission.
See, the second thing is you are challenging the order of the competent authority. You are challenging the competent authority being aggrieved by the rejection of the bail itself. It is not your, had you come straight away, concurrent jurisdiction, things would have been different. You have, this.
Permission amendment to section 238
Yes.
of the Code of Criminal Procedure, we are all just beginners in the profession. In those days, my lord, there used to be a number of petitions to the Honorable High Court under 438. Finally, the Honorable High Court had to give a ruling that to look the court of questions.
See, one thing you have argued, any order passed under this act, section 16 doesn't say so. What section 16 says that any person, including the competent authority, if aggrieved by an order passed by a special court, it doesn't differentiate under which provision of that order is passed. If a order is passed by a special court, that is appealable.
Special court
Special court is already defined under section 10.
also empowered the act. Regard to
See,
the-
that is the difference. Special court may be designated for various offences such as special court, but as the special court under this act is only to be considered. A principal district judge may be a special judge for number of acts. That doesn't make much difference. But while hearing the particular case, he is sitting as a special judge for a particular act only. He's special judge for a particular case.
We go there to the special court. Appeal is also provided either as a conviction or.
That is the day for,
My decision will be, perhaps if I prefer an appeal against that order, there is a more chance of the subjection that appeal is not granted.
that is under 439 if you challenge it. But if you file an appeal under section 16, office cannot raise any objections because law provides. KPID Act itself mandates that it should be an appeal.
In fact, I sincerely submit. What happens is that, my lord, person like me, it pains
Well,
to say that, no, I'll go to other. Normally, it is not, we are not trained.
well, I do consider it that is a different aspect. But when the law mandates,
When judgment I see, it's 2021 wherein my lord, the Honorable Supreme Court held that the rigors of the UAPA Act, which bars certain jurisdiction, will not take away the power of the court to take that. But in the citations, the note reading and reading other things, the downloaded copies, a little bit of difference. To 43D5, the High Court granted the bail.
there is one aspect, it can be differentiated in either way.
Yes.
There is a specific bar under 43, under section 43D subclause 5 under the UPA Act. Here there is no bar for you. There is no bar. Here only it says that you cannot come under 439, you can come in the by way of an appeal. That's the only difference.
That 439 is the power conferred upon the constitutional court. Nothing.
If that is the contention, then section 14 of SC/ST Act becomes redundant.
So with this may not
You just, since that is also an issue there, section 14 of the SC/ST Act becomes redundant. Even 103D of section 103D of Karnataka Forest Act becomes redundant.
Those,
Sorry, 104D.
I have submitted that petition. I have also inserted article 2. Read with 439. But if this objection also may not come.
That is a different aspect. Then it will go to a competent court having a roster of 482.
Yes.
Then we'll send it there.
Yes. So,
Because when 439 is there, you cannot invoke 426 again.
petition will be my lord. Not convinced with this.
I'm not convinced, to be frankly.
I have this difficulty.
Hello, I appreciate your stand. I absolutely know, I have no issue. But when statute mandates, it is not. Yes. Hello, definitely, because this petition is not going to take away your right, because it is not going to be passed on merits. Only court, in case your arguments are not accepted, court will direct that you cannot come under 439. Your remedy is under section 16 of the KPID Act. So you have got a remedy there. And statute gives you a remedy. And that remedy you are not yet exhausted. Had you exhausted that remedy, and if you have come under 439, things would have been entirely different.
Because my submission will be, even if I have dispute taken, even if I'm adjourned by my lord's pronouncement,
Definitely.
a further appeal.
Why?
There is no criminal appeal.
The criminal appeal is not there.
See the opinion of my lord's correct or otherwise.
Always there will be one or the other provision will be there, because this is not the final court. Correct. But the party may not be in a position to approach higher court. That is one aspect. But right is not flows here. This is not a final court at any event. The
I mean, presented the petition. 449 may not come in the way of inherent jurisdiction of responsible court.
Yes.
438 and 439 are totally constitutional provisions, virtually constitutional powers in relation to Article 20. And those two judgments that should not.
in fact, they are not inherent powers. Inherent powers are under only 482. It is only concurrent powers. Concurrent powers and inherent powers are entirely different. Allah, wording inherent powers are entirely different.
It means that we are expected to.
Allah, yakana, inherent powers means court can exercise any jurisdiction. Under 151 of CTC ಕೆಳಗೆ ನೀವು ಮಾಡ್ತಿರಲ್ಲ wrong provision ಇತ್ತು 151 we exercise the civil court ಒಳಗೆ.
Involved in the 439 before going to the government sessions case. But this question also would not have been raised. That is not permissible because the judiciary is on our side.
Yes.
That's all my lord I can know. In that way,
Yes. ಏನ್ ಹೇಳ್ತೀರಾ ನೀವು 21 Union of India Najib.
For them, for its academic. The first.
He also initially stated that whatever it may be, it is got a interesting academical interest is involved and it is a gray area. It requires to be settled. That is because he wants a rule of law on this point.
First, I kindly see section 16. Section 16. The general proposition is there is a doctrine called generalia specialibus non derivati. Wherever the special statute is there, the provisions of the general enactment cannot be looked into. Only those special provision has to be looked into. Here it is a APID Act is a special enactment to protect the interest of the depositors, designed to secure the protection through this particular enactment. Therefore, the appeal provision is a special provision. This special provisions prevail over the general provision of Code of Criminal Procedure. 439 or 438 or for that matter 437 is a provision. And more particularly, your lordship may kindly see the design of the act, the scheme of the act. The scheme of the act is forthcoming in the statement of reasons. Just I take your lordship to the statement. The act. An act to provide for protection of interest of depositors in financial establishment and matters relating thereto. Where it is expedient, the lordship may kindly note this, expedient to provide for protection of interest of the depositor in financial establishment and matter relating thereto, and for the purpose of hereinafter hearing, be it enacted by the Karnataka State. Therefore, it is very clear that it is a special enactment to protect the interest of the depositors. Now I take your lordship to the other provisions of the enactment. Procedure, that's section 18. Procedure and power of the special court regarding offences. Why this appeal provision is made is indicated here. Special court may take cognizance of the offence without the accused being permitted to it for trial, and in trying the accused person shall follow the procedures specified in the Code of Criminal Procedure 1973 for the trial of warrant cases with the magistrate. If the legislators thought it fit to give the scope for 439, specifically they could have mentioned This particular provision, that 439 is also applicable under this particular enactment. Deliberately, they have omitted to mention 438 or 439 here. Further, your lordship may kindly see subsection 2. The provisions of the Code of Criminal Procedure 1973, except the provision of section 438, they have mentioned it. So far as may be applied to the proceedings before the special court and for the purpose of the said provision, special court should deem to be a proper magistrate, first class or magistrate, metropolitan magistrate, as the case may be. There was no impediment for the legislature to mention that section 439 is also applicable. They have deliberately omitted it by providing appeal provision under section 16. Under section 16, any person, including the competent authority, if aggrieved by an order of the special court, may appeal to the High Court within 30 days from the date of the order. Any order. Here, your lordship may kindly see the other provisions of the National Investigation Agency Act 8. Similar provision is there, appeal provision. There is a difference. And UAPA also there is a difference. And the Prevention of Terrorism Act also there is a difference compared to section 16 of the APID Act.
But as per section 18 subclause 2.
Yes.
430.
As may be applied to the provision between the purpose of such provision, the special court shall be deemed a court of judicial magistrate.
So all other provisions are made applicable under section 18 subclause 2, except 438
438.
for hearing any matter before special court.
Special court. Here there is a special court. Here that is in so far as the trial is concerned. Here, see, 438 in a way is barred now.
438 before 438 cannot maintain. That is, it is not maintainable before special court.
Special court. Special court.
Not before High Court. There is no bar under High Court.
438 is
Only they accept the provisions of Code of so and so, except the provisions of section 430 shall so far as may apply to the proceedings before a special court. So 438 cannot be made applicable before a special court.
yes.
There is no bar under 438 under this before the High Court.
There we have to see the concurrent jurisdiction. What is not provided? But it's also concurrent court. Therefore, 438 is also part.
That will consider because that is not an issue at this.
Now you are not should be kindly see further section 19. Section 19. And to override the other laws. Specifically, this particular enactment overrides the other laws. Other laws includes the Code of Criminal Procedure. Same as otherwise provided in this act, the provisions of this act shall have effect, notwithstanding anything inconsistent with contained in any other law for the being involved, or any custom or usage, or any instrument having effect by virtue of such law. Therefore,
then IPC will not be there. You say that override.
yes,
Which runs inconsistent to the provisions of the KPID Act. They are this act. If it is inconsistent, this act will prevail rather than the special the other enactment.
if inconsistency to that extent it is there. Otherwise, it is applicable. IPC is also applicable. Any other provisions of law is also applicable. But this act will have a precedence over all other acts. That is the design of the act. Therefore, my submission is the section 16 is applicable insofar as rejection of bail will be. They have to put an appeal. Now, your lordship may kindly see. There is one judgment of this honorable court. Reported. This is in connection with SC/ST Act, your lordship is to be aware. There I take your lordship to the operative portion of the order.
ಅದು ನಮ್ಮ ಹೈಕೋರ್ಟ್ ಫುಲ್ ಬೆಂಚ್ ಎಡಿಷನ್
Reference
ಅದೇ ಫುಲ್ ಬೆಂಚ್ ಎಡಿಷನ್ ಅದೇ ಫುಲ್ ಬೆಂಚ್ ಎಡಿಷನ್ ಅದು ಫುಲ್ ಬೆಂಚ್ ಎಡಿಷನ್ ಅದು 3 ಬೆಂಚ್ ಫುಲ್ ಬೆಂಚ್ ಓಕಾ ಸಾಹೇಬ್ರದ ಅಲ್ವಾ ಇನ್ನೊಂದು ಫುಲ್ ಬೆಂಚ್ ಇದೆ ಒಂದು ಇದೆ ಸೆಕ್ಷನ್ 14
ಏನಾಗಿ ಹೇಳ್ತಾರೆ ಏನ್ ಹೇಳ್ತಾರೆ in view of the section 2 under section 430A that was also a special enactment there.
It is authored by Chief Justice, if I'm correct.
Chief Justice. Chief Justice.
Yes.
Therefore, my submission is, since it is a special enactment and the SC/ST Act is in a way not fully, insofar as the expense of an appeal is concerned, is in pari materia. Pari materia. Therefore, this judgment is also fairly applicable to the case. Their remedy is elsewhere in an appeal. Why that appeal provision is made, you are not kindly note. Because of this unscrupulous attitude of the companies, depositors are cheating, and their money is siphoned out. To protect the interest of the depositors, this stringent law is made. Therefore, because of this stringency, your lordship is fully aware of the scope of the appeal. Whether any illegality is there, perversity is there, or one without non-application. Only now those circumstances appeal can be entertained. Otherwise, what happens? Your lordship may kindly look into. 439 is a general provision. Your lordship can look into other facts. Not merely a law. Therefore, area, this appeal provision is made specifically. Therefore, my humble submission, what a remedy, they have to avoid that particular.
Put a citation on petition.
There are few number of cases.
ಈಗ ಇವೇ ಬರ್ತಾ ಇದಾವಲ್ರಿ ಈಗ ಸಿಕ್ಕಾಪಟ್ಟೆ ಬರ್ತಾ ಇದಾವೆ ಅಲ್ಲ ಈ ಪರ್ಟಿಕ್ಯುಲರ್ ಪರ್ಸನ್
Honorable Supreme Court also one of the cases taken in the bill, advising on bill, what the investigation done through CPI. That's it. So when we should not on bill on the case was leader. I have read it. The only thing is my feeling is the law department was not given enough time to draft the bill before because wording looks like that.
But in fact, one thing is, if it is an appeal, it is the scope will be still more compared to 439. In an appeal, the scope of the appellate court will be more. Now, in case of revision, the scope of the revisional court is very limited. But in case of appeal, the scope of the appellate court is very comparatively very large, wide enough. That is correct. But in 439, the order of the learned judge becomes irrelevant.
439, he don't speak a word about that.
Therefore, while considering a 439 in a concurrent jurisdiction, the High Court will not consider whether the session judge has considered or not. That becomes irrelevant. It will be independently assessed. Yes.
So far, this special enactment is Yes, that's right. What is that is a special enactment that has to be provided.
I have no difficulty in that.
Well, even overriding effect is already given. Yes, yes. No, 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 no. Later law will prevail until.
When there is no interview.
Yes. Yeah, I'll dictate it. What in you? Second of dictate, I'll dictate it in the open court itself. What do you? No, you let it be. No problem.
Another matter also, this 51.
This is 49. Right?
Again, 51 also, the other day, we have to them also, whatever.
ಚಂದ್ರಶೇಖರ್ ಅವ್ರ ಜೊತೆ ನಿಮ್ದು ಪರಿಸ್ಥಿತಿ Yes.
That's all like this one. That's the truth. Who happens to be the second petition, other of the third petition. Here,
I did not follow you, just repeat it. The petitioner, who is the petitioner? A2 and 3. Yes. Wife and son of A1. So A1 is an advocate. Huh? So High Court order has been manipulated.
I'm not appealing.
No, no, that is correct.
ದುಡ್ಡು ಕೇಳ್ತಾರೆ ಗಂಡ ಕೊಡ್ತಾನೆ ನೀನ್ ಎಲ್ಲಿ ದುಡ್ಡಿದ್ಯಾ ಏನ್ ದುಡ್ಡಿದ್ಯಾ ಅಂತ ಯಾರು ಕೇಳಲ್ಲ ಬಟ್ ಇವ್ರು ಇಷ್ಟು ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾರೆ ಅಂತಾರೆ ಸ್ಟೂಡೆಂಟ್ ಅವ್ರು ದುಡ್ಡು ಬೇಕು ಅಂತ ಕೇಳಿದ್ರೆ ಕೊಟ್ಟಿದ್ದಾರೆ ತಿಳ್ಕೊಳ್ಳಲ್ಲ ಬಟ್ ಇದಕ್ಕೆ ಹೆಂಗ್ ದುಡ್ಡಿದ್ದಾನೆ ಮೋಸ ಮಾಡ್ಬಂದಿದ್ರೆ ಅವ್ರಿಗೆ ಅಂಡ್ ಟ್ಯಾಂಪರ್ ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳಿ ಸೆಷನ್ ಹೇಳ್ತಾರೆ ಈ ಸ್ಟೂಡೆಂಟ್ ಹೌಸ್ ವೈಫ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ವಿಟ್ನೆಸ್ ಟ್ಯಾಂಪರ್ ಮಾಡೋ ಪ್ರಶ್ನೆ ಇಲ್ಲ ಏನಾದ ಕಂಡೀಷನ್ ಆಗಿ ದಯವಿಟ್ಟು ಬಿಟ್ಟರೆ ಅವ್ರಿಗೆ ಅದೊಂದು ಸ್ಟೂಡೆಂಟ್ ಒಬ್ಬ ಒಂದು ಹೌಸ್ ವೈಫ್ ಅವ್ರ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಏನಾದ್ರು ಮಾಡ್ತಾರೆ
So 10 lakhs he is siphoned under the ground that the order is passed in he will protect the interest of the client in the pending matters and allegations. And he sent the WhatsApp certified copies which were found to be forged one. Hello, that I am talking about only allegations. Okay, but one more allegation against you, that amount of 10 lakh was paid to you, to both the petitioners as well as accused number one. That was the first para allegations. DD check DD ಮತ್ತು ನಗದು ರೂಪದಲ್ಲಿ so and so ಅವ್ರ ಪತ್ನಿ ಹಾಗೂ ಅವ್ರ ಮಗ ತೆಗೆದುಕೊಂಡಿರುತ್ತಾರೆ. Yes.
ಅಲ್ಲಿ ಬರೀ ನ್ಯಾಯ ಮಾತ್ರ ಮಾಡಿದ್ರು.
ಹೆಂಡತಿ ಮಕ್ಕಳು ದುಡ್ಡು ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಅವ್ರನ್ನೂ ಸೇರಿಸ್ಬಿಟ್ಟು. ಎಸ್, ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳ್ತೀನಿ ನಿಮ್ಗೆ. He is a legal practitioner. He is supposed to appear for his client. Fees will be paid to him. Correct? What was the need for this person to pay the fees in the name of the wife of the concerned counsel and his son? Fine, but allegation of forgery is against accused number one. ಅಲ್ಲ, ನನ್ ಗೊತ್ತಿಲ್ಲ, ನಾನು ಅಜಿಕೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಅವ್ರು ದುಡ್ಡು ತಗೊಂಡವ್ರು ಎಲ್ಲರೂ ಆ ದುಡ್ಡು ತಗೊಂಡು ಹೋಟೆಲ್ದಲ್ಲಿ ಊಟ ಮಾಡಿದ್ರೆ ಆ ಹೋಟೆಲ್ದವ್ರಿಗೆ ದುಡ್ಡು ತಿಂದಿದ್ ದುಡ್ಡು ಅದನ್ನ ಅಂತ ಹೇಳಿ ನೀವು ಕೇಸ್ ಹಾಕಕ್ ಬರುತ್ತಾ? He was aware, there is no issue about it, prima facie. I'm not talking about those things. The awareness of the present petitioners, I'm asking you, whether they were aware that the accused number one, the husband or wife, is playing mischief with the client and securing the amount and he's giving it to us. I'm saying, is there any evidence?
There is a small situation.
So if, let us accept one, I'll appreciate your stand. Okay, let us accept it. During you take them into custody. Subsequently, absolutely no material will be there because they are not legal practitioner. She is not an advocate. Son is studying. In that event, can you repay the period of custody which they have undergone? Because right of freedom will be involved.
She was very well aware of the they might have asked these to be given to his wife and son. I himself he had knowledge of that.
ಒಂದು ಇಲ್ಲಿ ಇನ್ನೊಂದು ಇಂಟರ್ಫಿಯರ್ ಆಗಿ ಒಂದು ಪ್ರಶ್ನೆ ಕೇಳ್ತೀನಿ ನಿಮಗೆ. ಔಟ್ ಆಫ್ ರೆಕಾರ್ಡ್ಸ್, ಡೋಂಟ್ ಟೇಕ್ ಇಟ್ ಅದರ್ವೈಸ್. You are a practicing advocate. What transpires in the High Court in a particular case or otherwise case, do you share with your family members? ಈ ಕೇಸ್ ಒಳಗ ನಾನು ಇಷ್ಟು ದುಡ್ಡು ತಗೊಂಡು ಇವತ್ತಲ್ಲಿ ಸಕ್ಸಸ್ ಮಾಡ್ಕೊಂಡು ಬಂದೆ, ಈ ಕೇಸ್ ಒಳಗ ಏನು ಕೆಲಸ ಮಾಡಲ್ದ ದುಡ್ಡು ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳಿ ವೆದರ್ ಅಲ್ಲ, it is common because it is a profession. Can he share what transpires between him, because there is a protection? What transpires between him and the client is protected conversation. Howda? And normally he will be so busy. ಇಲ್ಲಿ ಏನೇನಾಗುತ್ತೆ ಮನೆಯಲ್ಲಿ ಹೇಳ್ಕೋತ್ ಕೂತ್ರೆ ಫೈಲ್ ಯಾರು ನೋಡ್ತಾರೆ? ಅಲ್ಲ, ಈ ಜನರಲ್ ನಾನು ಕಾಮನ್ ಸೆನ್ಸ್ ಮೇಲೆ ಕೇಳಿದ್ ನಾನು ಈ ಪ್ರಶ್ನೆ. ಇಟ್ಸ್ ಓನ್ಲಿ ಕಾಮನ್ ಸೆನ್ಸ್ ಕ್ವಶನ್. It is not but a generalized question, not a particular case. ಕೆಲವರು ಇರಬಹುದು, ಕೆಲವರು ಹೇಳ್ತಿರಬಹುದು. They doesn't express everything they want to say, but it happens if both are legal practitioners. It happens if both son, wife are legal practitioners, they bound to share because the account maintain ಮಾಡ್ತಿರ್ತಾರ, they used to share. But when they are not in the same field, whether they have got a patience to share this much information. Absolutely, there is no issue. He's not disputing it. The question is now complainant has to answer why he has paid it, because he made an allegation that he paid to wife and children. What compelled him to make payment to them when they are not his legal counsels? Is there any investigation is done by the investigating officer? Why? A bold statement is there in first para, and rest of the para completely diverted against pointing finger against A1 only. And if he had paid through DD check, there should be documentation. Then IO should say, get an explanation from the complainant first, why he was compelled to make payment to the family members. ಅಲ್ಲ, ಈ ಇನಿಷಿಯಲ್ ಸ್ಟೇಜ್ ಒಳಗೆ ನೀವೇ ಹೇಳ್ಬೇಕಲ್ಲ. ಆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಕಣ್ಣು ಮುಚ್ಚ ಮಾಡೋ ಬದ್ಲಿ ಎ ಕಾಮನ್ ಸೆನ್ಸ್ ಅಯ್ಯೋ ಏನ್ ಮಾಡ್ಬೇಕು, ಅವ್ರ ಸಂಬಂಧ ಇಲ್ಲ, ಅವ್ರಿಗೆ ಯಾಕೆ ದುಡ್ಡು ಕೊಟ್ಟಿಯಾ ನೀನು ಅಂತ ಕೇಳ್ಬೇಕೋ ಬೇಡ. ಅವ್ನ್ ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು ಫಸ್ಟ್. ಅವ್ನ್ ಕಂಪ್ಲೇಂಟ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. ದೆನ್ ಯು ವಿಲ್ ಹ್ಯಾವ್ ಟು ಅಸರ್ಟೈನ್ what was the need for him to pay the amount to other family members who are no way concerned with his case. Sometimes it amounts to blackmailing tactics. Yes, ಏನು ಹೇಳ್ತೀರಾ? Either first prove that they have received the amount. That document is with your custody. Complainant custodial idea irtalva. He made payment to them also. Where is that document then? Except his bald assertion. And when he asserts that payment is made by DD or check, there should be a documentation. Huh? ಏನ್ರಿ ಅದ ಡಿಡಿಸ್ ಅಂಡ್ ಚೆಕ್ಸ್ ಕರೆಕ್ಟ್. ಎಲ್ಲ in the name of accused number 1. ಚೆಕ್ ಮಾಡಿ. Cash deposit, DD, check, and one DD is not obtained by the complainant. It is obtained by complainant only. So, petitioners have filed the petition under section 438 of CRPC, seeking anticipatory bail in the event of their arrest in Viধানসভা of the PS crime number 44 of 22, registered for the offences punishment in 420, 465 and 468 of CRPC. The brief heard the learned counsel for and learned senior counsel for petitioner and learned HCGP for respondent state. 34. The brief factual matters leading to the case are that the complainant had filed a writ petition bearing number 56012 of 2015 and a RSA bearing RSA number 50 of 2017 in this high court. She has engaged the accused number 1 to prosecute both the cases, and in this regard, she has paid a sum of rupees 10 lakhs to the present petition accused number 1 by way of DD cash, accused number 1 and petitioners by way of DD cash and check. It is further alleged that the accused number 1 had sent her sent the court orders by WhatsApp message bearing the seal of the High Court as well as the registrar. When the complainant had checked the same in the High Court website, they were not found to be there. Then when she inquired with the accused number 1, it is asserted that due to Corona, certain orders were not uploaded. However, the complainant then suspected that they appears to be fake orders, approached the accused number 1, but the accused number 1 on the contrary abused her in filthy language, and then she asked accused number 1 to return her cases, return the files of her cases as well as the amount of 10 lakhs received by her, but accused number 1 did not refund the said amount. Hence, the complainant has filed this case, the complaint on 4/7/22 before the concerned jurisdictional police, and crime came to be registered. The present petitioners are the wife and son of accused number 1, and it is also alleged that they have also received certain amount from complainant. They have approached the learned session judge seeking anticipatory bail, but the learned session judge has rejected the bail petition. Therefore, the petitioners are before this court. Having heard the arguments and perusing the records, it is evident that the accused number 1 is a legal practitioner, and the complainant has entrusted the writ petition number 56012 of 2015 and RSA 50 of 2017 to him to prosecute on his behalf. Further, she has alleged to have been paid rupees 10 lakhs to him, though it is alleged that the amount was paid to present petitioners also, but prima facie no material evidence is placed to show that the present petitioners have received any amount from the complainant. Further, the present petitioners are not legal practitioners. The allegations does disclose that it is the only accused number 1 who has forged the court orders in the WhatsApp and sent the same to the complainant. Looking to these facts, madam, nimde checks, is there any single document to show that payment is made to any of these? Whatever checks, DD and cash, they are with reference to the accused number 1 only. Though there is allegation, there is an allegation in the complaint that amount is paid to present petitioners also, but the prosecution has not produced any scrap of paper to show that any amount was deposited to the account of the present petitioners. The petitioner number 2 is the woman, and petitioner number 2 is the petitioner number 3 is the student. The petitioner number 2 falls under exception. The offences alleged are not exclusively punishable with death or life imprisonment and are triable by the learned magistrate. Further, the main allegation regarding forgery and cheating is as against accused number 1. Under these circumstances, I do not find any impediment for admitting the petitioners on bail. The other apprehensions raised by the learned HCGP can be meted out by imposing certain conditions. This petition needs to be allowed, and accordingly, I proceed to pass the following order. 1 lakh with 1 surety for like sum, surrender within 15 days.
Respondent police for the offence is punishable under section 504, 498A and 306, read section 34 of the Indian Penal Code. So, Lordship may kindly see the complaint is page number 23, annexure B. The complaint lodged by one Gayatrama stating that ನಾನು ಈ ಮೇಲ್ಕಂಡ ವಿಲಾಸದಲ್ಲಿ ವಾಸವಾಗಿರುತ್ತೇವೆ. ನಮಗೆ 1ನೇ ಧನುಜ ವಿಆರ್, 2ನೇ ಧನುಜ ದರ್ಶನ್ ವಿಆರ್ ಎಂದು 2 ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ನನ್ನ ಮಗಳು ಧನುಜಾಳನ್ನು ಈಗ 4 ವರ್ಷಗಳ ಹಿಂದೆ ಉದಿಪಾಳ್ಯ ಗ್ರಾಮದ ರಾಮಣ್ಣನವರ ಮಗ ರಾಜುರವರಿಗೆ ಕೊಟ್ಟು ಮದುವೆ ಮಾಡಿದ್ದು. ಅವರಿಗೆ 1ನೇ ಲಾವಣ್ಯ, 2ನೇ ನೂತನ ಎಂದು 2 ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ನನ್ನ ಮಗಳು ಧನುಜಾಗೆ ಸಂಸಾರದ ವಿಚಾರವಾಗಿ ಅವರ ಅತ್ತೆ ಗೌರಮ್ಮ, ನಾದಿನಿ ಕನ್ಯಾಕುಮಾರಿ, ಅವರ ಗಂಡ ಮುರಳೀರವರು ತೊಂದರೆ ನೀಡುತ್ತಾರೆ ಎಂದು ನನಗೆ ಹೇಳಿದ್ದರು. ಈ ವಿಚಾರವಾಗಿ ನಾನು ಸಹ ನಮ್ಮ ಬೀಗರು ಗೌರಮ್ಮನ ಜೊತೆ ಮಾತನಾಡಿದ್ದೇನೆ. ನಂತರ ನನ್ನ ಅಳಿಯ ರಾಜರವರು ನನ್ನ ಮಗಳನ್ನು ಬೇರೆ ಬೇರೆ ಮಾಡಿ ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ನನ್ನ ಮನೆಗೆ ಈಗ 2 ತಿಂಗಳ ಹಿಂದೆ ತಂದು ಬಿಟ್ಟಿದ್ದರು. ಆಗ್ಲೇ ಫೋನ್ ಮಾಡಿ ನನ್ನ ಮಗಳ ಜೊತೆ ಮಾತನಾಡುತ್ತಿದ್ದರು. ನಂತರ ಹೀಗೆ 1 ತಿಂಗಳ ಹಿಂದೆ ಕಸಬಾ ಹೋಬಳಿ ಹುಸೆ ಮರದೊಡ್ಡಿ ಗ್ರಾಮದಲ್ಲಿ ನನ್ನ ತಾಯಿ ವಸಂತಮ್ಮನವರ ಮನೆಯಲ್ಲಿ ಊರೊಬ್ಬಕ್ಕೆಂದು ಹೋಗಿದ್ದಳು. ನನ್ನ ತಾಯಿ ಸ್ವಲ್ಪ ದಿನ ಇಲ್ಲೇ ಇರಲಿ ಅಂತ ಅವಳು ಕಳಿಸುತ್ತೇನೆ ಎಂದು ತಿಳಿಸಿದರು. ನಂತರ ನನ್ನ ಮಗಳು ನನಗೆ ಕರೆ ಮಾಡಿ ನನ್ನ ಗಂಡ ರಾಜು ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗು ಎಂದು ಏನೇನೋ ಕಾರಣ ಹೇಳುತ್ತಾನೆ, ಸರಿಯಾಗಿ ಮಾತನಾಡುತ್ತಿಲ್ಲ ಎಂದು ಹೇಳಿದರು. ನಾನು ಸಹ ಕರೆ ಮಾಡಿದಾಗ ಬರುತ್ತೇನೆ ಸ್ವಲ್ಪ ದಿನ ಎಂದು ನನ್ನ ಅಳಿಯ ಹೇಳುತ್ತಿದ್ದ, ಆದರೆ ಬರುತ್ತಿರಲಿಲ್ಲ. ಈ ವಿಚಾರವಾಗಿ ನನ್ನ ಮಗಳಿಗೂ ಮತ್ತು ನನ್ನ ಅಳಿಯ ರಾಜುಗೆ ಜಗಳವಾಗಿ ಮನೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತಿಲ್ಲ ಹಾಗೂ ಸಂಸಾರದ ವಿಚಾರವಾಗಿ ತೊಂದರೆ ಕೊಡುತ್ತಿರುವ ಬಗ್ಗೆ ದಿನಾಂಕ 8/8/2027 ರಾಮನಗರದ ಮಹಿಳಾ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಅತ್ತೆ ಗೌರಮ್ಮ, ಗಂಡ ರಾಜು, ನಾದಿನಿ ಕನ್ಯಾಕುಮಾರಿಯವರ ಮೇಲೆ ಠಾಣೆಯಲ್ಲಿ ಕರೆಸಿ ಮಾತನಾಡುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದರು. ನಂತರ ದಿನಾಂಕ 10/8/22 ರಾತ್ರಿ ವೇಳೆಯಲ್ಲಿ ನಮ್ಮ ಬೀಗರು ಗೌರಮ್ಮ ಮತ್ತು ಅಳಿಯ ರಾಜರವರು ಏನೇ ಹಾಕಿಕೊಂಡು ಮೃತಪಟ್ಟ ವಿಚಾರ ತಿಳಿಯಿತು. ಆ ವಿಚಾರವನ್ನು ನಾವು ಬೆಳಗ್ಗೆ ಹೇಳೋಣ ಎಂದು ನನ್ನ ಮಗಳಿಗೆ ಹೇಳಿಲ್ಲ. ನಂತರ ದಿನಾಂಕ 11/8/22 ಬೆಳಗ್ಗೆ 8:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ತಾಯಿ ನನಗೆ ಕರೆ ಮಾಡಿ, ನಿನ್ನ ಮಗಳು ಧನುಜ ವಿಷ ಸೇವನೆ ಮಾಡಿದ್ದಾಳೆ, ನಾವು ಕನಕಪುರ ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗುತ್ತಿದ್ದೇವೆ ಬನ್ನಿ ಎಂದು ತಿಳಿಸಿದರು. ನಂತರ ನಾನು ಕನಕಪುರ ಆಸ್ಪತ್ರೆ ಬಳಿ ಹೋಗಿ ನೋಡಲಾಗಿ ವಿಚಾರ ನಿಜವಾಯಿತು.
ನಂತರ ನನ್ನ ಮಗಳು ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗಾಗಿ ಚಂದ್ರಮ್ಮ ದಯಾನಂದ ಸಾಗರ್ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲು ಮಾಡಿದ್ದೇವೆ. ನಂತರ ನನ್ನ ಮಗಳ ಬಳಿ ವಿಚಾರ ಮಾಡಿದಾಗ ದಿನಾಂಕ 10/8/2022 ಬೆಳಗ್ಗೆ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ನಾದಿನಿ ಕನ್ಯಾಕುಮಾರಿರವರು ನನ್ನ ಮಗಳಿಗೆ ಕರೆ ಮಾಡಿ, ನನ್ನ ತಾಯಿ ಗೌರಮ್ಮ ಮತ್ತು ಅಣ್ಣ ರಾಜುರವರ ಸಾಯಲು ನೀವೇ ಕಾರಣ, ಸೋ ನೀನು ನನ್ನ ಅಣ್ಣ ಸತ್ತ ಮೇಲೆ ನೀನ್ ಯಾಕೆ ಬದುಕಿದ್ದೀಯಾ, ನೀನು ನಿನಗೆ ಸಾಯಲು ನಾನೇ ವಿಷ ತಂದು ಕೊಡುತ್ತೇನೆ, ಬೇಗ ಸಾಯು ಸೋ ಇಲ್ಲ ನಾನು ನಿನ್ನನ್ನು ಸಾಯಿಸುತ್ತೇನೆ ಎಂದು ಅವಾಚ್ಯವಾಗಿ ಬೈಕ್ ಗಲಾಟೆ. ಅಂಡ್ ಅವರ ಗಂಡ ಮುರಳಿ ಸಹ ನೀನೇ ಗೌರಮ್ಮ ಮತ್ತು ರಾಜು ಸಾವಿಗೆ ಕಾರಣ ಎಂದು ನನಗೆ ಅವಾಚ್ಯ ಸತ್ಯವಾಗಿ ಬೈದಿರು. ದಿನಾಂಕ 10/8/22 ದಿನಾಂಕ 19ರಿಂದ ದಿನಾಂಕ 19/8/22 ದಯಾನಂದ ಸಾಗರ್ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ನನ್ನ ಮಗಳು ಧನುಜ ಚಿಕಿತ್ಸೆ ಕೊಡಿಸಿದ್ದು ದಿನಾಂಕ 20/8/22 ಮುಂಜಾನೆ 12:45 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಗಳು ಧನುಜ ಚಿಕಿತ್ಸೆ ಫಲಕಾರಿಯಾಗದೆ ಮೃತಪಟ್ಟಿದ್ದ ವಿಚಾರವನ್ನು ವೈದ್ಯರು ತಿಳಿಸಿದರು. Kindly appreciate here that there was an incident on 10/8/2022 at night regarding the complaint regarding 10/8/2022. One Gauramma and Raju were died by committing a suicide. This incident came to know, and your lordship kindly appreciate that in the complaint last case, as 11/8/2022 ಬೆಳಗ್ಗೆ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ತಾಯಿ ಕರೆ ಮಾಡಿ ನಿನ್ನ ಮಗಳು ಧನುಜ ಸೇರಿಸಿದ್ದಾಳೆ ಅಂತ. First, there is a dead, the Gauramma and Raju is the Dhanuja's husband. He also died on 10/8/2022 by committing a suicide. The reason for committing a suicide by both of them, she has given a complaint to the Mahila police station in the Ramnagara. The police has called and inquired. Therefore, they committed suicide. So thereafter, that incident was intimated to the mother of the who is the complaint hearing on 10/11/2022. The incident your lordship kindly appreciate that ನನ್ನ ಮಗಳ ಬಳಿ ವಿಚಾರ ಮಾಡಿದಾಗ ದಿನಾಂಕ 10/8/22 ಬೆಳಗ್ಗೆ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನನ್ನ ಮಾಡಿರುವುದು ಮೊದಲಿಗೆ. Incident happened on 10/8/2022 night. They called morning 8 o'clock. At the time of when she called, who is the petitioner number 1 here in Kidnapping, there was no incident of suicide by her husband. The incident was happened on 10/8 night 7:45. In this regard, we have first lodged a complaint on 10/8. The complaint is I have produced who are the deceased, the complainant as well as the complainant daughter are the accused in earlier case. That is the crime number. Your lordship, I have produced the page number 39. Page number 39. A complaint lodged in crime number 306 of 2022 on 10/8/2022 under section 306 and 409, wherein the complaint is Kidnapping. Who is the number 1? She lodged a complaint regarding the death of her brother and mother. And the way the accused are is kindly see the next page number 40. Dhanuja, who is the deceased in the present criminal number, and Gayatri, accused number 3. Accused number 3, Gayatri. This Gayatri is the complainant in the present case. Third, my submission before the court and arguable point is important point that the case and counter case is there, and petitioner the alleged incident according to the complaint.
What do you mean by case and counter case?
First 10/8/2022.
What is the concept of case and counter case?
First we lodged the case. In order to counterblast that case,
it cannot be termed as a case and counter case. Concept of case and counter case is entirely different. And how? Now, since you have lodged a complaint under section 306, lodging a complaint amounts to abatement.
On the day my brother and my mother was dead.
Satra kilri, our complaint kotru. ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ನೀವು ಹೋಗಿ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಅಂತ ಹೇಳಿ ಅವ್ರ ಮ್ಯಾಗ ಒಂದು 306 ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೆ ತಪ್ಪ.
ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ ಕೇಸಲ್ಲಿ.
ನೀವು ಕೊಡೋಕ್ಕಿಂತ ಮುಂಚೆ ಅವಳು ಒಂದು ಕಂಪ್ಲೇಂಟ್. See, therefore I am asking you, what is the base? ಅವ್ರು ನಿಮ್ ವಿರುದ್ಧ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದ ತಪ್ಪ? then ನಿಮ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದಾರ ಅಂತ ಹೇಳಿ ಹೋಗಿ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಅಬೇಟ್ಮೆಂಟ್ ಆಗತ್ತಾ? ನಾನ್ ನಿಮ್ಮ ಪ್ರಶ್ನೆ, ನಿಮ್ಮ ಕೇಸ್ ಬಗ್ಗೆನೂ ಪ್ರಶ್ನೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಯು ರಿಗಾರ್ಡಿಂಗ್ ದ ingredients in your case also. ನೀವು ನಿಮ್ ವಿರುದ್ಧ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರು, ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರು ಅಂತ ಹೇಳಿ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ರೆ 306. See, it is for the police to investigate. That is a different aspect. They have taken a legal step. It is for the police to take a appropriate action. ಅದಕ್ಕೆ ನೀವು ಅವರು ಸುಸೈಡ್ ಪೊಲೀಸರು ಕರ್ಸಿದಕ್ಕೆ ಸುಸೈಡ್ ಮಾಡ್ಕೊಂಡ್ ಬಿಟ್ರೆ 306. ಎಷ್ಟು ದುರುಪಯೋಗ ಆಗ್ತಾ ಇದೆ 306. ಇವು ಎರಡು ಕ್ಲಾಸಿಕ್ ಎಕ್ಸಾಮ್.
According to the complaint on 11/8/8:30 morning, that the complaint lodged on 28/2022 11:30 after 9 days. The treatment did blood. The here blood the material the complaint as per the complaint. There is no custodial interrogation is not required. Since blood the entire allegation is only through phone call. There is a recording in the phone call. Blood the phone is with the complainant only. The according to the tampering of document, setting of the this does not arise. Second thing, third, the Milad, really Milad, if it is in the complaint itself, there is no particular allegation that the phone call was only by first petitioner according to the complaint. Second petitioner is not there. So, saying that in the complaint, nam tande nam anna tayi tirkondirare tayi husband of the complaint is nowhere.
ನೀವೇನ್ ಮಾಡಿದ್ರಿ ಅದನ್ನ ಅವ್ರು ನಿಮಗ್ ಮಾಡಿದ್ದಾರೆ. ನೀವ್ ಮಾಡುವ ಹೊತ್ನ್ಯಾಗ ನಿಮಗ್ ಅನಿಸ್ಲಿಲ್ಲ, ಅವ್ರು ಮಾಡಿದ್ಮ್ಯಾಗ ನಿಮಗ್ ಅದ್ರದ್ದು ಹೀಟ್ ಹತ್ತಾಕತ್ತದ.
But the second petitioner will is concerned legal complaint.
ಅದೇ ಹೇಳ್ತೀನಿ, ಸ್ವಂತಕ್ಕೆ ಬಂದಾಗ ಅಷ್ಟ ಅದ್ರದ್ದು ಇಂಪಾರ್ಟೆನ್ಸ್ ಗೊತ್ತಾಗತ್ತ. ಕಣ್ಣು ಮುಚ್ಚಿ ಕೊಡೋತ್ನಾಗ ಏನು ಗೊತ್ತಾಗಲ್ಲ.
Incident ಆಗಿದ್ಮೇಲೆ ಅವ್ರು ಇಂಟಿಮೇಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಕಾಲ್ ಮಾಡಿದ್ದಾರೆ. Incident was happened at night. Morning 10 o'clock, 8 o'clock, which was no such incident. The complaint is like that. Fully is not at all nowhere in the picture. And Milad, second thing Milad is the material evidence is only the phone recordings are there. If at all there, Milad, the police will take a investigation and we are ready to cooperate with the investigation. Milad, we are ready to obey with all conditions. Since Milad, the petitioners 1 and 2 are small children, they are now Milad is hospitalized. They are taking treatment in the Dr. Chandra, the Chandrama and Dayanand Sagar Hospital. And Milad here, there is a delay of 9 days. If at all really was 498 is concerned and other things Milad is concerned, they would have to lodge a complaint immediately on 11/8/2022 after this incident was happened. Therefore, Milad, the petitioner requested before the Honorable Court to enlarge and they will pay.
Yes. What is the serious allegations? ಫೋನ್ ಕಾಲ್ ಮಾಡಿ ನೀನ್ ನನ್ನ ಅಣ್ಣನ ತಾಯಿ ಸಾಯಿ ನೀನೇ ಕಾರಣ, ನೀನ್ ನೋಡ್ಕೋತೀನಿ ಅಂತ ಅಂದ್ಕೂಡ ಅಬೇಟ್ಮೆಂಟ್ ಆಗತ್ತಾ? ನಮ್ ಸಿಂಪಿ ಸೆಟ್ ಹೇಳ್ತೀನಿ, ನೀನ್ ಬಿಡೋಲ್ಲ, ನೀನ್ ಸಹಿ ಇಲ್ಲ, ನಾನ್ ಇನ್ನಾರೆ ಕೊಲ್ತೀನಿ ಅಂದ್ಕೂಡಲೇ ಅಬೇಟ್ಮೆಂಟ್ ಆಗತ್ತಾ? But simultaneously it is also applicable to her. She has also lodged a complaint. ಈಗ ನಾನು ನೋಡ್ತಾ 306 ದಷ್ಟು ದುರುಪಯೋಗ ಯಾವ್ದು ಆಗ್ತಾ ಇಲ್ಲ ಈಗ. 498 ಗಿಂತ ಮ್ಯಾಕ್ಸಿಮಮ್ ದುರುಪಯೋಗ 306 ಆಗ್ತಾ ಇದೆ. Petitioners have filed the petition under section 438 of CRPC seeking anticipatory bail in the event of their arrest in Kanakpura Rural PS crime number 180 of 22. Registered for the offence is punishment in 504, 506, 504, 498A, 306, read with section 34 of the IPC. The brief heard the learned counsel for petitioner and learned HAGP for state peruse the records. The brief factual matrix leading to the case are that the complainant is mother of the deceased Dhanuja and she was given in marriage to one Raju. The deceased had 2 children out of the said wedlock with Dhanuja. It is also alleged that the daughter of the complainant by name Dhanuja used to complain that her mother-in-law Gauramma, the present petitioner, who is the who is her sister-in-law, and her husband regularly used to ill-treat her. Subsequently, about 2 months earlier, the husband of the son-in-law of the complainant by name Murali left the daughter, the daughter of complainant by name Dhanuja in her house, and though there were number of requests to take her back, he never responded. Considering this aspect, on 8/8/2022, the deceased Dhanuja has lodged a complaint with Mahila Police Station, Ramnagar, and the police have summoned the husband of the petition, the complainant, husband of the deceased, her mother-in-law, and the present petitioner number 1 to the police station and inquired in this regard. Later on 10/8/22, the son-in-law of the complainant and the son-in-law of the complainant, that is her, that is the husband of the deceased Dhanuja, and the mother-in-law of the deceased have committed suicide by hanging themselves. The said fact was when the complainant got information of this aspect on the night of 10th August, she did not report the matter to her daughter with a and she decided to report the matter on the next day. Later on 11/8/22 at 8:30 p.m., 8:30 a.m., the complainant has received a call from her mother that her daughter has also committed suicide, has attempted suicide and was admitted in hospital. Then she went to hospital, and there she inquired with her daughter, and she narrated the incident that on 10/8/22 morning at 8 o'clock, the present petitioners called the deceased and abused her that she is the cause for they committing suicide, and threatened her and instigated her to go and die. Hence, she revealed that therefore she consumed the poison, and later on she was admitted, she succumbed in Dayanand Sagar Hospital on 28/22, and as such, this complaint came to be lodged. The petitioners have approached the learned session judge, and learned session judge has rejected their bail petition. Hence, the petitioners are before this court. Admitted, having heard the arguments and perusing the records, it is evident that the daughter of complainant Dhanuja is the wife of one Raju, who is the brother of the present petitioner number 1, and petitioner number 2 is the husband of petitioner number 1. The records disclose that there was certain family discord between the parties, between husband and wife, and the deceased Raju had left his wife, that is deceased Dhanuj, in her maternal home, and in spite of repeated requests, he did not take her for joining matrimonial life. However, being fed up of this, she approached Ramnagar Mahila Police Station by lodging a complaint on 10/8/22. In this regard, the police have summoned deceased Raju, his deceased mother, as well as the present petitioner number 1, and later on, and advised them, and later on 10/8/22, the Raju and his mother Gaurama committed suicide. In this regard, the present petitioner has lodged, petitioner number 1 has lodged a complaint, and that complaint came to be registered in crime Kaglipura Police crime number 306/22. The allegations of this complaint disclose that the Raju and Gaurama have committed suicide on 10/8/22 between 7:50 p.m. to 8 p.m. in the night hour. However, though the complainant had received the information on the same night, she did not intimate the same to her daughter, and on the next day morning at 8:30 a.m. she received information regarding deceased consuming the poison. According to complainant, her daughter narrated that on 10/8/22 morning at 8 o'clock, the petitioner number 1 called her on mobile, abusing her that she is the cause for the death of her mother and her brother, and instigated her for committing suicide. However, the records itself disclose that Raju and his mother Gaurama committed suicide on 10/8/22 in the night around 8 o'clock. But the allegations made in the present complaint are that the petitioner number 1 called the deceased on 10/8/22 in the morning at 8 o'clock, and at that time, admittedly, there was no suicide by Raju as well as Gaurama. Hence, the entire case of the prosecution is surrounded with suspicious circumstances. Though the suicide was committed on 11/8/22, the complaint was lodged on 28 no doubt the learned public HCGP would submit that only after the death of the deceased in the hospital, complaint is lodged, and that that ground cannot be ignored at this juncture. However, at this juncture, there is no reason, there is no material evidence to prove that there is any ingredients of abatement or instigation as referred in section 107 of IPC. The records disclose that due to only minor difference of opinion, the daughter of the complainant, her husband, as well as the mother-in-law of the daughter of the complainant have committed suicide, and for a tribal reason, it has taken the lives of 3 persons, and it appears to be because of weak mind, and it depends on their mental status. Looking to these facts and circumstances, in my considered opinion, the petitioners can be admitted on bail. The other apprehensions raised by the learned HCGP can be meted out by imposing certain conditions. This petition needs to be allowed and accordingly proceed to pass. 1 lakh, 1 surety, normal conditions. Appear before session judge, concerned SHO within 15 days from receipt of the certificate copy. Yes.
For the offenses mentioned under 409, 420, 424, in 54 of petition. Kindly be permitted to read the complaint applications. ಕೀಳ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚೇತಂದ್ರ ಎಸ್ಪಿ ರವರು ತಾಲೂಕಿನಿಂದ ನಿಯೋಜನೆ ಮೇರೆಗೆ ಪ್ರಾಥಮಿಕ ತಾಲೂಕಿಗೆ ಕೊಕ್ಕಡ ಹೋಬಳಿ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ 16 ಬಯಲು ಕುತಿಲು ಗ್ರಾಮದಲ್ಲಿ ಗ್ರಾಮ ಲೆಕ್ಕಗಳಿಗಾಗಿ ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಾರೆ. ಆದರೆ ಈ ಹಿಂದೆ ಬೆಳ್ತಂಗಡಿ ತಾಲೂಕಿನ ಕಚೇರಿಯಲ್ಲಿ ಕೊಕ್ಕಡ ಹೋಬಳಿಯ ವಿಷಯ ನಿರ್ವಾಹಕರು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಾ ಮಂಡ್ಯದ ಜಯಚಂದ್ರ ಎಂಬುವರು ಕೈಯಿಂದ ಅಕ್ರಮ ಸಕ್ರಮ ಕಡತದ ಬಗ್ಗೆ 76 ಲಕ್ಷ ರೂಪಾಯಿಗಳ ವ್ಯವಹಾರ ಮಾಡಿರುವ ಬಗ್ಗೆ ಮತ್ತು ಇತರ ಅಂಶಗಳ ಕುರಿತು ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ಸದರಿ ಸರ್ಕಾರದ ವಿರುದ್ಧ ಉಲ್ಲೇಖ ದೂರು ಅರ್ಜಿಯನ್ನು ಮಾನ್ಯ ಸಹಾಯಕಾಯುಕ್ತರು ಅವರಿಗೆ ಸದರಿ ದೂರಿನ ಪೂರಕವಾಗಿ ಉಲ್ಲೇಖ 2 ಮಂದಿ ಖುದ್ದಾಗಿ ಕಚೇರಿಗೆ ಹಾಜರಾಗಿ ಅವರ ಸಮಕ್ಷಮ ಈ ಕಚೇರಿಗೆ ವರ್ತಿಸಿರುತ್ತಾರೆ. ಕಚೇರಿಗೆ ಕಡತಗಳನ್ನು ವರ್ತಿಸಿ ಮತ್ತು ಹೇಳಿಕೆ ಜಾರಿ ಮಾಡಿ ವಿಚಾರಣೆ ಮಾಡಿಸಿ ನಿಯಮಾನುಸಾರ ಕಾನೂನು ನಿರ್ದೇಶನ ನೀಡಿರುವುದರಿಂದ ಉಲ್ಲೇಖ 5ರಂತೆ ಉಭಯರಿಗೂ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿ ದಿನಾಂಕ 1/8/2022 ದಿನಾಂಕ 3/8/2022 ವಿಚಾರಣೆ ನಡೆಸಲಾಗಿದೆ. ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ದೂರುದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿಗಳನ್ನು ಲಿಖಿತ ಹೇಳಿಕೆಯನ್ನು ವಿಚಾರಣೆ ಸಮಯದಲ್ಲಿ ದೂರುದಾರರು ಮತ್ತು ಪ್ರತಿವಾದಿದಾರರು ನೀಡಿರುವ ಹೇಳಿಕೆಗಳನ್ನು ಆಧಾರದ ಮೇಲೆ ದೂರುದಾರರು ಹಾಜರುಪಡಿಸುವ ಮೂಲ ಕಡತಗಳು ಈ ಕಚೇರಿಗೆ ಸಂಬಂಧಿಸಿರುತ್ತವೆ. ದೂರುದಾರರು ಶ್ರೀ ಜಯಚಂದ್ರ ಎನ್ಸಿಆರ್ ಕೊಕ್ಕಡ ಹುಬ್ಬಳ್ಳಿ ವಿಷಯ ನಿರ್ವಾಹಕರಾಗಿದ್ದು ಹಾಜರುಪಡಿಸಿದ ದಾಖಲೆಗಳಿಗೆ ಸದರಿಯವರು ನಿರ್ವಹಿಸಿ ವಿಷಯ ಸಂಕಲನ ದಾಖಲೆ ಮತ್ತು ಸದರಿಯವರ ಹಸ್ತಾಕ್ಷರವಿರುವ ದಾಖಲೆಗಳಾಗಿರುತ್ತವೆ. ಈ ಕಚೇರಿಯಿಂದ ಸದರಿ ಕಡತಗಳು ದೂರುದಾರರಿಗೆ ಹಸ್ತಾಂತರವಾಗಿರುವ ವಿಷಯವನ್ನು ಕಂಡುಕೊಂಡಿದೆ. ಇಂಥ ಕಚೇರಿಯ ಕಡತಗಳು ದೂರುದಾರರಿಗೆ ಹಸ್ತಾಂತರವಾಗಿರುವುದರಿಂದ ಹೆಚ್ಚಿನ ತನಿಖೆಯನ್ನು
ನಿಯಮಾನುಸಾರವಾಗಿ ಕಾನೂನು the accused number 1, based on the statement of the accused number 2 by P and Raju, the case has been lodged against him. The only allegation against this petitioner is that while he was working in 2018 as NCR case clerk, he has said to committed misappropriation of 76. He has neither issued any of the receipt on behalf of the office, or he was the full investment of it. Moreover, even the observations state that the office files were given to P and Raju, but particularly whether this petitioner has handed over, it is not clear. No recovery has been made. Only based on such a vague and bad allegation, this petitioner has been falsely loaded.
You are the concerned case worker. You are the custodian of the document, the files. How the files go to a third person? Who has to explain?
Sir, I was
See, first thing, you are custodian of the files, there is no issue. You are a case worker, no issue. The files were in your handwriting, no issue. How the files, office files, go to a third person position?
transferred as village accountant and village sector by the PO.
See, the question is, original files of a public office were found in a custody of some third person. You are the custodian. The moment you transferred, your duty is to hand over the charge of a particular post along with all relevant files to the incoming officer. That is the law. How the files go to a third person? You are supposed to explain how do you expect that the prosecution should prove it? A fact within your knowledge, because you are the custodian, undisputed, you are the concerned clerk, case worker. When you are custodian of the file, how the file goes out of the office?
Transferred, see my transfer, I had handed over. I should be concerned.
Here is the document to show that you have handed over the files to the concerned incumbent officer. See, fact is that these files were found with a third person. He lodges a complaint. It is a serious thing. A office file, a public office file is sent out of the office. Is it a important files? If this is the way,
And I was transferred from one office to another office. Then what about this? Police.
see, that is, see, question is now the outsiders forget about it. The issue is, these are the office files. Correct? They are in your handwriting, they were in your custody, they were found in custody of a third person. It is nobody's case that the proceedings in the file, after your handwriting, there is some other handwriting of a staff. Then the files were never handed over to anybody. The files were found misplaced. Some DA might have been taken place, that is a different aspect. But very interestingly, these files were found with a third person, private party.
My absence, it has taken place.
Yeah, how can it take place in your absence? You are the custodian. If the fact remains is that if the moment you are transferred, you are supposed to hand over the charge. While handing over the charge, along with the CTC, you prepare a list of all the files which you are handing over. That will be countersigned by the other officer who receives the files. Where is that document? That document completely falsifies the case of the prosecution regarding you. Sir, question is, certain files were handed over, certain files were not handed over. That was not even known to the, which file you have handed over, which file you have not handed. The incumbent officer will not be responsible for a file which is not handed over to him. He will be responsible only in respect of a file which is handed over to him.
Moreover, the inquiry proceedings also state that no particular allegation has been made against me. That I have transferred it. Even what is in the custodian
Sir, when you are handed over to, how the files go to a custody of a third person when you are the custodian? A very interesting argument, sir. New custodian, new case worker, new superior explanation kodbeku, new file hang transfer madidiri anta heli. Sir, unless it is brought to the notice that certain file is missing, thousands files irtavalle. Ee file bartane illa, superior officer gotte agalla. He will not be having knowledge whether the file was placed before him or not. The duty of the concerned clerk is to put a note, get the signature, and whatever order is passed, put it in office note, then file will be again in his custody only.
moreover, sir, the calculation that's
So we're not concerned about the other things that will have to be considered independently. I'm seriously asking our office file.
is
A office file missing, it is not a joke. It is a serious offense. So one thing is certain, that you have not shown your devotion towards the duty.
in my absence it has taken.
How can you, when you are the custodian, how can you, in your absence, it will take place?
Daily work, I will all the files to after finishing. Even at the time of the transfer, I will be doing the same. And when I get the transfer somewhere, somebody, third person takes it.
Sir, how can he take a file, sir?
He has arranged.
Sir, how he has access, ನಾನು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ, ಅದ್ರ ಬಗ್ಗೆ ಉತ್ತರನ ಕೊಡ್ತಾ ಇಲ್ಲ ನೀವು. Sir, what 106 of the Evidence Act says? Then ನೀವು ಕಸ್ಟಡಿ ಒಳಗಿದ್ದೀರಿ, ನಿಮ್ ಕಸ್ಟಡಿ ಒಳಗಿನ ಫೈಲ್ ಮಿಸ್ ಆಗತ್ತೆ, ಬೇರೆ ಕಡೆ ಎಲ್ಲೇ ಸಿಗುತ್ತೆ, ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಉತ್ತರ ಕೊಡ್ಲಿ ಅದಕ್ಕೆ ಅಂತ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಕನಸು ಬೀಳ್ಬೇಕಾ ಅದು? How can you argue in this way? Why 106 is there? That is not a criteria, sir. Let the investigation be completed, sir. Sir, officer, ನಿಮ್ ಅನ್ನ ಹಾಕಿದ ಆಫೀಸು ಅದರ ಇಂಟ್ರೆಸ್ಟ್ ಪ್ರೊಟೆಕ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ನೀವು you are worried about your family. The institution has feeded your family throughout the service. That is not botheration. Sir, let the investigation be completed first. This is too early to consider. Let there be complete investigation agli, sir. After arguing the matter for some time, the learned counsel for petitioner submit that he may be permitted to withdraw the petition. Submission is placed on record. The petition is dismissed as withdrawn. ಮೂವತ್ತೊಂದು ಹತ್ತರಿಂದ ಇದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. Repeated same submission for want of records. ಈಗಿನ 10 ವರ್ಷ ರೆಕಾರ್ಡ್ಸ್ ತರಿಸಲ್ಲ, 10 ವರ್ಷ ಒಳಗಿರ್ಬೇಕಾ? ನಿಮ್ಗೆ ಏನ್ ಜವಾಬ್ದಾರಿ ರೀ? 439 439 ಸೀರಿಯಸ್ನೆಸ್ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ಬೇಕಲ್ಲ. If your IO is not serious, court will become serious. You should understand, sir. 31:10 ಇದೇ ಸೇಮ್ ಥಿಂಗ್. 31:10 ಟೈಮ್ ತಗೊಂಡ್ರಿ, 4:11 ಟೈಮ್ ತಗೊಂಡ್ರಿ. Again you are repeating the same dialogue. Whether he gets a bail or not, whether court grants bail or rejects bail, that is a secondary. ಒಂದು ಆರ್ಡರ್ ಆಯ್ತು, earliest order, he wants an early order so that his further avenue will be open. ಅದನ್ನ ಬಿಟ್ಟು ನೀವು ಬ್ಲಾಕ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. The learned counsel for petitioner present. The learned counsel and the learned HCGP again seeks time on the ground that he has not yet received the medical records pertaining to the victim. However, since last 2 adjournments, the same submissions have been made. Considering these aspects as a final chance, this is the matter. 15, 16, 16. The learned counsel for called out absent missed after 2 weeks.
Statement of the individual, the ESI has become PM. 2 AM in hospital.
Yes.
Address ಸಮಯದಲ್ಲಿ 5-6 ಜನ ಯಾವತ್ತೂ ಮಾಡಿ 6:30. Front was large. Number 3267. Injuries are not caused to the death. But he has been already discharged from the hospital. And the ರಕ್ತಗಾಯ ಮತ್ತೆ ಬೆನ್ನು ಹೊಡೆದಿರೋದು. This attacks only 906, not 907.
Are you sure? See, ಅವನು ಡಿಸ್ಚಾರ್ಜ್ ಆಗ ನಾನು ನೇಚರ್ ಆಫ್ ಇಂಜುರಿ ನೋಡ್ಬೇಡಿ. ಬಿಯರ್ ಬಾಟಲ್ ಕಲ್ಲಿಗೆ ಹೊಡೆದು ಅದರಿಂದ ಅದು ಹೊಡೆದು ಐ ಹ್ಯಾಡ್ ನೋ ಇಂಟೆನ್ಷನ್ ಟು ಕಾಸ್ ಯುವರ್ ಡೆತ್, ಐ ಹ್ಯಾವ್ ಕಾಸ್ ಓನ್ಲಿ ಥ್ರೆಟನ್ ಯು ಅಂತಂದ್ರೆ the allegations is against only these two persons. One is assaulted on the head and another person stabbed on the back, that shoulder back, that too by broken beer bottle. ಬೆನ್ನಿಗೆ
So there is no enmity.
enmity is secondary, sir. What is the concept? Why you have taken such a serious step? Only when he asked you to clear the glass pieces broken by you, ಕುಡಿದ ನಿಶೆಯಲ್ಲಿ ನೀವು ಏನು ಮಾಡಿದ್ರು ಎಲ್ಲರೂ ಸಹಿಸ್ಕೊಂಡಿರ್ಬೇಕಾ? ಕುಡಿದೇ ಒಂದು ಫ್ಯಾಷನ್ ಆಗಿದೆ, nobody should question. ಕುಡಿದ ನಿಶೆ ಒಳಗೆ ಏನಾದ್ರೂ ದಾದಾಗಿರಿ ಬಂದ್ಬಿಡುತ್ತೆ, ಇಲ್ಲದ ಪವರ್ ಎಲ್ಲ ಬಂದ್ಬಿಡುತ್ತ. No sir, other petitions ಕೈಯಿಂದ ಹೊಡೆದಾರ ಅಂತ ಹೇಳಿ ಅಲಿಗೇಷನ್ ಇದೆ. ನೀವು you have used the beer bottles, that too broken beer bottles, and you attacked on vital parts. ನೀವು ತಲೆಗೆ ಬೈರ್ ಬಾಟಲ್ ಹೊಡೆದಿದ್ದು ಅಟ್ಯಾಕ್ ಮಾಡೋದಂಗ ಆಗಲ್ವಾ? ವೈಟಲ್ ಪಾರ್ಟ್ಸ್, ಬೆನ್ನು ತಲೆ ವೈಟಲ್ ಪಾರ್ಟ್ಸ್ ಅಲ್ಲ. Let the investigation be completed, sir. No. Sir, yen, sir. Only 506, sir. 506 ನೋಡ್ಕೋತೀನಿ ಅಂದ್ರೆ 506 ಬರುತ್ತೆ ಹೋಗಿಲ್ರ? ನೀವು ನೋಡ್ಕೊಳ್ಳೋದು ಒಂದೇ ಅಲ್ಲ, ಅಟೆಂಪ್ಟ್ ಮಾಡಿದೀರಾ. And you are arguing that only 506 is attracted. How you are going to explain then injuries? The 2 days ತಗೊಳ್ಳಿ, ಒಂದೇ ದಿವಸ ತಗೊಳ್ಳಿ. Consequences of injuries you should have thought ಅಲ್ಲ. I thought, let us see after the completion of investigation. This is too early. So arguing the matter. Sometime the learned counsel for petitioner submit that he may be permitted to withdraw the petition. The submission is placed on the court. The petition is dismissed as withdrawn. Learned counsel for petitioner called out absent. Who is the matter up to 3 weeks.
Number one. Where is daughter? Friend, daughter is doing not good. You got to that lot one FIR has been registered on cities. But the thereafter blood, it is a complaint is being lodged by the complainant saying that these accused persons, number 1 to 6, said to the Lord that complaint said that daughter is being. So we'll make you sure that there is a oral but the present petition before the worship who are no longer related to either of the families are the accused. Accused number 2 is not the brother of the accused. 3 and 4 are not the parents of the accused. Accused number 5 and 6 were the son and the mother, who are not nowhere not concerned to the either of the families. The first FIR what I have produced along with this petition, what your lordship will get to page number 29 the complaint. They read the complaint note. That is the first FIR first. Very conduct last very this is blocked by not that deceased now that is father of the girl. And very conduct will also Kayam is also super window of the then the victim girl. That is Sanjana there. ವಿಚಾರ ಮಾಡಬೇಕು ನನ್ನ ಮಗಳು 17 ವರ್ಷ ವಯಸ್ಸಿಗಳು ಮನೆಯಲ್ಲಿ ನಮ್ಮ ಗ್ರಾಮದ ಸುಮಾರು 25 ವರ್ಷದಿಂದ ಅತಿಮೇವರ ಮಗನಾದ ನಮ್ಮ ಮನೆಯ ಬಳಿ ಬೈಕಿನಲ್ಲಿ ನನ್ನ ಮಗಳನ್ನು ಬಲವಂತವಾಗಿ ಅಂದರೆ ನಮ್ಮ ಊರಿನ ಆಡಿನ ಪಡೆಯುವ ಸಲುವಾಗಿ ಉಂಡೇಗೌಡರು ಅವರು ಕಣ್ಣಾರೆ ನೋಡಿ ವಿಚಾರವನ್ನು ತಿಳಿಸಿ ನಂತರ ಅಭಿ ಮತ್ತು ವಿಚಾರ ಮಾಡಬೇಕು. ಯಾರು ಸಹ ಮನೆಯಲ್ಲಿ ಇರಲಿಲ್ಲ. ಇದನ್ನು ನಮಗೆ ದೂರವಾಣಿ ಸಂಪರ್ಕ ಸಿಕ್ಕಿರುವುದು. But in this complaint, we are not named as after this, 3 days after this murder, another complaint is being lodged. By that time, not the victim's father has been committed. That complaint is not actually ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧ ನಾನು ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುವುದೆಂದರೆ ನನ್ನ ಮಗಳಾದ
ಅಡಿಕೇರಿಯಿಂದ ವಾಚಿಸುತ್ತೆ ಆಗ ನನ್ನ ಪತಿ ಕಾಲೇಗೌಡರವರು ದಯಮಾಡಿ ನನ್ನ ಮಗಳ ಮನೆಗೆ ವಾಪಸ್ ಬೇಡಿಕೊಂಡ ಸಭೆಯ ನನ್ನ ಎಲ್ಲರ ನೀನು ನಮ್ಮ ಗ್ರಾಮದಲ್ಲಿ ಬೆಳೆಯುತ್ತಿದ್ದ ಹಾಗೆ ನಿನ್ನ ಮತ್ತು ನಿನ್ನ ಮನೆಯ ಬಗ್ಗೆ ಈ ಸಮಯದಲ್ಲಿ ಬಹಳ ಒಂದು ಸಮಾಧಾನ ಮಾಡಿ ಕಳಿಸಿದರು. ಆ ಕಾರಣದಿಂದ ಮನೆಯನ್ನು ಮಾಡಿ ನಿಮ್ಮ ಪತಿಯವರ ಸಭೆಗೆ ಒಳಗಾಗಿ ಮತ್ತೆ but the victim girls has been traced. Accused number 1 is been apprehended, but the statement of the what there been also recorded. So there is no the victim girl also doesn't say a single word against it.
ಡಸ್ಟ್ಬಿನ್ ಹಾಕ್ತೀನಿ, ಮೆಮೊ ಹಚ್ಚಿ ಕೊಡಲ್ದ ನಾನು ಅಷ್ಟೇ ಎಲ್ಲರಿಗೂ. ನನಗೆ ಎಕ್ಸ್ಪ್ಲೇನೇಷನ್ ಬೇಕಾಗಿಲ್ಲ ಸರ್, ನೀವು ಏನ್ ಕೊಟ್ರು ಮೆಮೊ ಹಚ್ಚಿ ಡೆಕರಮ್ ಮೇಂಟೈನ್ ಮಾಡಿ ಕೊಡಿ, ಅದರ್ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿ. ಯು ಆರ್ ಆಫೀಸರ್ ಆಫ್ ದಿ ಕೋರ್ಟ್, ಒಂದು ಡೆಕರಮ್ ಮೇಂಟೈನ್ ಮಾಡಿ ನೀವು ಕೊಡಿ. ಕೋರ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಳಕ್ ನಾನು ರೆಫ್ಯೂಸ್ ಮಾಡಲ್ಲ, ಬಟ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಶುಡ್ ಬಿ ವಿತ್ ಸಮ್ ಡಿಗ್ನಿಟಿ. ಮೆಮೊ ಹಚ್ಚಿ ಕೊಡಿ, ರಿಲೈಯಿಂಗ್ ಇಟ್ ಅಂತ ಹೇಳಿ ಕೊಡಿ, ಡೆಫಿನೆಟ್ಲಿ ಕನ್ಸಿಡರ್ ಇಟ್. ಇಲ್ಲೇ ಇದನ್ನ ನೋಡ್ಕೊಳ್ರಿ ಅಂತಂದ್ರೆ ಕೋರ್ಟ್ ಅಂದ್ರೆ ಏನು, ನೀವು ಡಸ್ಟ್ಬಿನ್ ಇದು. ಡೋಂಟ್ ಡಂಪ್ ದಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನೀವು ರಿಲಯಬಲ್ ಇತ್ತಂದ್ರೆ ಅಲಾಂಗ್ ವಿತ್ ಮೆಮೊ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಅಬ್ಸಲ್ಯೂಟ್ಲಿ ನೋ ಪ್ರಾಬ್ಲಮ್. ವಿಲ್ ಡೆಫಿನೆಟ್ಲಿ ಅಪ್ರಿಸಿಯೇಟ್ ದಿ. ಇಫ್ ಯು ವಾಂಟ್ ಟು ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್ ನೀವು ಪ್ರಾಪರ್ ಫಾರ್ಮ್. ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ ನಂದೇನ್ ಬೇಡ ಅನ್ನ, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದ್ರಿಂದ ಪ್ರಾಪರ್ ಆಗಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ, ಡೆಫಿನೆಟ್ಲಿ ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್.
What the word they have used, why they have used. But I am not in what the relative of the accused. Accused number 1 with our parents brother now accused. But I am not the over concerned to be implicated in this case for critical motive. But my daughter's marriage is scheduled. But this is not the invitation card also not allowed. Number request is not allowed.
Your name specifically alleged in the complaint. That you, when the other accused number 1 to 4 threatened, you were also present with them. Similar allegations were made. One day, omnibus allegation irli. A minor daughter of a person is kidnapped. He was humiliated in the village. Again, ಅದಕ್ಕೆ ಮತ್ತ ಖಾರ ಉಪ್ಪ ಹಾಕೋಣ ಅಂತ ಹೇಳಿ ಮನೆಗೆ ಬಂದು ಹ್ಯೂಮಿಲೇಷನ್ ಮಾಡಿದ್ರೆ ವಾಟ್ ಇಟ್ ಅಮೌಂಟ್ಸ್? ಮನೆ ಮುಂದೆ ಬಂದೆ, ಮನೆ ಮುಂದೆ ಅಂದ್ರೆ ಇನ್ನು ಪಬ್ಲಿಕ್ ಒಳಗ ಆಗ್ಲಿಲ್ವಾ? ಇಟ್ ಈಸ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ಅಲೇಜ್ಡ್, ಬಟ್ ದಿ ಫ್ಯಾಕ್ಟ್ ಇಸ್ ದಟ್ ಡೆತ್ ಇಸ್ ದೇರ್. ದಟ್ ಈಸ್ ಟು ಕನ್ಸಿಡರ್ಡ್. You don't want to produce the 164 statement, produce money, then I'll consider it. How you are related document shows that the allegation against you also. A normal 306 is different, but here the 306 is based on earlier complaint.
The victim is not on a village. Police arrest ಮಾಡಕ್ಕೆ ಕೊಡ್ತೀವಿ.
Sir, ನನ್ ಮುಂದ records ಇಲ್ಲ. You are arguing without records.
It is in the complaint.
It is in the complaint. He is there ಅಂತ ಹೇಳಿ ಎಷ್ಟ allegation.
All together.
Correct ರೀ. ಅವ absconding ಇದ್ದ ಅಂತ ಹೇಳಿ ಯಾ ಬೇಸ್?
That is not he was not in a village.
ಹೆಂಗೆ ನೀವು, how you are going to say he is not in a village? You are not representing him, you are not concerned with him, you are not related to him, but you say that he was not in village. You are defending him.
Why I am saying is
No sir, document produce ಮಾಡಿ.
Complaint itself is not not CS.
We will consider it, sir. New document produce ಮಾಡಿ. You are seeking anticipatory bail. Urgency ಇರ್ಲಿ 27th, not there is no urgency. ನಿಮ್ಮ ಮಗಳ ಮದುವೆ ಬಗ್ಗೆ ನಿಮಗೆ ಅರ್ಜೆನ್ಸಿ ಆಗಿದೆ. ಒಬ್ಬ ಮಗಳ ಜೀವನ, ಒಬ್ಬ ತಂದೆ ಮಗಳ ಸಲುವಾಗಿ ಜೀವನ ಕಳ್ಕೊಂಡು ಅದನ್ನು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. I never said that it is not the opinion of the court that your cause, but let there be on records. ನೀವು ಏನ್ ಕೊಡ್ತೀರಿ records ಮೇಲೆ ಪ್ಲೇಸ್ ಮಾಡಿ. You consider it, you will appreciate it. ನೀವು ಬರೀ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲ್ದ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು then produce it. Produce ಮಾಡಿ victim statement. You want to refer it, but you don't want to produce it. Why? ನೀವು ಯಾವಾಗ ಸಿಕ್ತು ನನ್ಗೆ? See, if you want to refer it, definitely you refer it, you produce it, will definitely appreciate it. ನಾನು ಇವತ್ತು ಮಾಡ್ತೀನಿ ಗ್ಯಾರಂಟಿ ಕೊಡೋಲ್ಲ. ನೀವು ಪಾಸ್ ಈ ರೀತಿ ಆದ್ರೆ ಈ ರಿಕ್ವೆಸ್ಟ್ ಮಂಡೇ ಇಲ್ಲ ಟ್ಯೂಸ್ಡೇ ಆಗುತ್ತೆ ನೋಡಿ. ಟ್ಯೂಸ್ಡೇ ನೀವೆಲ್ಲ ಮೊದಲನೆಲ್ಲ ಕೊಟ್ಟು ಅವ್ರ ಕಾಪಿ ಕೊಟ್ಟು ಪ್ರಿಪೇರ್ ಆಗಿರ್ಬೇಕು ಕೆಲ್ರ. ಇಲ್ಲಿ ನೋಡ್ಕೊಡ್ರಿ ಅನ್ನೋದು ದಟ್ ಇಸ್ ನಾಟ್ ಫೇರ್. ಯಾಕಂದ್ರೆ ಏನಾಗುತ್ತೆ, ಸಿ ಐ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಪಾಸ್ ಸಮ್ ಆರ್ಡರ್ಸ್, ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಡಾಕ್ಯುಮೆಂಟ್ ವೆನ್ ಯು ಪ್ರೊಡ್ಯೂಸ್ ಇಟ್. If that document is to be appreciated, it should be placed on record. The document ಇಲ್ದಾಗ ನಾನು ಹೇಗೆ ಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ತಪ್ಪಾಗತ್ತೆ. ಕೊಡಿ. ನೋ, ಅದೆಲ್ಲ ಕತೆ ಇಲ್ಲ ನಮ್ಗೆ. ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್, ಹಾಫ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಏನು ಇಲ್ಲ. ರೂಟೀನ್ ಸಿ ದಟ್ ಈಸ್ ಅ ಡಿಫರೆಂಟ್. ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ನಾನು ಯಾರಿಗೂ ಕೊಡ್ತಾ ಇಲ್ಲ. ಎಲ್ಲ ರೀಚ್ ಆಗತ್ತೆ. ನಮ್ದು ಬೋರ್ಡ್ ರೆಗ್ಯುಲರ್ಲಿ ನನ್ನ ಬೋರ್ಡ್ 95% ಬೋರ್ಡ್ ರೀಚ್ ಆಗತ್ತೆ. ನಾನು ಎಕ್ಸೆಪ್ಟ್ 1 or 2 few dates ಬೋರ್ಡ್ ರೀಚ್ ಆಗಿಲ್ಲ. ನಿಮ್ದು ಒನ್ ಡೇ ಎಕ್ಸೆಪ್ಷನ್ ಆಗಿರ್ಬೋದು. 99% ನಾವು ರೀಚ್ ಆಗ್ತಾ ಇದೀವಿ ಬೋರ್ಡ್. ಇವತ್ತು ಬೋರ್ಡ್ ರೀಚ್ ಆಗುತ್ತೆ 15th as per request.
In the section 438, the offences are 420, 465, 468 offences. Complaint dated 18/8/2022 brought by Tahsildar of Successive.
Yes.
He received a letter from the respondent dated 20/25/2022. Police Minister Police Patra Sanjay ದಿನಾಂಕ 25/2022 ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ ಪತ್ರದಲ್ಲಿ ಕೋಕಿಕೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 34 ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಎಂಬುವರು ಸುಮಾರು 10-15 ಜನರಿಗೆ ಅನಧಿಕೃತವಾಗಿ ಆಶ್ರಯ ನಿವೇಶನ ಆಶ್ರಯ ಜಾಗವನ್ನು ಹಾಗೂ ದಾಖಲೆಗಳನ್ನು ಅಭಿಪ್ರಾಯ ನೀಡುವಂತೆ ಕೋರಿರುವ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸುವುದಾಗಿ ನಿಮ್ಮ ಪತ್ರದಲ್ಲಿ ಲಗತ್ತಿಸಿರುವ ಪುಟ ಸಂಖ್ಯೆ 5/52 ಲಗತ್ತಿಸಿರುವ ದಾಖಲೆಗಳಲ್ಲಿ ಸ್ವಾಮಿನಾಥ ಹೆಂಡತಿ ಜಯಬಾಯಿ ಶಕ್ತಿನಾಥ ತಂದೆಯಿಂದ ನಾಯಕ ಶಕುಂತಲಾ ತಂದೆಯಿಂದ ನಾಯಕ ಪತ್ರಗಳ ಜೆರಾಕ್ಸ್ ಪ್ರತಿಗಳನ್ನು ಪರಿಶೀಲಿಸುವುದಾಗಿ ಬರೀ ಹಕ್ಕುಪತ್ರಗಳನ್ನು ಈ ಪ್ರಾಧಿಕಾರದಿಂದ ನೀಡುವುದರಿಂದ ಅದರಿಂದ ಮುಂದಿನ ಕ್ರಮ is the reference that will going to be not to the respondent to be taken experience. According to this blood, nowhere stated that alleged incident when it was occurred. Maybe come to the page number 9 Alexa FIR. Column number 3 minutes Kutti and Nagada Dinaka Naku 1992. That's the FIR had been last minute on 29/8/2022. Up to 30 years this first information has been. On second column, subsequent column, Parthigar Kadavagi Varadi needed the complaint also, there is no explanation single line or word regarding delay in filing the complaint. Moreover, based on the report given by the respondent, only similar this complaint as last. That was based on Xerox Pratigram correction. Like their allegation that Supatra has been got registered. They have to obtain certificate copy. Further, none of the victim lodged a complaint with the respondent police. Till 30 years from the allegation.
Yes.
Before there is an inordinate delay in filing the complaint and the alleged offences are may extend to 7 years.
You are not argued on merits. You are only harping on delay. You are only harping on delay and you have not argued anything on merits of the case.
This Xerox copies he given opinion with the appellant.
So Xerox copy mein opinion kodak baralla anta.
Opinion according to
No, it is opinion that they were not issued by the competent authority. That's all. They were not issued by competent authority. Then
allegation. You have created a document.
you have created and executed shell deeds.
If at all created and executed by me, up to 30 ವರ್ಷ ಯಾರಾದರೂ
ಯಾರ್ ಮನೆ ಕಟ್ಟಕ್ ಹೋಗಿ ಪರ್ಮಿಷನ್ ಕೇಳಿದ ಮೇಲೆ ಗೊತ್ತಾಗೋದು, ಅಲ್ಲಿವರೆಗೆ ಯಾರಿಗೂ ಏನೂ ಗೊತ್ತಾಗಲ್ಲ. ಅವ್ರು ತಗೊಂಡು ಕೂತಿರ್ತಾರೆ. ದೇ ಆರ್ ರಿಜಿಸ್ಟರ್ ಆಗ್ಲಿ ಸರ್, ರಿಜಿಸ್ಟ್ರಿಂಗ್ ಅಥಾರಿಟಿಗೆ ತಲೆ ಕೆಡಿಸ್ಕೋದಿಲ್ಲ ಅವರು. ಸರ್ಕಾರಕ್ಕೆ ರಿಜಿಸ್ಟ್ರಿಂಗ್ ದುಡ್ಡು ಬರುತ್ತೆ. ದೇ ಆರ್ ಬೌಂಡ್ ಟು ರಿಜಿಸ್ಟರ್ ಆಸ್ ಪರ್ ದಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಕ್ಟ್. ಇಟ್ ಇಸ್ ಮ್ಯಾಂಡೇಟರಿ. They are not bothered about the other things.
Lordship is refined. ಈಗ ನಾನೇನೋ ಡಾಕ್ಯುಮೆಂಟ್ ತಗೊಂಡ್ಲಿಕ್ಕೆ ಹೋದೆ, ಅವಾಗ ಗೊತ್ತಾಯ್ತು ನನಗೆ ನಾಟ್ ಒರಿಜಿನಲ್ ಅಂತ. That is not the allegation. None of the single
The allegation is that That is one thing, that is, we will consider it. The issue is creation of the Hakkupatra and execution of the sale deed.
30 years back.
Yavagare haki.
Years back.
See, question is, now,
ನಾವು ಅಲ್ಲಿ ಹೋದಾಗ ಗೊತ್ತಾಯ್ತು ನಮ್ಗೆ
sir, ಅದು original ಅಂತ ನೀವು ಹೇಳ್ತೀರಾ? Are you asserting then? No, sir, let the investigation be concluded. ಆಯ್ತು, ಅದನ್ನ ನೋಡ್ಕೋಬೇಕಲ್ಲ, ಇನ್ನ it is part of the investigation. Too early to come to a final opinion. No, sir. No, sir.
We cooperate with the investigation.
No.
They say that amount was received. What is the mode of payment? Nothing.
ಸರ್, ಅದನ್ನ ಇನ್ನ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಒಳಗೆ ಬರುತ್ತೆ. ನೀವು ಯಾವ ಡೇಟಿಗೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರಿ ಎಲ್ಲ ಬರುತ್ತೆ. ಎಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಈಗ ನೀವು ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಕೊಟ್ಟ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡೋದಿದ್ರ ನಿನ್ನೇನು ಇಂಟರ್ವ್ಯೂಷನ್ ಮಾಡಿ? ನೋ ಸರ್. Sir, first thing, one thing is certain. Now they are very sure that all the Hakkupatras are the forged. They are not issued by a competent authority. One that is clarified from the statement of the Tahsildar. And you are not asserting that there were Hakkupatra issued by the competent authority. It is not your case that you have not executed the sale deeds also. When you are only targeting the delay and the latches, the merits, the other merits are required to be considered. This is not a ground at this juncture, sir, because that too an anticipatory bail iddaga.
All not made of it.
Yes.
They have created. I
Yes.
have taken the person into.
The petitioner has filed the petition under section 438 of CRPC, seeking anticipatory bail in the event of his arrest in Hosadurga PS crime number 364 of 22 for the offences punished under section 420, 465 and 468 of the IPC. Third, the learned counsel for petitioner, the learned HCGP for state. There is the records. The Tahsildar has set the law in motion on the basis of a reference made by the EI of Hosadurga police station by lodging a complaint on 18/8/22, wherein he has clarified that no Hakkupatras were issued in the name of persons in respect of the land belonging to municipal council in survey number 34 of Bokikere village, which is a government Goma land situated behind the Muslim graveyard. And it is alleged that the present petitioner has created the Hakkupatras in the name of 10 to 15 persons and has received rupees 2,50,000 from each one of them. And then by issuing Hakkupatra, he got sale deed registered. In this regard, a complaint came to be lodged after delay of 30 days. On the basis of the complaint, the investigating officer has issued a FIR and apprehending his arrest, the petitioner has approached the learned session judge and learned session judge has rejected the bail petition filed by the petitioner. Hence, the petitioner is before this court. Having heard the arguments and perusing the records, it is evident that the alleged offense were said to have been committed about 30 years back, when the present petitioner is alleged to have created the documents and distributed size to 10 to 15 persons under Ashraya scheme in respect of survey number 34 of the government Gomala land by obtaining rupees 2,50,000 per site from 10 to 15 persons. The main contention of the learned counsel for petitioner is that there is a delay in lodging the complaint, and complaint was lodged after 30 years, and the opinion expressed by the Tahsildar is based on Xerox copy. But however, it is not the case of the petitioner that the Hakkupatra issued were genuine documents. Only a delay cannot be ground for ignoring the seriousness of the offense, as the offense is against the purchasers as well as the state. The state was also cheated, and the state property was distributed to certain persons by receiving cash amount of rupees 2,50,000 per site. These offenses are required to be investigated in detail. The petitioner is seeking anticipatory bail. There are serious allegations regarding fabrication of documents and alienation of human land. These matters are required to be investigated in a detail, and for that purpose, the custodial interrogation of the petitioner is also essential. At the same time, the investigating officer is also required to obtain necessary documents from concerned register also. And looking to these facts and circumstances, if the bail petition is granted, anticipatory bail is granted, there is every possibility of tampering the prosecution witnesses. The custodial interrogation of the petitioner is essential. In considering these aspects, the petition being devoid of any merits and hence it does not survive for computation. Accordingly, it stands dismissed. Next.
Yes,
ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ? Weeks as per request. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ? ನೀವು ಯಾವಾಗಾರ ರಿಸೀವ್ ಮಾಡ್ರಿ, ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅಂತ ಇಷ್ಟೇ ಕೇಳಿದೆ.
It is published on 4th September.
ಆಯ್ತು ವಕೀಲ್ರ. ಇದು ನೀವು ಒಂದು ಕೆಳಗೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೇನಾ, ದಿಸ್ ಈಸ್ ಓನ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಕಾಪಿ ಅಂಡ್ ಒರಿಜಿನಲ್ ಈಸ್ ಪಬ್ಲಿಷ್ಡ್ ಇನ್ ಸಚ್ ಅಂಡ್ ಸಚ್ ನ್ಯೂಸ್.
ಇದು ಹೇಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ
ನನಗೆ ಹೇಗಿದೆ ಅಲ್ಲಿ ಕೇಳಿದೆ, ನಿಮ್ಗೆ ಇದ್ರಲ್ಲಿ ಏನ್ ಗೊತ್ತಾಗತ್ತಾ?
ಪಬ್ಲಿಷ್ ಮಾಡಿರುವಂತದ್ದು ಪೇಜ್ ನಂಬರ್ 10 ಅಲ್ಲಿ ಲಿಂಕ್ ಓಪನ್ ಮಾಡಿದ್ರೆ ಹೇಳ್ತಾರೆ ಅದರಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿದ್ದೇನೆ ಅಂತ ನಾನು ಹೇಳಿದ್ದೇನೆ.
ಎಲ್ಲಿದೆ ಇದರಲ್ಲಿ? ಇದ್ರಲ್ಲಿ ಮಂದಿ ನೀವ್ ಹೇಳಿದಿರಿ, ಎಲ್ಲಿದೆ
ಓಪನ್ ಮಾಡಿ
ಎಲ್ಲಿದೆ ಅದು? ಲಿಂಕ್ ಓಪನ್ ಮಾಡುವವರೆಗೆ ವೇಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಇವರಿಗೆ? ದಿ ಹೆಡ್ಲೈನ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಸೋ ಮಿಸ್ಲೀಡಿಂಗ್. ವೆರಿ ಮಿಸ್ಲೀಡಿಂಗ್ ಹೆಡ್ಲೈನ್.
ಪೇಜ್ ನಂಬರ್ 8. This is the Twitter post. ಅವರದೇ Twitter post. ಪೇಜ್ ನಂಬರ್ 1 ಅಲ್ಲಿ ತೋರಿಸಿದೆ.
ಹೌದು, ಇರ್ಲಿ ಬಿಡಿ ಸರ್. ನಾವು
ಅದೇ ಹೆಡ್ಲೈನ್ ನಾನು ಇಲ್ಲಿ ಫಸ್ಟ್ 2 ಲೈನ್ಸ್. Second paragraph also they have stated. Twitter ಅಲ್ಲಿ ಮಲಯಾಳಂ and ಕನ್ನಡ ಎರಡೂ ಇದೆ. ಅವರೇ ಹೇಳಿದ್ರು.
ಯಾರು ಹೇಳಿದ್ದು? ಯಾರು ಹೇಳಿದ್ದು?
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಟ್ವಿಟರ್ ಪೋಸ್ಟ್ ಇದೆ. Twitter @ untold washisharma.com ಇದರಲ್ಲಿ ತೋರಿಸ್ತಾ ಇಲ್ಲ.
Either it is a genuine.
ವೆಬ್ಸೈಟ್ ಇಂದ
ಸರ್ ವೆಬ್ಸೈಟ್ ಲಿಂದ ಡೌನ್ಲೋಡ್ ಮಾಡಿ ಅದನ್ನ ನೀವು ಮತ್ ಪಬ್ಲಿಸಿಟಿ ಕೊಡ್ಬೇಕಿಂತ ಮುಂಚೆ ವಾಟ್ ಇಸ್ ದಿ ಡ್ಯೂಟಿ ಕಾಸ್ಟೆಡ್ ಆನ್ ಯು ಟು ಅಸರ್ಟೈನ್ ದಿ ಜೆನ್ಯೂನ್ನೆಸ್ ಆಫ್ ದಿ ನ್ಯೂಸ್ ಪಬ್ಲಿಷ್ಡ್ ಇನ್ ಎನಿ ವೆಬ್ಸೈಟ್. ಒಂದು ವೆಬ್ಸೈಟ್ ಒಳಗೆ ಬಂತು, ಅದನ್ನೇ ನಾನು ಹಾಕೊಂಡು ಹೋದೆ. ಒಂದು ವೆಬ್ಸೈಟ್ ಒಳಗೆ, ಒಂದು ಫೇಕ್ ವೆಬ್ಸೈಟ್ ಒಳಗೆ ಒಂದು ಬರೀತಾರೆ ಸೋ ಅಂಡ್ ಸೋ ಕಮಿಟೆಡ್ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಹೇಳಿ, ಅದನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತೀರಿ. ನನಗೇನು ಗೊತ್ತು? ಆ ವೆಬ್ಸೈಟ್ ಒಳಗೆ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ದೀರಿ. ಆ ವೆಬ್ಸೈಟ್ ಜೆನ್ಯೂನ್ ವೆಬ್ಸೈಟು, ಫೇಕ್ ವೆಬ್ಸೈಟು, ಹ್ಯಾವ್ ಯು ಅಸರ್ಟೈನ್ ಫಸ್ಟ್? ಅವ್ರ ಓನ್ ಅಕೌಂಟ್ ಇರ್ಲಿ, ನೀವು ಅಸರ್ಟೈನ್ ಮಾಡ್ಕೋಬೇಕಾಗಿತ್ತಾ? ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಇಸ್ ನಾಟ್ ದಿ ಗ್ರೌಂಡ್. If you want to borrow a news from one media, and publish it in your own media, you should ascertain the genuineness of the news alva. ಆ ಮೀಡಿಯಾ ಒಳಗೆ ರಿಪೋರ್ಟ್ ಆಗಿದ್ರೆ ಅದಕ್ಕೆ ನಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ಈ ರೀತಿ ಅಂತಂದ್ರೆ ನಿಮ್ ವೆಬ್ಸೈಟ್ ಒಳಗಂದ್ರೆ ಅದು ಮೀಡಿಯಾ ಅಲ್ಲ. your website is not in public domain. It is in public domain. Then you are seeking anticipatory bail, sir. No, sir. ಈ ರೀತಿ ಇದಕ್ಕೆ ಆಂಟಿಸಿಪೇಟರಿ ಕೊಟ್ರೆ ವೆರಿ ಸೀರಿಯಸ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್. ಯು ಆರ್ ಟಾರ್ಗೆಟಿಂಗ್ ಎ disruptions of communal harmony. That is the manifest from the open. You are not supposed to do it, sir, unless you get a confirmation. ಅಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ನಾನು ಅದನ್ನ ರೀಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ ಅನ್ನಕ್ ಬರಲ್ಲ. Unless you have got a genuine confirmation, then only you can publish it. You cannot do it, sir. No, sir. Produce ಮಾಡಿ Monday ಇಲ್ಲ next week ರೀ, next Friday. ಒಂದೇ ನಿಮಿಷ. Yes, Supreme.
Please, this is to be open the agency. Okay.
Offenses, 417.
Okay, borrowers. Registered agreement of sale in respect of a client.
Yes.
By the developer as well as the owner. Twice. 19,170. When the complaint says plan to agree to be completed in 6 months by July, with an extension of another 6 months. When which the builders are agreed to give rental for rupees 1 lakh. Does the page 20 after the complaint. Complaint is of 19,117, subsequently on 17,417, 15 lakh 50,000 paid, 17,280, 15 lakh 50,000 paid, in 11,2018, 15 lakhs, 5 lakhs was paid. So the agreement was not given any weightage of this 6 months or 6 weeks. And he keeps quiet. There is no correspondence at all between the parties. The agreement provides for referring to this clarification and for specific performance of the contract. The Lordship will get at page 41. Clause 6 of the agreement. Any dispute arising between the parties under an agreement and the withdrawal, anything between them is parties not be able to resolve the dispute amicably despite reasonable solvent. The agreed party is entitled to the enforcement of the if you had any demands, he should have at least made a demand. If in January 2018, there are 2 heavy payments in the case. Owners of the land have filed a suit. Your Lordship will get at page 115. OS number 4273. Here, these parties, Appellant and his wife are arraigned as defendants 27 and 28. The Lordship will get their names at page 120 and 128. They have ended appearance and they did not contest the suit at all. The suit is for various reliefs. The Lordship will get there. Joint development agreement is ought to be declared initiated. And the mandate given, that is general power of pledge given to the developers is ought to be cancelled. Agreement of sales executed has ought to be declared null and void. The banker who had financed the developer company
As approached the NCLT, the Lordship will get at page 152. NCLT has passed restrained orders against the company. The Lordship will get at page 160 and 160. This includes creating any charge or creating any sale or anything of that. This order is passed in February 2020. Present complaint is filed. But all the directors, ex-directors, who again, the parties who have signed the agreement fantasy get rated at this stage, 5 years left to be without resorting to any civil remedies, or without even issuing a demand notice, any point of liability is not disputed. MNE is not disputed. Each state agreement is not disputed. These are the additional one is the managing director. Petitioner 2 is another director. Petitioner 3 is the wife of petitioner. It was also a director. Petitioner number 4 is only a signature to this agreement as a business. But the question of all payments are made, people are not checks. There is nothing to be in a custodial interrogation. Because in conditions that there will be.
He is an agent who used to introduce his money and also he and he has introduced various main allegations in this particular case. Totally instructed total measurement of the property after this each of the law to 85 and these petitioners they have conveyed 1,28,000 rupees per bed to registered state and in some cases agreement. Yeah, across my candidacy, the availability of this case is 85,000. These people they have sold 1,28,000 and they have the multiple sale dates and agreements in respect of the very same flat. And another, they have sold this particular more than 130 cases. And investigation is going on.
From how many purchaser who has registered or who have saved in the register has to be ascertained. Number one, the agreement holders one by one they are coming to stating that particular company and the directors there are not any details of the state there are various persons. In this context, the custodial interrogation assumes important. Unless we interrogate taking it is very difficult because though it is in the realm of a civil nature, because of this cheating and criminal charges, now that has to be the another important factor is whether they have obtained proper sanction plan from the competent authority, whether in the end they have extended what they have promised. But it is not merely a case of cheating. So, is under section 41A is issued. They are not cooperating. They are not come for an investigation. And they are avoiding the law. Another important factor is they are capable. And some of the yes, like in the present case, they have threatened us to come take care of you, taking their charge. Therefore, unless they are taken very difficult exact amount has been important. For how many people? One after the other person they are approached. If the accused, the petitioners, this particular case, his job, certainly they are going to influence the investigation. And this is also. And many persons who are CWs, they have given statement. Totally 29 statement given. And this is 29 CWs with respect to law number 5. Totally 11 floors are there. One by one they are approaching us. And this time just is officially yes, we have committed cheating, really cheating, will be therefore certainly case therefore my submission is not the case at this juncture. The these people they have paid substantial and MOU is also under the MOU they are the
written the amount, entire amount, but they have not done. This is another factor which clearly indicates. The senior counsel, he has stated so there in the occupation class, what is that? That is not the prosecution to be done. In many matters, yeah. Those everything is like a system. Whenever safeguard, it's not the new thing. There also he has stated so many. These people, this company, the persons who have invested their money, have searching various avenues, get their money at least above the flats. Therefore, they are very much required information. Without their presence, very difficult to tell the exact amount. Now, when are they saying, period before the court, that stating the only that the 85% more than extra to that. Senior counsel addressing the argument that that is also CLT and NCLT. NCLT also appears to be any service on the therefore, in a way, we are also it is also part of it. So the civil aspects. Now I am concentrating on the criminality. There, NCLT has admitted that there is a crime. On the basis of that, he is not. He can say this is document. What prevented him? What he has to that itself shows. And the how much they have been from. Now we are not in a position to exactly those that various. Therefore, probably it will go beyond the 100 posts. Many people know. Therefore, my submission is it's by Naveen P. Electoral submission, this does not cover, beyond these 82. These 80s are executed not only by agreement. 80,000 percent to 170,000 1 crore.
What is the period of particular 1 year, something being added is understand. They are all years 2017, only 2 transactions. Then 19, then 20, then 20. I think I have expected for all this year. I expect to submit a violence. Taken in cash and not accounted. Any payment by any one of them is one year. Additional lordship are not this particular date. And one Manjula is said to have been executed as few. It's not connected to this. Lordship is the prediction. There is no harm in having but NCLT or that is decided. In the circumstances of the case, why would the case they are not made issues. You can understand the company and is managing that here. Hello. That means transaction is not equal. If they are really intended to adjust this property, there should not be some demand. Some demands. I don't say that you have gone to demand for either executing the sale deed or to refund them. Nothing of that kind. He has to keep an asset in that. He is coming. I think you anticipate the equation is not by getting up here.
Who has filed this application? Rejected. His one is there already. You are also aggrieved person. That's all. Yeah, all aggrieved person need not be given. One person is already given permission. You can sell with him. We are not here to build up the file. No, matter he is there. No, he is one person is assisting. You can assist him. He will in turn assist the prosecution. You are not allowed to approach the court. Matter ends there. You are not a de facto complainant. Then nothing prevented you from lodging a private complaint to show your bona fides. Or over complaint ಮಾಡಿದ್ರು nanu there is no end for litigation then. You can assist him. He is there to assist him. He is granted permission. ಮತ್ತೊಂದು 50 ಜನ ಬರ್ತಾರೆ ನಮಗೂ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ಬೇರೆ ಕೋರ್ಟ್ ಕೆಲಸ ಇಲ್ವಾ? Heard reserved.
ಅಲ್ಲಿ ಆರ್ಡರ್ ಯೂನಿಟ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ
Now,
Hello. Hello. Sir, hello, port officer.
ಹೇಳಿ ಸರ್.
Sir, madam, ಈಗ 2.5 ಮೀಟರ್ ಧಾರವಾಡ ಹೈಕೋರ್ಟ್ ಇಂದ ತಗೊಂತೀರಾ, ಧಾರವಾಡ ಬೆಂಚ್ ಇಂದ ತಗೊಂತೀರಾ ಅಥವಾ ಪಾಸ್ ಓವರ್ ಮ್ಯಾಟರ್ ತಗೊಂತೀರಾ ಮೇಡಮ್ ಈಗ 2.5ಗೆ? ಧಾರವಾಡದ. ಥ್ಯಾಂಕ್ಸ್ ಮೇಡಮ್.
ಸಾಹೇಬ್ರನ್ ಕೇಳ್ತೀನಿ ಸರ್, ನೀವು ಲೈನ್ ಅಲ್ಲೇ ಇರಿ. ಸಾಹೇಬ್ರ ಹೆಂಗ್ ಹೇಳ್ತಾರ ಹಂಗ್ ಮಾಡಿ.
ಶೂರ್ ಮೇಡಮ್.
Petition is allowed subject to conditions.
Please, my lord, kindly phrase 1 week time, sir. Taking the steps for respondent, sir, please.
PF ಕೊಡಕ್ಕೂ time ಬೇಕಾ ನಿಮಗೆ?
Sorry, sir. Sorry, my personal inconvenience. I am not taking steps to, sir. Please.
Why? What is it? One copy ಕೊಡ್ಲಿಕ್ಕೆ, then why you have filed petition if you are incapable of taking steps?
Sorry, my lord. Personal inconvenience is not taking the steps, please.
ಅಲ್ರಿ ಆಫೀಸ್ದಾಗ ನೀವು ಕಾಪಿ ಕೊಡ್ಲಿಕ್ಕೂ ನೀವು ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಬರುತ್ತೆ. And you are seeking anticipatory bail.
Sir,
It discloses the urgency on your part.
sir, sorry, my lord. Respondent number 1 already copy served, sir. Respondent number 2 is victim girl, sir.
ಮುಂದೆ ಅವ್ರ ಕಾಪಿ ಕೊಡೋದು ಬೇಡವಾ?
So,
PF ಕೊಡೋದು ಬೇಡವಾ?
sir,
ಪಾರ್ಟಿ ಮಾಡ್ತೀರಿ, ಅವ್ರ PF ಕೊಡಲ್ಲ, ಕಾಪಿ ಕೊಡಲ್ಲ, 1 ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳಿಬಿಟ್ರೆ ಮುಗಿದು ಹೋಯ್ತಾ?
sorry, sir, my lord. ಇವತ್ತೇ ಕೊಡ್ತೇವೆ sir. ಇವತ್ತೇ steps ತಗೋತೇವೆ, please.
Learner Council for petition submit that in course of the day will be done. Office to verify and issue notice to R2. After 2 weeks.
After 23, my lord, please.
2 weeks.
Okay.
Bill number 1, Vishal.
Or issued the copy.
Yes, yes, I received the objection. And it had that verifying affidavit also.
Learned counsel for petitioner submit that has received the copy. Who is representing Dharwad Kalburgi bench matter? ನಿಮ್ ಕಲಿಗನ್ ಕೇಳ್ಕೊಡ್ರಿ ಇಲ್ಲಾಂದ್ರೆ ಅಬ್ಸೆನ್ಸ್ ಒಳಗ ನಾನು ಅಲ್ಲಿ ಹಿಯರ್ ಹಿಮ್ ಕೇಳ್ಕೊಡ್ರಿ ಅದೇ ಯಾಕಂದ್ರೆ ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಬಾಳ ಇಲ್ಲ.
ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ರಿವ್ಯೂ ಮಾಡೋದು ಜೀವನ ಮಾಡು ಈಗಿರುವಲ್ಲಿ ನಮ್ಮ ಸಂಬಂಧಿಕನಾದ ಈಶ್ವರಪ್ಪ ಅದೇ ಸೇವಂಶ ಈ ಚೌಡಪ್ಪ ಎಂಬುದು ನಮ್ಮ ಮನೆಗೆ ಹೆಚ್ಚಾಗಿ ಬರುತ್ತಿದ್ದು ಈಗಲೂ ಬರುತ್ತದಂತ ಹೀಗೆ ಒಂದು ತಿಂಗಳಿಂದ ಈ ವಿಚಾರ ತಿಳಿದು ಇದನ್ನು ಮನಸ್ಸಿನಿಟ್ಟುಕೊಂಡು ಏನಾದರೂ ಮಾಡುವುದರಿಂದ ಈಶ್ವರಪ್ಪನು ಈ ದಿನ 7:20 ಬೆಳಗಿನ ಜಾವ 3 ಗಂಟೆಗೆ ನನ್ನ ಗಂಡ ನಾವು ಬೆಳೆದಿದ್ದ ಮೆಣಸಿನಕಾಯಿಯನ್ನು ಚಿಂತಾಮಣಿ ಮಾರುಕಟ್ಟೆಗೆ ತೆಗೆದುಕೊಂಡು ಹೋಗಲು ತಲೆಯ ಮೇಲೆ ಹುಸಿಯನ್ನು ಇಟ್ಟುಕೊಂಡು ಬಂಡಾವರಿ ಕಾಸು ಹೋಗುವುದು. ಹೋದ ನಂತರ 15 ನಿಮಿಷ ನನ್ನ ಗಂಡ ರಟ್ಟೆಗಳಲ್ಲಿ ಈಗ ಬಂದನು. ವಿಚಾರ ಮಾಡಲಾಗಿ ಈಶ್ವರಪ್ಪ ಚೌಡಪ್ಪ 7 ದೊಡ್ಡ ಚೌಡಪ್ಪ ಬೆಂಟು ನಡೆದುಕೊಂಡು ನಾನು ಮೇಲ್ಕೊಂಡು ಈಶ್ವರಪ್ಪ ಈಶ್ವರಪ್ಪನವರು ನಿಮ್ಮ ಕಡೆ The bed was registered 130/22, 341, 324, these persons not assaulted also the complaints stated A1 to take action against the A1. According to the information this individual examined. We are in judicial custody. ಕೇಸ್ ಎರಡು ಮೂರು ದಿವಸಕ್ಕೆ ಎರಡೇ ದಿವಸಕ್ಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿ ಅವ್ರು ರಿಕವರಿ
ಮತ್ತೆ ಅವನ ಜೊತೆ ಯಾಕೆ ಹೋಗಿದ್ರಿ? ಅವನ ಜೊತೆ ನೀ ಯಾಕೆ ಹೋಗಿದ್ರಿ?
ಒಂದೇ ಫ್ಯಾಮಿಲಿ ಅವರು
ಈಗ್ಲಿ ಬಿಡಿ, ನೀ ಯಾಕೆ ಹೋದ್ರಿ ಅವನ ಜೊತೆ? ಬೆಳಗ್ಗೆ ಮುಂಜಾನೆ ಅವನೇನೋ ತನ್ನ ಪತ್ರಕ್ಕೆ ನಿಮ್ಮ ಹೆಸರು ಅಲ್ಲ, ನೀವು ಹೋಗಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಹೆಸರು ಹೇಳ್ಬೇಕಂದ್ರೆ ನೀವಿದ್ರಿ ಅಂತ ಎಷ್ಟು ಹೇಳ್ಯಾನೆ. ಅದರ್ವೈಸ್ if he wants to falsely implicate you, he would have attributed some overtract against you.
Custody since from the arrest. Now A1 was also ಅವ್ರಿಗೂ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ information ಬಂತು. All these matters.
Yes, ಏನ್ ಹೇಳ್ತೀರಿ?
Taking it as all these allegations only against A1. We are suffered like anything. 3:30 ಗಂಟೆನಲ್ಲಿ ಅಂತಾರೆ ಬೆಳಗಿನ ಜಾವ. ಮತ್ತೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿ ಮೇಲೆ 3 ಗಂಟೆ ಸಂಬಂಧ ಇಲ್ಲ. A1ಗೆ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂದಿದೆ.
A1 ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನಿಮ್ಗೆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬಂತಂದ್ರೆ ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಯು ಟು ಆಸ್ ಪರ್ ಯುವರ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಆಸ್ ಇಟ್ ಸೇಡ್. ಅಲ್ಲಿ ಹೋಗಿ ಮತ್ತೆ ನನ್ಗೆ ಇಲ್ಲೇ ಯಾಕೆ ಹೇಳ್ತೀರ ಅದನ್ನ?
ಇಲ್ಲಿ ಅಡ್ರೆಸ್ ಏನು ಆಗುತ್ತೆ 439 from 438 because any stringent conditions
enlarging the bail in Betterhully case crime number 130 of 2022, registered for the offences punishment of 351, 324, 307, 504 and 506 read with section 34 of the IPC. The factual matrix, the prosecution, the third learned counsel for petitioner and learned HEGP for respondent state. There is the reports. The very facts leading to the case are that the complainant is the wife of the injured Venkatramana, and she was residing along with her husband and the 2 children. It is alleged that accused number 1 regularly used to visit her house, and as such, her husband suspected and quarreled with accused number 1 and asked him not to visit his house. It is further alleged that subsequently the petition from the accused number 1 used to declare that he is going to cause the death of her husband, and as such, the complainant has stopped entertaining the accused number 1. It is further alleged that on 7/10/22 at about 3 AM, her husband left the house in order to go to market for sale of captain grown in his land, and when he went to Kondavari cross, he returned within 15 minutes with head injury on his head. On inquiry, he reported that all the petitioners blocked his way, all the accused, that the present petitioner and other two accused blocked his way. And the accused number one threw pepper powder in his eye and gave a blow on his head by a chopper. It is further alleged that when Srinivas, Reddappa and Rajanna rushed to the spot, they fled away, and then the injured was shifted to the hospital and then to Nuhans. As a subsequently, the complainant has lodged a complaint. The petitioners are apprehended and they have approached the learned session judge seeking regular bail, and the learned session judge has rejected the bail petition. Hence, the petitioners are before this court. Having heard the arguments and perusing the records, it is evident that the alleged incident has said to have taken place on 7/10/22 in the morning at about 3 a.m. The allegations of the complaint disclose that it is that the accused number one used to visit his house regularly, and as such, her husband suspecting something, he quarreled with him and asked not to visit his house. It is alleged that with this vengeance, the accused number one, along with present petitioner and another accused number 4, on 7/10/22 at 3 a.m., when the petitioner was proceeding to Kondavari cross, the victim was proceeding to Kondavari cross. They wrongfully restrained him, and by putting chili powder in his eyes, the accused number one assaulted him with a chopper. The complaint allegations disclose that the main allegations of assault were directed against accused number one, and though it is asserted that the present petitioners were present at the spot, no role was attributed to them by the injured. The learned HCGP has also contended that the injured has suffered grievous injury on the head, as the injury was exposed till the brain. But however, that allegation was directed as against accused number one, and no allegation have been made regarding assault as against the present petitioner. They are in custody, and their custodial interrogation is also not warranted as per the investigating agency. No purpose would be served by keeping them in custody. Under these circumstances, I do not find any impediment for admitting the petitioners on bail, considering absence of any specific vote act attributed to them. The other apprehensions raised by the learned HCGP can be meted out by imposing certain conditions. Hence, petition needs to be allowed, and accordingly proceed to pass 1 lakh with 1 surety. Attendance, I think.
CH-27.
Creation against petitioner. Say it to terminate prisoner kidnapped the victim. I can't drink my papa and there they committed natural sex. Victim. Earlier, my initial place of offense. Offense. Total say like ladies road in your Ringu Tani was a really good around and are also taken the Arabic ಸ್ಪೂನನ್ನು ಅದನ್ನ ಮೇಲೆ ಅಲ್ಲೇ ಮಾಡಿ ಹಣ ಪ್ಲಾನ್ ಮಾಡಿದ್ದೇನೆ ಅಂತ ತಿಳಿಸಿ ಇವರ ಹೇಳಿಕೆಯಿಂದ ಮುಂದುವರೆದ ಅಪನ್ನ ಕೊಡೋದು ವ್ಯಕ್ತಿ ಮೊಳಿಗೆ ಮುಂಭಾಗದ ಮಾಡಿ ಹೇಳಿಕೆ ಅಲ್ಲಿಗೆ ಈ petitioner forcibly taken into the place and where forcibly they have been natural. This case may not be complaint petitioner himself went to the petitioner. Where as per the statement of the then petitioner voluntary statement. Our hospitality they have committed the offense. Later he escaped from the place. One of his friend had information. He was given 20,000. The victim himself came out from the place of and he was not large any complaint. One of his colleague was large. He was kidnapped. In this case, he was not because he was victim himself went to the petitioner. They had was not taken in any possible in any place. He went after midnight, midnight, he went, he find the petitioner, and they but escape from the this unlawful he one of his friend mistake, he was his phone was switched off. He himself came back. In the meantime, the complaint has been raised. As per his statement, the respondent police draw the mother, take a decision. Himself admitted. He committed the offense against the petitioner. But as per the statement of the petitioner, he possibly demanded 20,000. He escaped from the place. Later, investigation must as per the statement as per the complaint. First complaint. He sees judicial custody mirror 6. Then he had 20, nearly 60 days. There is no previous just after the petition. He has to report from
ಇದ್ರೊಳಗೂ ರಿಕವರಿ ಬೇಕಾ ನಿಮಗೆ? ಏನ್ ಸರ್ ಇದ್ರೊಳಗೂ ರಿಕವರಿನ ಏನ್ ಹೇಳ್ತೀರಿ? But the confusion, yeah, what is it states? When he escaped, ಯಾವಾಗ ಅಲ್ಲಿಂದ ತಪ್ಪಿಸ್ಕೊಂಡ? When he escaped from the room, he has not lodged any complaint. And while committing the sex, he was in a dominating position, but he did not make any attempts to escape from the spot. When he was there, he was enjoying. The petitioner has filed the petition. Only one accused. Petitioner has filed his petition in section 439 of CRPC for enlarging him on bail in Sudiguntepalle police station, crime number 222 of 22, registered for the offence punishable under section 364A. You are not in, what is the charge sheet is filed? Under which provisions? Three 42. There is a specific allegations regarding 377 incorporation illa. It is case of 377 according to the prosecution. After his statement is recorded, 377 barbekagittu, 377 illa. FIR is lodged on section 364A. That is also missing. Then 342 ಒಳಗಿದ್ರೆ ಏನ್ ಕಸ್ಟಡಿ ವಿಟ್ ಮಾಡೋರ್ದಿರಿ ನೀವು? Wrongful confinement, assault and 506, threatening. Even if he is consented, what 377 says? A unnatural sex. A carnal sex.
The petitioner has filed this petition in section 439 for enlarging human being
Sons of Police Station, crime number 220 registered for the offense 364
64 petition. Third, the learned counsel or petitioner and learned HCGP for state the records. It is the case of the prosecution that one suggested be a licensing officer of GR Infra Projects filed a complaint alleging that on 6/8/2022, a worker working under at Swagat Junction hypermarket, and from midnight 2 a.m. he was found missing. At about 10:30 a.m., somebody called the phone of Dhirendra Kumar, who is friend of Sachin Kumar, informed that Sachin Kumar is kidnapped and demanded a ransom of 20,000. The said fact was reported by Dhirendra Kumar to his friend Bhavan Kumar, and in turn, the same was informed to complainant. As such, he lodged the complaint. On the basis of the complaint, FIR came to be issued, and the investigating officer able to search the victim of the abduction by name Sachin Kumar, and on inquiry, it is revealed that on 7/8/22 in the midnight at about 2:25 a.m., when he came to Paramount Granimore Complex granite shop situated in Maiko layout, Adugadi, the petitioner, by noticing him, taken him in a car to his house situated near church in Mallasandra and asked him to have a unnatural sex with him. Thereafter, it is also alleged that he has demanded ransom, but however he escaped. In this regard, the complaint came to be lodged. The petitioner has approached the learned session judge, and the petitioner was apprehended and was remanded to judicial custody. Then he approached the learned session judge seeking regular bail, and learned session judge has rejected his bail petition. Hence, the petitioner is before this court. Having heard the argument and perusing the reports, it is evident that there were initial allegations regarding kidnapping for a ransom. However, the statement of the victim speaks a different story regarding unnatural sex. Further, the statement of the victim also disclosed that he has voluntarily accompanied, and as such, the allegations regarding kidnap also does not survive. The investigating officer, it is submitted by the learned HCGP that the final charge sheet has been laid down for the offences commission on section 342, 323, and 506 IPC alone. These offences are exclusively triable by the learned magistrate regarding illegal confinement, causing simple injury, and threatening. None of these offences are punishable with a death or life imprisonment, and as submitted by the learned HCGP, the offences, the investigation is completed and charge sheet is already laid down. The petitioner is in custody and his presence is no more required by the investigating agency. Under these circumstances, I do not find any impediment for admitting the petitioner on bail. Hence, the petition needs to be allowed according to USIR with one surety, normal conditions.
Parents of the victim. How affect the parents of petitioner to send the court.
What has transpired to recollect? They were present. She was hardly very small child. She was even physically very weak. What about?
Initially, the parents are, they were offering.
No, and your victim, what is the opinion of your parents?
She attended.
Subsequently, if they are not married, if they give a go by to their promise,
I'll call them.
ಅಲ್ಲಮ್ಮ ನೀವು ಡಿಸ್ಕಷನ್ ಮಾಡಿ ಇವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಇವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಇವ್ರು ಕೂಡ ಡಿಸ್ಕಷನ್ ನೀವು ಡಿಸ್ಕಷನ್ ಮಾಡಿ ಕಾನ್ಸಿಕ್ವೆನ್ಸಸ್ ವಿಲ್ ಬಿ ವೆರಿ ಸೀರಿಯಸ್. 10 ನಿಮಿಷ ಬಿಟ್ಕೊಳ್ಳೋಣ.
70 E. Ravishankar.
Still, how many months you require to produce the judgments, or you want to wait till a judgment is pronounced? ನಾನು ನಿಮ್ಗೆ ಕೇಳಿದ್ರೆ ಆಯ್ತು, ಒಂದು ಜಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೀನಿ, ರಿಸರ್ಚ್ ಮಾಡ್ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ. You are unable to produce the citations. Now you are waiting for a citation to be delivered. The deceased was the rider of the motorcycle. The motorcycle belongs to his mother. He steps into the shoes of the mother as a RC owner. Can he maintain a petition under 163A? This is the simple issue. Correct? There is a direct citation of the apex court. So overriding the Supreme Court addition. ಕೊಡಿ ನೋಡೋಣ ನಿಮ್ದು ಏನೇನದ ನೋಡ್ರಿ ನೋಡೋಣ. What are the few more judgments? You are relying on a decision of a coordinate bench decision of this court. Correct? A coordinate bench decision of this court. Correct? But that decision of the coordinate bench is in against the apex mandate of the apex court. Then what is the law of precedence? What is the law of precedence? What is the law of precedence? Which decision will prevail? Then Supreme Court decision is there also. Okay, fine. Whether the earlier bench decision of the Supreme Court is overruled by this bench or discussed or distinguished. If two co-equal benches give a same verdict, which decision will prevail? First decision will prevail. It is also as per the decision of the full court decision of the apex court in Ratiram case. And even the second decision, even if it is given in ignorance of the first decision, it is hit by the principles of per incuria. Then I'm asking you, the earlier Supreme Court decision lays a law, and subsequent apex court decision, without considering, without placing reliance on it, when it was not brought to the subsequent bench regarding earlier bench decision, what is the fate of the subsequent decision? When the first decision of the apex court was not brought to the notice of the apex court while delivering the subsequent decision, what is the law? It can rely, if it is placed, it can rely, it can distinguish. Things are entirely different. If it distinguishes, taking into consideration the principles enunciated and distinguishes whether it is applicable to facts, fine. But the earlier decision of the apex court is not at all brought to the notice of the apex court while delivering the subsequent decision. What will be the concept of the law? That is exactly covered by Ratiram 2012 SEC. That is a full court, full bench decision of the apex court, wherein it is held that if the subsequent decision is in ignorance of the earlier bench decision, it attracts the principles of per incuria. Then which decision will prevail? ಯಾವ ಡಿಸಿಷನ್ ಪ್ರಿವೇಲ್ ಆಗುತ್ತೆ ನಿಮ್ ಪ್ರಕಾರ ಹೇಳಿ ನೋಡೋಣ. ಈ ನೀವೆಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ರಿಸರ್ಚ್ ಮಾಡ್ಬೇಕು, ಕಷ್ಟ ಪಡ್ಬೇಕು. ಸೀನಿಯರ್ ಹೇಳಿದ್ರು ಸೀನಿಯರ್ ಇದನ್ನ ಕೊಟ್ರು ಅಷ್ಟೇ ಅಲ್ಲ, ಸೀನಿಯರ್ ಇದನ್ನ ಎದಕ್ ಕೊಟ್ರು, ಈ ಕೇಸ್ ಇದು ಅಪ್ಲೈ ಆಗತ್ತಾ ಇಲ್ಲ, ಕೋರ್ಟ್ನವ್ರು ಏನ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ವೆದರ್ ದಿಸ್ ಡಿಸಿಷನ್ ವಿಲ್ ಆನ್ಸರ್ ದಿ ರಿಕ್ವೈರೀಸ್ ರೇಸ್ಡ್ ಬೈ ದಿ ಕೋರ್ಟ್ ಆರ್ ನಾಟ್, ಇವೆಲ್ಲ ವಿಚಾರ ಮಾಡ್ಬೇಕು ಬೇಡ. ಮತ್ತೆ ಇನ್ನ ರಿಸರ್ಚ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ, ಇನ್ನ ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಗೆ ರಿಸರ್ಚ್ ಹೇಳಿ? ಹೇಳಿ, ನಂದೇನ್ ತಕರಾರಲ್ಲ, ಇನ್ನ ಎಷ್ಟು ದಿನ ಬೇಕು ನಿಮ್ಗೆ ರಿಸರ್ಚ್ಗೆ? ಹಾ, provided you argue the matter. If there is any shortcomings, your senior can subsequently fill in those lacunas, answer those queries. But initial argument should be by you only. ನೀವು ನಮ್ ಕೋರ್ಟ್ ನಿಂದ ಇಲ್ಲ, ಕೋರ್ಟ್ ಸಹವಾಸನೇ ಬೇಡ, ಸೀನಿಯರ್ ನೀವು ಉಂಟು, ನೀ ಈ ಕೇಸ್ ಉಂಟು ಅಂತ ಹೇಳಿದ್ರೆ ಅಂದ್ರೆ ಮುಂದೆ ನಮ್ ಕೋರ್ಟ್ ಒಳಗೆ ನಿಮ್ನ ಎಂಟರ್ಟೈನ್ ಮಾಡಲ್ಲ ನಾವು. ದಟ್ ಈಸ್ ಕಂಡೀಷನ್ ಪ್ರೆಸಿಡೆಂಟ್. as per request of the Government Council for petitioner, please the matter next week. ನೀವು ಹೇಳಿದ ಡೇಟ್ ಚೂಸ್ ಯುವರ್ ಡೇಟ್ ಆಸ್ ಪರ್ ಯುವರ್ ಕನ್ವೀನಿಯನ್ಸ್. ಕ್ಯಾಲೆಂಡರ್ ಅಲ್ಲಿ ಇದೆ, ನೀವು ಬಟ್ ಮಾಡಿದ ಡೇಟ್ ಕೊಡ್ತಾ ಇದ್ದೀನಿ. ನೀವು ಫಿಕ್ಸ್ ಡೇಟ್ ಅಂತೀರಿ, ಮತ್ತೆ ಎನಿ ಡೇಟ್ ಅಂತೀರಿ. ನೀವು ಅಲ್ಲಿ ಯಾವ ಡೇಟ್ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡ್ತೀರಿ ಅದೇ ಡೇಟ್ ಅವ್ರು ಯಾವ ಡೇಟ್ ಹಾಕ್ತಾರ ಹಾಕೊಡ್ತೀರಿ ಹೇಳಿ. ಆಯ್ತು 16th ಆಯ್ತಾ. ಎರಡು ಕೇಸ್ ಒಳಗೆ ಹಾಕಿದಿರಿ, ಆ ಕೇಸ್ ಒಳಗೆ ಹಾಕಿದಿರಾ? 45 ಒಳಗೆ ಹಾಕಿದಿರಿ. 42 ಒಳಗೆ see Sunil S. Narayan has filed power for respondent number 2. ಇದ್ರೊಳಗೆ ಏನಾರ objection ಹಾಕೋತಿದ್ದೇನಾ ನಿಮಗೆ? And he seeks some time to file objection statement. End ಹಾಕ್ತೀರಿ because already you have drafted one objection in ಅದನ್ನ ಅವ್ರು ಹೇಳ್ಬೇಕು. ನಾ ಐ ಕ್ಯಾನಾಟ್ ಕಂಪೆಲ್ ಹಿಮ್ ಯು ಅಡಾಪ್ಟ್ ಅಂತ ಹೇಳಿ. ಇಟ್ ಈಸ್ ತಪ್ಪಾಗಲ್ವಾ? ನೀವು ಅದನ್ನ ಯಾಕೆ ಅಡಾಪ್ಟ್ ಮಾಡೋಲ್ಲ, ಅದನ್ನ ಅಡಾಪ್ಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ ತಪ್ಪಾಗುತ್ತೆ. ಬಿಕಾಸ್ ದಿ ಅಲಿಗೇಷನ್ಸ್ ವಾಟ್ ಇಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಲಿಗೇಷನ್ಸ್ ಒಬ್ಬರ ವಿರುದ್ಧ ಇವರು ಏನಿದೆ ವಿ ಡು ನಾಟ್ ನೋ. 15th ಮಂಗಳವಾರ ಕೊಡ್ತೀನಿ. ಕರೆಕ್ಟ್ ಸರ್, ನಾನು ಅದು ನೋಡೋಕ್ಕಿಂತ ಮುಂಚೆ ಅವ್ರಿಗೆ ಅಪಾರ್ಚುನಿಟಿ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ತಪ್ಪಾಗತ್ತೆ. ಮಂಗಳವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ, ಶಾರ್ಟ್ ಡೇಟ್, ಲಾಂಗರ್ ಡೇಟ್ ಏನು ಕೊಟ್ಟಿಲ್ಲ. Tuesday and he placed time for filing objection. Release the matter on Tuesday. 45 no Tuesday. ಸರ್ ನಿಂದ ಡಿಸ್ಪೋಸ್ ನಾನು ಮಾಡಿದ್ನಿ ಅಂದ್ರೆ ಆ ಕೇಸಿಗೆ ಇಫೆಕ್ಟ್ ಆಗುತ್ತೆ. ಅದನ್ನು ಮಂಗಳವಾರ ಇಟ್ಟಿದ್ದೀನಿ. ಏನೇನು ಈ ಮಂಗಳವಾರ ಫೈನಲಿ ಇಟ್ಟಿದ್ದೀನಿ ಫಾರ್ ಹಿಯರಿಂಗ್. Even if he doesn't file objection in that matter, I'm going to hear this matter.
If the chances are there, suppose in future, for 1 year or 2 years, chances are there for a security matter discuss. One matter will affect the
100%, sir. ಈಗ now the moment he has gone in custody, Allah, the moment he has gone in custody, there is certain difference of opinion are bound to occur. The revenge and other things will go into, but we will try to conceal it.
Restitution of natural rights petition filed by the accused in the court. It is pending. This petition, mediation is also going on. Police has come over.
ಮಂಗಳವಾರ ಇಟ್ಟಿದ್ದೀನಿ, ಟ್ಯೂಸ್ಡೇ ಓನ್ಲಿ. ಆಯ್ತು, ಮಂಡೇ ಬೇಡ, ಮಂಡೇ ರೀಚ್ ಆಗಲ್ಲ, ಅದಕ್ಕೆ ಮಂಗಳವಾರ ಇಟ್ಟಿದ್ದೀನಿ, ಟ್ಯೂಸ್ಡೇ.
Parties only making submission.
I have not given. I have given only 2 days.
Only my submission is at the interest of.
I can understand. I can understand it because the relations of husband and wife is very important issue that cannot be. It is not better. It is better not to hear. We will hear it on merits only. Yes. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಅವ್ರಿಗೆ?
For this petition that 448, accused number 2, 4 and 6. And the offences alleged are 363, 276, 114, 116, 34 and POCSO 4 and 6. But the complaint is available at page 14. Right copies at page 14. Complainant is the mother of the Swami. ಈ ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ಕಾಯಂ ನಿವಾಸಿಯಾದ ನಾನು ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳೋದಂದ್ರೆ ನನಗೆ 3 ಜನ ಮಕ್ಕಳಿದ್ದು. ಅದರಲ್ಲಿ 1ನೇ ಮಗಳಾದ ಸ್ವಾಮಿ ಸರ್ಕಾರಿ ಕಾಲೇಜಿನಲ್ಲಿ ಪ್ರಥಮ PUC ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿದ್ದ. ಪ್ರತಿದಿನ ಕಾಲೇಜಿನ ಓದಿ ಬರುತ್ತಿದ್ದ. ದಿನಾಂಕ 17/8/2022 ಮಧ್ಯಾಹ್ನ 12 ಗಂಟೆಗೆ ಕೋಳಿಗಳನ್ನು ಮೇಯಿಸಲು ನಮ್ಮ ಜಮೀನಿನ ಹತ್ತಿರದ ಹೋದಾಗ ಸದರಿ ಗ್ರಾಮದ ಭದ್ರಪ್ಪ ಸಣ್ಣ ಕುಂಟಯ್ಯ ಹಂಪಳ ಇವರು ನನ್ನ ಮಗಳನ್ನು ಬಲವಂತವಾಗಿ ಕಿಡ್ನಾಪ್ ಮಾಡಿ ನಂತರ ಅಲ್ಲಿಯೇ ಆಕೆಯ ಕೈಗಳನ್ನು ಬಿಗಿಯಾಗಿ ಹಿಡಿದುಕೊಂಡು ಮತ್ತು ಬಾಯಿಯನ್ನು ಮುಚ್ಚಿ ಎತ್ತಿಕೊಂಡು ಹೋಗಿ ನನ್ನ ಮಗಳನ್ನು ಎಷ್ಟೇ ಕಿರುಚಾಡಿದರೂ ಸಹ ಬಿಡದೆ DK ರಾಜಪ್ಪನ ಜಮೀನಿನ ಹತ್ತಿರ ಹೋಗಿ ಸದರಿ ಜಮೀನಿನ ಅವಳ ಮೇಲೆ ಬಲಾತ್ಕಾರದಿಂದ ಲೈಂಗಿಕ ಸಂಭೋಗ ಮಾಡಿರುತ್ತಾನೆ ಮತ್ತು ನೀನು ಈ ವಿಷಯವನ್ನು ಬೇರೆ ಯಾರಿಗಾದರೂ ಹೇಳಿದರೆ ಜೀವಂತವಾಗಿ ಸಾಯಿಸಿಬಿಡುತ್ತೀನಿ ಎಂದು ಕೊಲೆ ಬೆದರಿಕೆ ಹಾಕಿರ್ತಾನೆ. ನಂತರ ನನ್ನ ಮಗಳು ಮನೆಗೆ ನಾನು ಹೋಗಬೇಕೆಂದು ಕಿರುಚಾಡಿದರೂ ಸಹ ಅವನು ನನ್ನ ಮಗಳನ್ನು ಬಿಡದೆ ಮತ್ತು ಮತ್ತೆ ಲೈಂಗಿಕ ಸಂಭೋಗ ಮಾಡಲು ಯತ್ನಿಸಿರುತ್ತಾನೆ. ಜಮೀನಲ್ಲಿರುವ ರಾತ್ರಿ ಕತ್ತಲೆಯ ದೂರ ನಂತರ ಎದುರುಕೊಂಡು ನನ್ನ ಮಗಳು ಅಲ್ಲೇ ಕಾಲನ್ನು ಕಳೆದಿದ್ದಾಳೆ. ನಾವುಗಳು ಎಲ್ಲಾ ಕಡೆ ಹುಡುಕಿದಾಗ ಈ ದಿನ 12 ಗಂಟೆ ಜಮೀನಿನ ಹತ್ತಿರ ಇರುವುದು ಗೊತ್ತಾಗಿರುತ್ತದೆ. ಆಗ ನಾನು ಈ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ನನ್ನ ಮಗಳಿಗೆ ಆಗಿರುವ ವಿಚಾರವನ್ನು ತಿಳಿದುಕೊಂಡು ಫಿರ್ಯಾದಿಯನ್ನು ನೀಡುತ್ತೇನೆ. ಮೇಲ್ಕಂಡ ಆರೋಪಿತನಿಗೆ 1 ಶಶಿಕುಮಾರ್, ಸಣ್ಣ ನಂಜಪ್ಪ, 2 ಸುಂದಯ್ಯ, 3 ಪ್ರಸನ್ನ, 4 ಸುನೀಲ್ ಇವರುಗಳು ಸಹ ನನ್ನ ಮಗಳ ಮೇಲೆ ಬಲಾತ್ಕಾರ ಮಾಡಲು ಸಹಕರಿಸುತ್ತಾರೆ. ಈ ರೀತಿ ಮಾಡಲು ಮೇಲ್ಕಂಡ ಆರೋಪಿತರು ಹಿಮ್ಮತ್ತನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಇವರುಗಳ ಸಹಕಾರದಿಂದ ನನ್ನ ಮಗಳಿಗೆ ಬಲವಂತವಾಗಿ ಎತ್ತಿಕೊಂಡು ಹೋಗಿ ಜೀವ ಬೆದರಿಕೆ ಹಾಕಿ ಬಲವಂತವಾಗಿ ಲೈಂಗಿಕ ಸಂಭೋಗ ಮಾಡಿರುವುದು ಆರೋಪಿತನ ವಿರುದ್ಧ ಮತ್ತು ಸಹಕರಿಸಿದ ಹಿನ್ನೆಲೆ ಆರೋಪಿತರ ಸಚಿವನ ಸಂಘಟನೆಗಳು ಆಗಿರುವುದರಿಂದ ಗ್ರಾಮಸ್ಥರಿಗೆ ತಡವಾಗಿ ಬಂದು ಕಾನೂನು ಕ್ರಮ. The investigation has been completed and the action has been filed. But I would like to read the statement of the victim recorded in terms of section 164. But that statement is available at page number 31 of the volume that I have just handed over. Page 3131. ದಿನಾಂಕ 17/8/2022 ಬೆಳಗ್ಗೆ 11:30 ಸಮಯದಲ್ಲಿ ನಾನು ಗುರಿ ಹೊಡೆದುಕೊಂಡು ಹೊರಕ್ಕೆ ಹೋಗಿ ಬರುತ್ತಿದ್ದಾಗ ಭದ್ರಪ್ಪ ಹಿಂದಿನ ಬಂದು ನನ್ನ ಬಾಯಿ ಹಾಗೂ ಮೂಗಿ ಮುಚ್ಚಿ ನಾನು ಎಚ್ಚರ ತಪ್ಪುವ ಹಾಗೆ ಮಾಡಿ ಹೊಲಕ್ಕೆ ಹೊರದುಕೊಂಡು ಹೋದರು. ನಂತರ ನನಗೆ ನೀರು ಹಾಕಿದಾಗ ಎಚ್ಚರ ಬಂದು ನನಗೆ ಇಲ್ಲಿ ಯಾಕೆ ಕರೆದುಕೊಂಡು ಬಂದಿದ್ದೀರಾ ಎಂದು ಕೇಳಿದಾಗ ಸುಮ್ಮನೆ ಎಂದು ಹೇಳಿದರು. ನನಗೆ ನನ್ನ ಅಪ್ಪ ಅಮ್ಮನ ಹತ್ತಿರ ಹೋಗ್ತೀನಿ ಅಂತ ಕೇಳಿದಾಗ ಹೋಗೋಕ್ಕೆ ಬಿಡಲಿಲ್ಲ. ನಾನು ತಪ್ಪಿಸಿಕೊಳ್ಳಲು ಪ್ರಯತ್ನಿಸಿದಾಗ ನಿನಗೆ ಸಾಯಿಸಿಬಿಡುತ್ತೇನೆ ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿದರು. ನನ್ನ ಅಪ್ಪಾಜಿ ಫೋನ್ ಆದರೂ ಮಾಡುತ್ತೇನೆ ಅಂತ ಕೇಳಿದರೆ ಫೋನ್ ಕೂಡ ಕೊಡಲಿಲ್ಲ. ಭದ್ರಪ್ಪ ನನಗೆ 4 ಬಾರಿ ಬಲವಂತವಾಗಿ ಸಂಭೋಗ ಮಾಡಿದರು. ಶಶಿ, ಪ್ರಸನ್ನ, ಸುನೀಲ್ ಹಾಗೂ ಪಾಲನ ನಾನು 2 ದಿನ ಮೆಕ್ಕೆ ಜೋಳದ ಹೊಲದಲ್ಲಿದ್ದಾಗ ಊಟ ತಂದು ಕೊಡುತ್ತಿದ್ದರು. 3ನೇ ದಿನ ಬೆಳಿಗ್ಗೆ ಶಶಿ ಮತ್ತು ಪಾಲನ ನನಗೆ ಊಟ ತಂದು ಕೊಟ್ಟು ಅವರು ತಮ್ಮನಾದ ಭದ್ರಪ್ಪನಿಗೆ ಕಳುಹಿಸಿಬಿಟ್ಟರು. ಪಾಲನ ನನ್ನ ಕುತ್ತಿಗೆ ವೇಲ್ನಿಂದ ಜೋರಾಗಿ ಹಿಡಿದುಕೊಂಡು ಶಶಿ ನನ್ನ 2 ಕೈ ಹಿಡಿದುಕೊಂಡು ನನ್ನ ದೊಡ್ಡಪ್ಪನಿಗೆ ಕಾಲ್ ಮಾಡಿದಾಗ ನನಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಹೇಳಿದರು. ನನ್ನ ದೊಡ್ಡಮ್ಮ ಹಾಗೂ ಚಿಕ್ಕಪ್ಪ ನನ್ನ ಕರೆದುಕೊಂಡು ಸರ್ಕಾರಿ ಆಸ್ಪತ್ರೆಗೆ ಹೋದಾಗ ಪೊಲೀಸರು ಸಹ ಆಸ್ಪತ್ರೆಗೆ along with the statement in the 164 points out that the accused number 2, 4 and 5 who are before this number 12 But were not present when the alleged offence in the 376 was committed. The only allegation is that they brought food and gave to her on the next day. That is the only allegation which is. Other than that, my lord, there is nothing else. What the only link to these petitioners, which can probably bring them into this domain, is 114. If you also kindly have a look at 114, but it is necessary that the accused have to be present there. Otherwise, my lord, the difference between 107 and other abetting offences and 114 is that if the abetter is present, then he is deemed to have committed that very offence. But there is absolutely, it's neither the complainant nor the statement recorded at 164 points out the presence of these petitioners when the alleged offence was committed. Whether at the time of enticement, whether it was taking away, or at the time of the offence under section, these people were not there. Only on the next day, they come to the hall and they hand over the food and they go. So therefore, my respect submission not to probably to reduce the.
When she was confined in the jawar crop, ಹೊಲದಲ್ಲಿ, she was confined, she was raped by one accused number one. There is no issue. They used to provide food. They used to provide food, but they did not make any attempt to assist her.
To assist to escape.
Assist to save her, forget about escape.
But this not providing food, my lord, can also be an attempt.
No, that is not. They might have thought of serious consequences in future. And the fact is that you are absconding all along since the date of the offence. Even during charge sheet, you are not made available yourself. You are the brother. You are the brother. Distance relatives. You had everything knowledge. You have no attempt to protect that child.
No, but here my respect sufficient. But here, whether or not the complaint or the statement of the victim, does it make out an offence as against these petitioners?
Definitely, sir. Concealing an offence is also an offence. That way, kidnapping a victim, minor, committing rape by your brother, and providing food, you are not making any favor by providing a food. You want that she should live. Yeah, otherwise it would have been a serious consequences.
Very third day she is rescued. It is not that on
See, third day she rescued. The question is why you are providing food to her.
It's a humanitarian act, I would say not. Without food, without water, not the Chita probably suffered. It's not to, in one way.
Correct, 100% humanitarian act. See, correct, 100% I appreciate your on humanitarian. You have provided food and water to the victim. When she was raped, that humanity was not there.
No, they were not present.
See, they were not present. Then is it not their duty? Why she is confined? Who has asked them to provide her food? Without their knowledge, nothing can happen. How can they provide a food to a stranger? How can they come to know that she was confined in a particular land?
It seems that they were in a relationship. Both of them were in a relationship. But in that background, these people will not have taken food and given. But the question is not whether any ingredient is satisfied or not.
A person who is absconding, who did not cooperate with the investigating agency in such a heinous offense, is not entitled for a discretionary relief. Cooperate, investigation mugud hogida. Charge sheet have adjournment madidira, ನೀವೇ copy charge sheet ಕೊಟ್ಟಿದ್ದೀರಿ. ಇನ್ನೇನ್ cooperation ಮಾಡೋರು ನೀವು?
They have filed the charge sheet, but we can always appeal before the authorities.
That is different. See, that is one aspect. Even that doesn't prevent the investigating agency under 173A. Absolutely no problem, but your conduct.
My respectful suggestion is not, I would urge your lordship to look at this. Not the offence is alleged, Lord. My link to either 363, 376 or the POCSO offences is to 114. For 114, Lord, I should be present when those offences.
Not only your presence, your aid itself is established that you are gone providing food to the victim who was illegally confined. What else is required? See, at this juncture of statement, you are relying on that statement itself discloses. See, simple thing. They are capable of providing a food. Who has directed them to provide a food? How they got information that she was confined in a particular place? Who has informed them and who has directed them to provide food?
No. Once they come to know about some information, not the first thing that from a humanitarian.
Then humanitarian ground, they should have brought it to the notice of the villagers, and with their assistance, they should have made an attempt to rescue that child. Instead of that, they're claiming that on humanitarian ground, they have provided food.
Step one in any humanitarian act is to provide food and water to a person. But the very third day she has been rescued. Lord,
Sir, for 2 days, you provided the food.
Not only 1 day. It is only 1 day. Day 2, they take the food. Day 2, they take the food. And day 3, she is rescued.
ನಾನು 2 ದಿನ ಮೈಕೆಜೋಳದ ಹೊಲದಲ್ಲಿದ್ದಾಗ ಊಟ ತಂದು ಕೊಡುತ್ತಿದ್ದರು. 2 days you provided the food and you don't want to ascertain why she is confined. You don't want to bring it to the notice of any of the villagers. ನೀವೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ನೀವೇ ರಿಲೈ ಮಾಡಿದ್ರಿ.
Perhaps beyond providing food and water, they could have done a little more. They could have reported it to the, not the questions, not whether that itself can make me liable for the offences which are alleged in the charge sheet and the FIR and the charge. I agree that the humanitarian act should have gone beyond what they have done. But for that, can they be charged with offences which in the statute they cannot be? If one were to be the ingredients of this, is the offences, they cannot be linked to that.
We do not know at this juncture unless further investigation is required.
But all of these petitioners would cooperate. But your lordship may put us on terms, we would cooperate. But I do concede that humanitarian acts should have been a little more larger than what they did. But your lordship would see whether the ingredients of 114 have been satisfied or not. If 114 has the bridge of 114 has not been crossed, then we cannot be linked to any other offences at all. Not from that angle, if your lordship would see, not these are all young people, not there is no antecedents, not they would abide by the law, abide by the terms.
The petitioner number 3 is brother, own brother. Petitioner number 3. Petitioner number 3 is Sunil.
He is A4. I will just confirm.
So A5, is A5.
These are not brothers. These are not brothers. These are not. But two of them are pursuing their education. One has just started working. But they would subject themselves to any investigation. They would appear before the IO, before the court. But their liberty may not at this point of time. But cannot be jeopardized.
Their liberty cannot be jeopardized, but the liberty of a victim.
Lord,
you are least interested.
Not considering the fact that Lord, they have made an effort to save the victim. in some way by providing food and water. Not the fact that they could have done a little more, but they have not done, Lord, should not come in the way of your lordships considering, particularly the fact that the 114 ballot cannot be applied. Prima facie ballot, 114.
Sorry, I cannot accept your argument in this regard. 114 cannot be accepted. The presence only is not required. What is the intention, subsequent act, that cannot be ignored. For 2 days, he was raped continuously. Is it a joke? A small kid kidnapped and raped.
But none of these petitioners were aware of it. No, that is the
For 2 days, you go on providing food, but you are unaware of what has happened to that child. Very interesting. Yes, what you have to say?
Illegal omission. We come dispassion to who are the time of omission of anything, whatever facilitate of that, they can facilitate for the statements. That's why the investigation released that the petitioners going in the investigation of these committed the center. The complaint was the NDC. We
are not concerned with the accused number 1. Forget it. Because he is not before the court. We are concerned with the present petitioner.
These petitioners also not used to be the
Yes, anything else?
ಒಂದು ಮೆಕ್ಕೆಜೋಳ ಜಮೀನಲ್ಲಿ ಇರಿಸಿಕೊಂಡು ರೈತ ಸಂಭವ ನಡೆಸುವ ವಿಚಾರ ಕೆಲವು ಸಹ 2, 3, 4, 5 ಊಟ ಇಡೀ ಊಟ ತಿಂಡಿ ಮತ್ತು ನೀರನ್ನು ತೆಗೆದುಕೊಂಡು ಅದಕ್ಕೆ ಒಂದು take evidence of the taking
Yes.
Without a ritual. but the expression "Kummakkininda" is only in the statement which is recorded in the statement recorded under 164 simply all allegations are against A1. The only statement is that they brought the proof. But Lordship would also consider that it's a open place, since it is a open area, and the provisions which were learned from there. But aiding, considering the nature of offense, what aiding would mean where there is some active role played in, say, confining the victim to the body. But here not other than providing in an open field, other than providing food and water, there is nothing else which has been done. So therefore, what would the prosecution be justified in contending that they aided the commission of the offense punishable under 3 CX? In fact, Lord, that the 164 statement also says, ಶಶಿಯನ್ನು ಎರಡೂ ಕೈ ಹಿಡಿದುಕೊಂಡು ನನ್ನ ದೊಡ್ಡಪ್ಪನಿಗೆ ಕಾಲ್ ಮಾಡಿ ನನಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಹೇಳಿದರು. Therefore, what some attempt has been made to report that she should be taken away. So this,
You are absconding, you are not entitled for bail, and make it very clear. Sorry, sir. Looking to the seriousness, a victim child kidnapped, was raped within the knowledge of the other 3 persons. They provided food. Why food is provided? Because she should get some strength. And repeatedly,
that do not be always be positive.
If she is not provided food, he would not have been able to continue the sexual assault.
Considering that one of the petitioners called the Baddappa and requested him to take her away.
He had never called, he asked her to talk.
It says, ಶಶಿ ನನ್ನ ಎರಡೂ ಕೈ ಹಿಡಿದುಕೊಂಡು ನನ್ನ ದೊಡ್ಡಪ್ಪನಿಗೆ ಕಾಲ್ ಮಾಡಿ ನನಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಹೇಳಿದರು. So ಶಶಿ calls ದೊಡ್ಡಪ್ಪ and he says,
ಅವ್ರ ಸಮಕ್ಷಮ ಕಾಲ್ ಮಾಡ್ಬೇಕಾಗಿರ್ಲಿಲ್ಲ ನಾವ. 2 ದಿವಸ ಊಟ ಕೊಡೋಕ್ಕಿಂತ ಮುಂಚೆನೆ ಹೋಗಿ ಹೇಳ್ಬೋದಾಗಿತ್ತು. See, there is something is busy. That is the what how you are putting it. That alone cannot be considered. Totality. ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. Totality absconding throughout the entire investigation. This entitles you to seek anticipatory bail. I do in custody things would have been different. I don't. There were things were attempted. Now, since you are absconding accused, absolutely no mercy.
Even now, it is not that the investigation officer has closed the.
I never said it, but see, you are seeking anticipatory bail. A person who approaches the court to seeking an equity must do equity. Here, equity is lacking on the part of the petitioners.
But here, what they approached the sessions.
That was rejected.
Time got consumed in that, which is why they have not approached.
Now you go and approach the investigating officer by surrendering.
Lordship wanted to know why we have not appeared before the investigating officer. Our application was pending before the court.
Yeah, whatever it may be, sir. That is not a criteria.
It is not that we were trying to shirk away from the appearance before the authority.
Then that is not a ground for you for not appearing. This order was passed on 22nd September.
By
the Sessions Court, and the charge sheet was received on 17/10. That is evident from your records only. The order annexer C disclosed that it was disposed of on 22nd September.
26th we have filed before this.
The charge sheet was filed on 17/10. ಅಲ್ಲಿ ರಿಜೆಕ್ಟ್ ಆದ್ರೂ ನೀವು ಇನ್ನ ಇಲ್ಲಿ ಬಿಟ್ಟು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೂ ಹೋಗ್ತೀರಿ. There is not a criteria, sir.
Sessions court can dispose and within 4 days we have approached this house.
You have approached it, but the IO has waited for nearly 3 weeks. But there was no cooperation because the other accused was in custody. Had he not filed charge sheet, he would have been entitled for statutory bail. There are certain compulsions on IO. No, sir.
Lordship had emphasized the conduct, particularly not appearing before the investigation officer.
Surrender before the court.
The reason was that my application.
Your application go on pending, sir. That is not the criteria. Even if it's pending for 2 to 3 months or 4 months, one person is in custody. If he is unable to file a charge sheet within 90 days, he will be having a benefit of statutory bail. So that will be compel the investigating officer to submit a charge sheet.
Just final conclusion, Lordship had raised 2 issues of conduct. One, not appearing before the IO. For that, my responsibility is that they were prosecuting the petition before.
That cannot be a ground, sir. How can it be ground?
And as far as the facts are concerned, the Lordship would kindly consider that along with while giving the food and water, they also made an attempt to report it to the uncle. But considering that cannot, your Lordship kindly consider the prayer.
Yes, sir. Petitioner. Spell the petition. 438 of CRPC for enlarging them on bail in Jagalur PS crime number 196 of 22 to register. Move regular bail, they will not come in your way. If you move regular bail by surrendering, definitely magistrate is the concerned special court. It doesn't come to magistrate. Straight away the concerned court will be there. Court will take a. What shall I do?
Your Lordship may grant liberty to withdraw this petition and
surrender. Anticipatory bail ನಾನು liberty ಕೊಡುದಿಲ್ಲ.
Surrender and apply for everyone.
Then after arguing the matter for some time, the learned counsel for petitioner submit that he may be permitted to withdraw the petition with a liberty to surrender before the special court and move a regular bail. The submission is placed on record. In view of the submission, the petition is dismissed as withdrawn with a liberty as prayed for. The learned magistrate, the learned special judge is also directed to dispose of the bail petition. Learned special judge is also directed to dispose of the bail petition if it is filed as expeditiously as possible. I cannot fix a date. Dictate ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ ನಾನು. I am supposed to dictate them ತೆಗೆದಿದೆ ಅವನು. ಅದು hearing ಏನಿಲ್ಲ ಅದು. It is a question of law ಇದೆ ಅದು.
Accused number 3 for offense municipal under 323, 324, 307. Complaint is at annexure B, page 13 is up. The right copy is at page 13. ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ತಂದೆ ಮೊಹಮ್ಮದ್ ಸಿದ್ದಿಕ್, ತಾಯಿ ಸಬ್ಜಾ ಬಾನು, ಅಣ್ಣ ಮೊಹಮ್ಮದ್ ಸಮೀರ್, ತಂಗಿ ಆಯೇಷಾ, ತಮ್ಮ ಮೊಹಮ್ಮದ್ ಬಿಲಾಲ್ ರವರಿಗೆ ವಾಸವಾಗಿದ್ದು, ನಮ್ಮ ತಂದೆ ಹಳೆ ಕೆದರೆಯಲ್ಲಿ ಕುದುರೆ ಅಂಗಡಿ ಇಟ್ಟಿದ್ದು, ನಾನು ನಮ್ಮ ತಂದೆ ಜೊತೆ ಸೇರಿ ಕುದುರೆ ಅಂಗಡಿಯಲ್ಲಿ ವ್ಯಾಪಾರ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 5/3/22 ನಮ್ಮ ತಂದೆಗೆ ಹುಷಾರಿಲ್ಲದ ಕಾರಣ ನಾನು ಒಬ್ಬನೇ ಬೆಳಿಗ್ಗೆ 9
ಗುಜರಿ ಅಂಗಡಿಗೆ ಹೋಗಿ ರಾತ್ರಿ 8 ಗಂಟೆವರೆಗೆ ವ್ಯಾಪಾರ ಮಾಡಿ ಅಂಗಡಿ ಮುಚ್ಚಿ ರಾತ್ರಿ 8:30 ಗಂಟೆಗೆ ಸಮಯಕ್ಕೆ ನಮ್ಮ ಮನೆಗೆ ಬಂದು ಮುಖ ಕೈಕಾಲು ತೊಳೆದು ನಮ್ಮ ಮನೆಯ ಹತ್ತಿರದಲ್ಲಿರುವ ಕಾಸಾ ಸ್ಟೋರ್ಗೆ ಹಾಲು ತರಲೆಂದು ಕಾಸಾ ಸ್ಟೋರ್ ಬಳಿ ಬಂದಾಗ ರಾತ್ರಿ ಸುಮಾರು 9:15 ಗಂಟೆ ಆಗಿತ್ತು. ಅಲ್ಲಿ ರಸ್ತೆ ಪಕ್ಕ ನಿಂತಿದ್ದ ಆಟೋ ಬಳಿ ಒಬ್ಬ ಸ್ನೇಹಿತರಾದ ಅಬ್ಬಾಸ್ ನಿಂತಿದ್ದನು. ನಾನು ಆತನನ್ನು ಮಾತನಾಡಿಸಲು ಹೋಗುತ್ತಿದ್ದಂತೆ ಅಲ್ಲಿಗೆ ಏಕಾಏಕಿ ಬಂದು ಪಾರೆಲ್ ಅಲಿಯಾಸ್ ಬಾಂಬೆ, ಮುಸಲಿಫಾ, ಅಪನಾನ್ ಅಲಿಯಾಸ್ ಅಪ್ಪು ದಪೀಸ್ಕಿ ಪೆಟಿಷನರ್ ಎಲ್ಲಿದ್ದಾರಪ್ಪ, ಫೈಜಾನ್, ಫಾಜಿಲ್ ಮತ್ತು ಇತರರು ದೊಣ್ಣೆಯಿಂದ ಮತ್ತು ಕೈಗಳಿಂದ ಹಲ್ಲೆ ಮಾಡುತ್ತಿದ್ದು ನಾನು ಬಿಡಿಸಲೆಂದು ಹೋದಾಗ ಕೈಯಲ್ಲಿ ಮಚ್ಚು ಹಿಡಿದುಕೊಂಡು ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಬಾಂಬೆ ಈತನು ಮಚ್ಚಿನಿಂದ ನನ್ನ ತಲೆಯ ಬಲಭಾಗಕ್ಕೆ ಹಾಗೂ ತಲೆಯ ಹಿಂಭಾಗಕ್ಕೆ ಹೊಡೆದು ರಕ್ತ ಗಾಯವನ್ನು ಉಂಟು ಮಾಡಿರುತ್ತೆ. ನಾನು ಕೆಳಗೆ ಬೀಳುತ್ತಿದ್ದಂತೆ ಮುಸಲಿಫಾ ಈತನು ನಾನು ಹಿಡಿದುಕೊಂಡ ದೊಣ್ಣೆಯಿಂದ ನನ್ನ ಬಲಭಾಗಕ್ಕೆ, ಎಡಗಾಲಿಗೆ ಹಾಗೂ ಫಾಜಿಲ್ ಅವರ ಕೈಗಳಿಂದ ಹಲ್ಲೆ ಮಾಡಿ ಕಾಲಿನಿಂದ ತಳ್ಳಿ ನನ್ನ ಮೇಲೆ ಮಾರಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿರುತ್ತಾರೆ. ಅಷ್ಟರಲ್ಲಿ ನಮ್ಮ ಮನೆಯ ಬಳಿ ವಾಸವಾಗಿರುವ ಸಕ್ವೇನ್ ಎಂಬುವರು ನನ್ನನ್ನು ಗಾಡಿಯಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ಕೈಫ್ ಮಸೀದಿ ಬಳಿ ಕರೆದುಕೊಂಡು ಬಂದು ತಲೆಯಲ್ಲಿ ಗಾಯವಾಗಿದ್ದ ಸ್ಥಳಕ್ಕೆ ನೀರು ಹಾಕಿ ನಂತರ ಅರಿಶಿನ ಪುಡಿ ಹಾಕಿದ್ದನು. ನಂತರ ಹಲ್ಲೆ ಇದ್ದ ನಮ್ಮ ಸಂಬಂಧಿ ಜುಹೇಬ್ ಮತ್ತು ನಮ್ಮ ಚಿಕ್ಕಪ್ಪ ಸುಹೇಲ್ ರವರು ನನ್ನನ್ನು ಅನ್ನಾರ್ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಬಂದು ದಾಖಲಿಸಿದರು. ಈ ಘಟನೆ ನಡೆದಾಗ ರಾತ್ರಿ ಸುಮಾರು 9:30 ಗಂಟೆ ಆಗಿದೆ. ನನ್ನ ಸ್ನೇಹಿತ ಅಬ್ಬಾಸ್, ಮುಸಲಿಫಾ, ಫೈಜಲ್ಗಾಗಿ ಈ 2 ವರ್ಷಗಳ ಹಿಂದೆ ಜಗಳವಾಗಿತ್ತು. ಇಬ್ಬರು ದ್ವೇಷದಿಂದ ಇದ್ದರು. ಈ ಹಿಂದೆ ಗಲಾಟೆ ಆಗಿದ್ದ ವಿಚಾರದಲ್ಲಿ ಹಳೆ ದ್ವೇಷದಿಂದ ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಬಾಂಬೆ ಮತ್ತು ಇತರರು ಅಬ್ಬಾಸ್ ಮೇಲೆ ಹಲ್ಲೆ ಮಾಡುತ್ತಿದ್ದು ನಾನು ಬಿಡಿಸಲು ಹೋದಾಗ ನನ್ನ ಮೇಲೆ ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಬಾಂಬೆ, ಮುಸಲಿಫಾ, ಫೈಜಾನ್ ಹಾಗೂ ಫಾಜಿಲ್ ರವರು ಹಲ್ಲೆ ಮಾಡಿ ನಿನ್ನನ್ನು ಮುಗಿಸಲೇ ಬಿಡುವುದಿಲ್ಲ ಎಂದು ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ. ನನ್ನ ಮೇಲೆ ಮಾರಣಾಂತಿಕ ಹಲ್ಲೆ ಮಾಡಿ ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುವ ಮೇಲ್ಕಂಡ ಆಸಾಮಿಗಳು ಹಾಗೂ ಇತರರ ವಿರುದ್ಧ entire complaint method, the allegation, the assault is made by accused number 1 and 2. There is no allegation against this petitioner, that is accused number 3 is concerned. And the full certificate is produced at annexed E page 33 method. The injured is admitted for hospital on 6/3/22 and discharged on 9/3/22 method. Next, E page 33. Date of admission is 6/3/22. Date of discharge is on 9/3/22. The injuries, table 1 is grievous. Nature. There is no allegation against this accused is concerned. And in further statement my lord of the complainant, and you will permit a further statement about 6/3/22. ಅದರಲ್ಲೂ ಕೂಡ ನಾನು ಮೇಲ್ಕಂಡ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಾಗಿದ್ದುಕೊಂಡು ಗುಜರಿ ಅಂಗಡಿಗೆ ಮಾಡಿಕೊಂಡಿರುತ್ತೇನೆ. ದಿನಾಂಕ 6/3/22 ನನ್ನ ವಿವರವಾದ ಹೇಳಿಕೆಯನ್ನು ನೀಡಿದ್ದು ನನ್ನ ಹೇಳಿಕೆ ದೂರಿನ ಆಧಾರದ ಮೇಲೆ ಉದಯಗಿರಿ ಪೊಲೀಸ್ ಠಾಣೆಯಲ್ಲಿ ಮೊಕದ್ದಮೆ ಸಂಖ್ಯೆ 28-22 ಕಾಲಂ 7 ರೀತಿಯ ಪ್ರಕರಣ ದಾಖಲಾಗಿರುತ್ತದೆ. ನನ್ನ ದೂರಿನಲ್ಲಿ ದಿನಾಂಕ 5/3/22 ರಾತ್ರಿ 9:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಉದಯಗಿರಿ ರಾಜೀವ್ ನಗರ ಗುಪ್ತಾ ಸ್ಟೋರ್ ರಸ್ತೆಯಲ್ಲಿರುವ ಕಾಜಾ ವುಡ್ ಸ್ಟೋರ್ ಮುಂಭಾಗ ನನ್ನ ಸ್ನೇಹಿತ ಹರ್ಬಾಜ್ ಆಟೋ ಬಳಿ ನಿಂತಿದ್ದು ಆತನನ್ನು ನಾನು ಮಾತನಾಡಿಸಲು ಹೋಗುತ್ತಿದ್ದಂತೆ ನಮ್ಮ ಮೊಹಲ್ಲದ ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಫಾಜಿಲ್ ಬೇಗ್, ಮುಸಲಿಫಾ, ಫೈಜಾನ್ ಅಂಡ್ ಮೊಹಮ್ಮದ್ ಫೈಜಾನ್ ಮತ್ತು ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಮೊಹಮ್ಮದ್ ಫಾಜಿಲ್ ಎಂಬುವರು ಮತ್ತು ಇತರರು ಬಂದು ಅರ್ಬಾಜ್ಗೆ ಹಲ್ಲೆ ಮಾಡುತ್ತಿದ್ದಾಗ ಬಿಡಿಸಲು ಹೋದ ನನಗೆ ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಬಾಂಬೆ ಅಲಿಯಾಸ್ ಫಾಜಿಲ್ ಬೇಗ್, ಏನೋ ಮಗನೇ ಅವನಿಗೆ ಸಪೋರ್ಟ್ ಮಾಡುತ್ತಿದ್ದೀಯಾ, ನೀನ್ ಯಾಕೆ ಮಧ್ಯದಲ್ಲಿ ಬರುತ್ತೀಯಾ, ನಾವು ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ವಾ, ನೀನು ಸಪೋರ್ಟ್ ಮಾಡಿದರೆ ನಿನ್ನ ಕೂಡ ಮುಗಿಸುತ್ತೇನೆ ಎಂದು ಹೇಳಿ ಬೈಯುತ್ತಾ ನನ್ನನ್ನು ಕೊಲೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಅವರುಗಳ ಪೈಕಿ ಫಾಜಿಲ್ ಅಲಿಯಾಸ್ ಫಾಜಿಲ್ ಬೇಗ್ ಅಲಿಯಾಸ್ ಬಾಂಬೆ ಮಾಂಸ ಕತ್ತರಿಸುವ ಮಚ್ಚಿನಿಂದ ನನ್ನ ತಲೆಯ ಬಲಭಾಗ ಹಾಗೂ ತಲೆಯ ಹಿಂಭಾಗಕ್ಕೆ ಹೊಡೆದು ಗಾಯ ಉಂಟು ಮಾಡಿದ್ದು ನಾನು ಕೆಳಗಡೆ ಬಿದ್ದು ಹೋದ ನಂತರ ಸ್ವಲ್ಪ ದೊಣ್ಣೆಯಿಂದ ಬಲಭಾಗಕ್ಕೆ ನನ್ನ ಬಲಕೈ ಎಡಗಾಲಿಕೆ ಹೊಡೆದಿದ್ದಲ್ಲದೆ ಅಫ್ಘಾನ್ ಅಲಿಯಾಸ್ ಅಪ್ಪು, ಫೈಜಾನ್ ಹಾಗೂ ಫಾಜಿಲ್ ಮೊಹಮ್ಮದ್ ಫಾಜಿಲ್ ಅವರು ನನಗೆ ಕೈಗಳಿಂದ ಮೈಕೈಗೆ ಹೊಡೆದಲ್ಲದೆ ಕಾಲದಿಂದ ಒದ್ದು ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದರು. The entire incident is made by the accused number 1 and 2, my lord. There is no allegation against this accused is concerned. In the complaint, your mail no allegation is a further statement. Kaigalinda and the complainant has been hospitalized and is discharged within 3 days, my lord. Now the charge sheet has been filed. No need of investigation. Any condition, my lord, the case will be enlarged on the
Charge sheet is filed.
yes, my lord.
You are absconding during the course of entire charge sheet.
No allegation, what sort of things is-
You are, the other two persons were assaulting. One is assaulted him by chopper on his head. He suffered grievous injury on the head. And other person assaulted him by a club. You have assaulted him by hands and kicked him. That is the simple allegation. Okay, fine. But you are present there.
Yes.
You are present. You did not cooperate with the investigating agency. No, sir. A person who doesn't cooperate with the investigation is not entitled for discussion.
No allegation against him at all.
There is allegation that you have assaulted the other two persons, assaulted seriously. You have also assaulted by hands.
The complaint, my lord, there is no allegation against this person at all. The further statement, Kaigalinda Hodadru anta. And within 3 days, he has been discharged from the hospital, my lord.
Do you mean to say that the moment he is discharged from the hospital, everything is over?
But the incident has been taken place between rivalry between the accused number and municipal, not in.
See what this poor person has sought. ಗಲಾಟೆ ಎದಕ್ಕೆ ಮಾಡ್ತೀರಾ ಅಂತ ಹೇಳಿ ಕೇಳಕ್ ಹೋಗಿದ್ದಷ್ಟೇ. ಅವನೇ ಟಾರ್ಗೆಟ್ ಮಾಡ್ತೀರಾ?
ಇವ್ರು ಮಾಡಿದ accused number 1 and 2.
See, a person, if he is not targeted, why he is absconding then? All along, he is not made available himself for the investigating agency. A person is seeking equitable relief, of discretionary relief, but he doesn't want to do equity.
The parent is cooperated with the investigation.
Surrender agi.
Lord should appreciate it. There is no
I'll
allegation
appreciate it.
against him, my lord.
I'll appreciate it. Sorry. ನೀವು ಏನು ಹೇಳಿದ್ರೆ
Kaigalinda Hodadru wants to serious injuries, my lord.
ಚಾಪರ್ಲಿ ಒಬ್ಬನ್ ಕಡ್ದಾಗ ಕೈಲಿಂದ ಹೊಡೆದ್ರು ಅಂದ್ರು ನೀವು ಸೀರಿಯಸ್ ಆಗಲ್ಲ. ಅಲ್ಲಿ ಇರ್ಲಿ ಅವ್ರ ಅವನ್ಗೆ ಕೆಳಗ್ ಹೊಡೆದ ಕೆಳಗ್ ಕೆಡವಿದಾರೆ, ಆಮ್ಯಾಗ ನೀವು ಮತ್ತೆ ಹೊಡಿತೀರಾ? ವಾಟ್ ವಿಲ್ ಬಿ ರಿಯಾಕ್ಷನ್? ಬಿಡಿಸ್ಕೊಳ್ಳಿಕ್ ಅವ್ನ ಯಾಕೆ ಹೊಡಿತೀರಾ ಅನ್ನೋದು ಬಿಟ್ಟು
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಿತ್ತು, ಅದನ್ನ ಏನು ಹೇಳಿಲ್ಲ. ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್
ಸರ್ ನೀವು ಅಪಿಯರ್ ಆಗ್ಲಿಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್, ಯಾವಾಗ ಥಿಂಗ್ಸ್ ವುಡ್ ಹ್ಯಾವ್ ಬಿನ್ ಮೋರ್ ಕ್ಲಿಯರ್. ಹಿಸ್ ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕ್ಲೇರಿಫೈಸ್. ಸರ್ the petitioner. Petitioner has filed his petition under section 438 of CRPC seeking anticipatory bail in the event of his arrest in Udayagiri PS crime number 28 of 22 registered for the offences punishable under section 323, 324, 307, 506, read with section 34 of the IPC. Third, the arguments advanced by the learned counsel for petitioner and learned HCGP. There is the records. The brief factual matters leading to the case are that on 5/3/22 at 9:30 p.m., the complainant was standing in front of Kaja store at Rajiv Nagar, and at that time he noticed that with previous enmity, accused number 1 to 5 were assaulting CW2 by clubs all over his body. When the complainant went there to rescue CW2, all the accused, including the present petitioner, threatened him with the direct consequences, and accused number 1 assaulted him with a chopper on his head, while accused number 2 assaulted him with a club. While when he collapsed, the other accused, including the present petitioner, assaulted him by hands and kicked him with legs. Later on, the injured was shifted to the hospital, and in this regard, he lodged the complaint. The present petitioner was arraigned as accused number 3. He has approached the learned session judge seeking anticipatory bail, but the learned session judge has rejected the bail petition. Hence, the petitioner is before the court. Having heard the arguments and perusing the records, it is evident that the investigation is concluded and charge sheet has been laid down by the investigating agency. The allegations further disclose that the petitioner, the complainant, has simply intervened when the accused were assaulting CW2 in order to save him, and at that time he was assaulted by accused number 1 with a machete on his head, while accused number 2 has assaulted him by a club, while other accused assaulted him by hands and kicked him. These allegations clearly disclose that the present petitioner was present when the alleged incident has taken place. The wound certificate further disclosed that the injury sustained by the complainant on his head was grievous in nature, while the second injury is simple in nature. No doubt, within 3 days, the complainant was discharged from the hospital, but mere discharge of the complainant from the hospital cannot be a ground to treat the injury in a light way. Admittedly, the present petitioner was absconding all along, and he has not cooperated with the investigating agency during the entire course of the investigation. He has deprived the investigating agency of collection of material evidence, and he is now seeking equitable and discretionary remedy of anticipatory bail. A person who seeks equity must do equity, but in the instant case, the conduct of the petitioner disclosed that all along he is absconding. Though he has not assaulted the complainant by any weapon, however, the allegations disclose that he did assaulted him by hands, that too after assault by chopper, the complainant has collapsed, and even the complainant, the present petitioner has not shown any mercy towards the injured, and even there is no attempt to provide him any medical aid. Looking to these facts and circumstances and conduct of the petitioner in absconding all along, question of entertaining is anticipatory bail under section 438 of CRPC does not arise at all. The remedy of the petitioner is to surrender before the learned session judge, a learned concerned court, and apply for a regular bail. Hence, petition being devoid of any merits does not survive for consideration, and accordingly it stands dismissed. Oh, yes, what happened, sir?
But we have also cautioned them, the parents of the in case if they won't look after in well manner, their property will be forfeited to the now they have agreed. From the day one, they have agreed. But the thing was, the parents of the victim would not agree. Ivaga avaru kuda they also.
The indirect compulsion to the parents of the victim, indirect compulsion ಮಾಡಿದಂಗ ಒಪ್ಕೊಳ್ತಿದ್ದಿಲ್ಲ. ಈಗ ನಿಮ್ ಮಗಳಿಗೆ ಇದನ್ನ ಮಾಡಿದೀನಿ, ಮಗು ಅದೇ ಬಂದ್ ಮದುವೆ ಮಾಡ್ರಿ ಅನ್ನಂಗ ಆಗತ್ತ. Everything is now at the for the sake of the child, because the child should not be called as a bastard child. ಯಾಕೋ ಮನಸ್ಸು ಬರ್ತಾ ಇಲ್ಲ ಕೊಡ್ಲಿಕ್ಕೆ. ಹಂಗ ಕಂಡೀಷನ್ ಹಾಕ್ಲಿಕ್ ಬೇಲ್ ಒಳಗ್ ಹಾಕ್ಲಿಕ್ ಬರಲ್ರಿ. That condition cannot be imposed in a bail petition. That they should marry, he should marry the victim after she attaining age of majority and condition ಹಾಕಕ್ ಬರಲ್ಲ. That is an illegal thing. ಅದನ್ನ ಮಾಡಕ್ ಬರಲ್ಲ. Let me think it's Wednesday ಇಟ್ಟಿರ್ತೀನಿ. Let me think it. ಯಾಕ್ರಿ ಕಲಬುರ್ಗಿ ಬೆಂಚದವ್ರಿಗೆ ಏನ್ ಸಂಬಂಧ ಇಲ್ವಾ? ಅಲ್ಲ ನಿಮ್ಗಾರ ಹೇಳ್ಬೇಕು ಇನಿಷಿಯಲಿ. ಹಾ then report to your AG. ನಿಮ್ AG ಗಮನಕ್ಕೆ ತಗೊಂಡ್ ಬನ್ನಿ.
I'll make this report. Before there was a notification saying that those advocates who are going to the respective bench, they will argue the matter. Gulbarga, the strength is very less. Therefore, when I request that please appearing, they told that the advocate is present here. Will be appearing from the government.
It is for them to intimate the concerned person. Notice ಅವ್ರವ್ರೊಳಗೆ ಏನು ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ, we are least interested. See, we are going to issue notice to them. They will be directed to take notice, not he. And they will come to know that case is filed. They should intimate the local HCJP that you should argue on behalf of the state. That's simple thing. This communication ilde idre.
Now I appeal to the petitioner to start the offense mentioned in the section 143, 147, 148, 324, 504, 506, 302, 307. Read with section 34 of the IPC. This is the petitioner successive application. The Lordship is already aware of the facts since the twice the Lordship has accepted. But I will briefly state the facts so that the courts can jump in the middle of the court. In this case, there was a group of persons were sitting in some remote part of the city of Kalburgi in the night. At the same time, another group had come there. They were hunting for rabbits, the other group. So they, was a remote part of the town, there was no electricity, no light. It was there, this sitting there, and these people also had. Now they were carrying torch with them. Now the torch light flashed on the faces of those who were sitting there. Now this situation of flashing light led to some verbal altercation, and eventually this turned violent, resulting in injury and of one person and one person is dead. In the next this is exactly what has happened. This is the case. However, the complainant has stated that after verbal abuse and cross abuse, this petitioner, so what they say, they go back and this petition, they inform the petitioner. Then petitioner in turn will come to the spot and
I am the Don.
I am the Don of the area. Yes, the Don part. Yes. So I'm the Don of the area. They said, complaint said, we pick him up from the spot, take him to Sonia Gandhi quarters, and there they said that he noticed him and also observed him some residential locality, the book of residential locality with some deadly weapon assault the deceased on his head. Now, the government previously had claimed that the investigation against this present petitioner is still ongoing. That's what they had claimed. The Lordship was right in checking up. Because investigation is was. Now, this petition has a criminal record. That is also they have stated. Saying that this petition has a criminal record. Even in this objection also they have stated that he has many criminal records. So the basis of these two submissions, the Lordship were in its wisdom, in Lordship wisdom, has rejected the bill of petition. Now, my idea here is multiple things. Firstly, the place where the alleged crime has taken place, according to the complaint,
is some Sonia Gandhi photos, the dense neighborhood. That is where the, however, the sketch map, I will, with the permission of the court, I present the sketch map. The Lordship may kindly permit to present the sketch map where this incident has happened. Where so this is the sketch map where the incident is said to have occurred.
Yes.
They will have given the sketch map, right? See the sketch map. I'll
Yes.
sketch map. The complaint and the actual events on the ground are completely a different story. Sketch map, you see the photographs. This is the place. This is the place where these people were sitting. Next page. And this is exactly the place where the incident is. It is a case. It is a very clear-cut case of where two groups, one was sitting, and my information is that these people were sitting at remote place, sleeping there. And these people have gone there for shooting. In the process, that sudden outburst of things resulted in the death of that person on the spot. Nothing nowhere. That the offense of taking him somewhere, assaulting, that absolutely did not happen. But this, the police itself has produced this map is coming from the, so this directly contributes the person which what he has stated in the complaint. So therefore, once the complainant's presence itself becomes very, very doubtful. And the witnesses are also lying there. Blood is also lying there. This can be very clearly made. But this is my first angle. The second angle of that, the second part, the photograph clearly reveals the scene of offense is seen where there was first encounter, not the second encounter as per the complainant. So between the two groups sitting. So therefore, the very act of shifting the venue from some remote place to some other distant place, that's in effect is to mislead the investigation. I think this is a very serious transmission. The very process, the very main.
All these, I think you have argued this matter in the earlier bail petition.
In the earlier bail petition, this material was not brought. Investigation was material.
Let it be. But regarding shifting of the place of offense, you have already argued.
There are minor distinctions.
Correct. You have argued regarding variance in the 161 statement, shifting of the scene of offense. They were also argued.
Who thinks this honorable court had considered?
No, what are the changed circumstances? If I have taken a wrong decision, it is for the next court. Not, I cannot again. No, my simple question is, what is the? You cannot say like that. No, my question is, what is the now other changed circumstances after the passing of the earlier bail order?
That part. Now, earlier, investigation with regard to remote spending, investigations completed 164 statement of one of the witnesses. One statement for a very, very interesting reason. Yet to be unfolded. Take it up in time. I remember that. Only one. He says that this witness before the magistrate has clearly stated this petitioner did not attack the deceased because he was not at that place. Who was at his home? That was the statement I had to face with. This was not there in the other petition.
So subsequent developments you are enlightening.
Yes. So this 164 statement, had it been the case where the 164 statement was brought before the lordship.
Even then I'll ask you. If that is the case, all earlier statements are to be washed away. Only 164 statement, subsequent 164 statement is required to be looked into. All other 161 statement initially recorded wherein his presence was specifically stated by each and every witness.
I put it in this way. Your Lordship has very validly asked this question. Can that wash out this subsequent consistency? Oh, that's no. Your Lordship has previously noted that there are discrepancies in the way statements are covered. However, there is some consistent trend. Now, what they have done, now there is a direct statement before a magistrate saying that this man was not well seen of
Yes, 100%. Now I'm coming to that statement itself. This person has given one statement. All along your two bail petitions were rejected. Now, before filing third bail petition, 164 statement was recorded. The person has rescinded from his 161 statement now. He has given a different version, isn't it?
Sure, his statement was taken 164 before the magistrate.
Therefore, he is reciting with his statement before the IO regarding presence of accused number 1.
This was not the all along. That very incident where the complainant says, where the incident has occurred. The evidence which is not constitution. Standing for two separate things. One is in India, the other is on Himalaya. This is a very important aspect that I use. Because it's not a minor thing. I further look at this. So this is people. I come to this part.
I'm not here to sitting on a ground of discharge. Bear it in mind. You are in a successive bail petition. You have got a very limited scope. I cannot assess the evidence in totality.
But
I cannot assess the evidence in totality.
Yes.
Bear it in mind.
Yes.
Shifting and other things, they were taken note of earlier itself.
164 statement.
Now your trump card is 164 statement.
164 statement. And my lords, this is very important statement saying that I was not present. He was not there.
That was a statement of a one witness.
Why did not they? That is
the therefore, I'm asking you, that was statement of a one witness. There are no other eyewitnesses are present.
That is precisely what my
including that of complainant.
So the lordships, now that the lordships questions are exactly hitting the hammer on the head of the nail. Why did they record the statement of only one witness under 164 when they had all the witnesses available? And he was in prison all alone.
Therefore, there is also the other thing is also there. What was the need for pursuing for recording 164 statement?
Yes.
The other side of the coin is also looked into. When entire regular ones, they are not a victim, a child victim. There was no need.
The reason I will take my notes. Why their statement of 164 was not recorded? I subsequently in my point and tried to address that. But however, you should not have stopped the investigation officer to the sentence. It would have made this particular statement would have been reiterated. That is my submission. But investigation against this petition is not concluded. He is in prison for last 1.5 years. Now, that's the second aspect is the two major gaps in prosecution case. One, the very shifted 164 statement really wakes out that he was not present at the scene of crime. But the third aspect is the legal aspect. Presumption of innocence is in my favor. And that presumption of innocence is now
in bail at the juncture when your two bail petitions were rejected. You cannot argue that presumption of innocence is in your favor. When there are two bail petitions were earlier rejected, you can argue for a change circumstances, but not a on the ground of presumption of innocence.
On both the two occasions, on two occasions, they said the prosecution has said that investigation against this petition is not complete. That is number one. So your lordships, in your lordship's view, that since investigation is not complete, there is no question of me court granting him bail. Now investigation is complete. Number two, second important consideration before the court was that he had a criminal history. Now he is a don. That part, that don part, that is the part which this has to be addressed first, because I cannot let the facts are speaking to me.
Sir, I am not here to give an explanation to my observation.
No. Prosecution.
That was the assertions made by the complainant. He claims to be himself as a Don. That is his assertion. It is the complainant's version that he claimed himself to be Don and assault. That's all.
So therefore, that is a situation where we had a of vetting. That part I want to take you. That concern.
I'm not at this juncture. This is too, you are exceeding your limits, sir. I'm not supposed to give any explanation in this case. No, I am not even to give clarification. It is not my botheration at this juncture. Whatever observation based on records. Now your case is restricted to change circumstances, restrict it to. Otherwise, don't go to the merits of the case. We are not concerned. You are not arguing for discharge. You are not arguing for quashing the proceedings. You are at liberty to go under 482 to cash the entire proceeding in view of the change of scenario. 164 statement. You are at liberty. Here you are restricted, seeking bail, restricted there only.
I understand that. But what has happened is, now, in terms of this, two observations I have to overcome, because one observation is.
See, you cannot overcome, sir. I'm not sitting in a review petition.
Because facts are not brought before one people.
See, it is for you. Yeah, every time I make some observation and again he will come and I will make clarification regarding this observation. No, sir. This is not the way of entertaining a successive bail petition.
Change circumstances for us. I will just come to change.
Just restricted to change circumstances, nothing more.
Change circumstances. Number one circumstances.
You are number one circumstance, subsequent 164 statement. Number two, he is in custody for 1.5 years. Number three, investigation is completed. Only three change circumstances.
And another thing is that insofar as the criminal record which prosecution is doing that he has clearance, with regard to that also
I cannot entertain, sir. I'm sorry.
Yes.
That was the allegation that is to be substantiated during the course of the trial only. It is only for the timing, it is a observation, but that is not the sole ground for rejection of your bail petition. That is not the sole ground.
Three grounds for this. One, yes, what I was imputed against him, and second thing was that he had criminal history and investigation. These are the three grounds which the lordship had before your lordship put to consideration and rejected the bill of petition. Now I am before your lordship that these three grounds. Number one, investigation against him. He has spent more than 1.5 years in prison, and number three, 164 statement clearly makes out a case where he was at the scene of offense, he was not there, and moreover, now it's cumulative. Now what we have cumulatively, if you look at it, see the complaint, yes, there is a discrepancy in 164 statement. Yes. Now 164 statement is coming and saying that it was not there. The length of time here. Now it's the asset of bail also has to be. Reason why I'm saying this. Because the people who were sitting there died. But they were also had a very, very strong criminal history. But the disease itself had 3 murder cases. So witnesses, which are claimed to be brought before the trial, saying that these people were part of the sitting and who had witnessed it. They have a long history, have come out the documents and the videos of everybody, every one of them have at least 4 or 5 heinous offenses against them. So basically, it was a criminal gang sitting there and which was indulging in that activity. These innocent people who had gone there for
so you mean to say that you are no criminal history and they are the only criminal gangs?
Yes, I have no criminal history. I have no criminal history. That I understand. Against me, what they have done, the police members on the night at the institution, the father of the deceased is a very, very powerful man. If the lordship remembers, there was a case in Kalburgi where one inspector, Malikarjun Bande, was shot. That man was shot and he was a co-accused in this case. He absconds. Well, that's for some reason, some political reasons he was found. He also is involved in other supervisions.
Sir, please, you restrict it, sir. You are transversing too much. No, not. You cannot expect the court to give finding in all these aspects. Nothing to warranted, sir. Restricting to this case, restricted to this case.
I'm only trying to make a point that I don't have any criminal history. There is absolutely nothing against me. Saying that I was a criminal itself is without any basis because
Yes.
false case is not against me. What they do is possible. This part, pick me up in the night. But I have CCTV footage. The only reason why I didn't do this, but I have footage saying, showing that I was picked up in the night and then I was taken to the police station. And my client's wife, she writes mail to everybody, including the High Court. That mail to High Court.
Sir, please restrict, sir. You are exceeding your limits, sir. Change the circumstances, customary. Ratri pick up madidara. Those are not the criteria to consider your bail petition at this juncture because earlier none of these issues have been raised. That was there then also. See, we are not concerned about it. You are at liberty to initiate action against the investigating officer if he has floated any of the rules. You are at liberty. You cannot expect in this court I should do something else. See, sir, please. Notary, sir, criminal that is a second. You have come here for bail on changed circumstances, limit it.
I get it.
So, involved in other and I cannot express, I cannot give opinion regarding the facts which were not part of the record. Here regarding CCTV footage and picking up in the midnight, I cannot express anything because they are not the part of the record. And they are no way concerned regarding the granting of bail. They can be concerned, they may be relevant for initiating the action regarding violations of the floating the rules at the time of arrest. What are the rules? What is the requirement? Those are the different things. And law is always open and you can obtain necessary certificate and you can file. That is a different aspect. But let us restrict it to this case only.
These 3 points which were there. Your Lordship, number one.
Yeah.
Yes.
164 statement, where is your presence is disputed, completion of the investigation, and you are in custody for more than 1.5 hours. These are the more major 3 grounds.
Other ground of me having criminal, it has no legal basis. And insofar as the incident itself, it was an incident from the, as we make up, the Lordship also had appreciated. It's an incident which occurred spontaneously on the spot because of this. The other is an improvement done by the investigation officer at the behest of the deceased father, who is a very, very powerful man. You know, this is also another aspect, which I would request the court to kindly take note of. Other than this, there were, if the Lordship permits me, I can submit to residents, if the Lordship, with the permission.
I'll not come in here. There is no issue. But don't traverse argument regarding the case.
Now, one good thing, and again, I told that case also, subsequent some other medical and there was just do that. Just do that. I just limit myself to that. Yeah, this is one particular order here on the basis of one Supreme Court orders. On the basis of 160 there was. Page 2, page 2, second time. After hearing the learned counsel for the parties and taking into consideration statement of prosecutors according to 164 CR, without any opinion merits and evidence, the petition may not be nothing has been said. This is one.
No reasonings were given. Such order, such orders can be passed by Supreme Court, not other courts. 164 statement, it is in respect of a rape. It is in respect of a rape. And prosecutrix herself was a complainant victim. She has resiled. That is a different aspect.
Some ground basis. In this case, madam, to the commission, in this case. Paragraph number 6. Page 3. Admittedly, the petitioner is on bail in all other criminal cases. The High Court of Jurisdiction, Bombay, offers a petition held that some criminal cases petition against the petitioner. Further, this court on 10-1 has started with the official stance on same petition. Next, 11 counsel the petition has also produced a report showing the petitioner had filed a complaint against investigating officer of this case, alleging offense of the prevention of corruption act before Anticipatory. As a party, I will get the opposite. This is successive bail. Earlier it was rejected. Now, subsequently, these notices were looked into. In my case also, they have said that I have criminal history. When in reality, I don't have any criminal history. And what case is forced? I was arrested, and when I made a complaint to Superintendent of Police, Commissioner of Police, to High Court, to the District Court, I have an email which I have filed. Then what they do to escape, screen the officers who are conducting this act. What they do next? They register a false case against me in the Arms Act. And now they say that because there is only one case, and in that also I have been granted bail. What they do, they say that I have a criminal history. And they say that I am a prosecution. After I have it, second thing, I'm quarterly email. But the scene of offense ಕೂಡ ನೋಡಿದ್ರೆ we can make it up for ಹೋಗುದು ಏನು ಜಗಳ ಬಂದಿದ್ದ ಮಾಡಿದ ಅನ್ನೋದು is a thing in view of all these things. If try to establish the practice, okay, it's the practice will also the bail is read into Article 21 also, which I have so many judgments because most of the time I'm not submitting. Therefore, I humbly request this to the court. I will impose a stringent condition and I will grant it.
Okay. That will be in this. James. That's finding of the cash and most if continuing to for a large amount of
Heard. Reserved.
There's one more judgment I did, just to, on the chain circumference. The judgment by Justice I have scholar all over the world. I just the commission of court comments. So very beautifully worded judgment. Unless there's so many aspects of judgment.
Beautifully worded. One we have to be specialized to understand the language of his lordship.
It is always a pleasure to go to the judgment of I am very always happy to now second paragraph briefly state the facts pertaining to the present petition and prayer and from the word right at the beginning, we must mention that the application of bail was rejected by this court. Now, that is this portion removed. But an order refusing an application of bail does not necessarily get another on a later occasion, giving more material, further developments, and different considerations. Same material. While we surely must set store by the circumstances, we cannot accede to the faint view that we are barred from second consideration. this so beautifully, so succinctly, yet so briefly it is important. So here also, case is made up. Nuts. In view of this, I most humbly request stringent condition will be imposed and kind words, liberty will be restored.
Yes, resort. ಎರಡು ಕೋಡ್ ಡಬಲ್ 935 and 9971 common order. These two petitions are filed under section 439 of CRPC. Reserve ಮಾಡಿದೀನಿ ಬೇರೆ ನಡೆಸ್ತಾ ಇದೆ. 439 of CRPC for enlarging the bail, for enlarging the petitioners on bail in Chikballapur town PS PAN number 2 of 2019, registered for the initially registered for the offense under section 420 of the IPC, and subsequently the investigating officer has incorporated the provisions of KPID Act, Karnataka Protection of Interest of Depositors in Financial Establishment Act 2004. For the petitioners were arrested and were remanded to judicial custody. The petitioners have approached the learned session judge seeking regular bail, and their bail petition came to be rejected. Hence, the petitioners are before this court by filing petition under section 439 of CRPC. Next. The ಯಾರ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದಾರೆ ಅದರಲ್ಲಿ? ಅಲ್ಲ, ಈಸ್ HCGP ನವರು ಅಲ್ಲ, ಬೇರೆ ಈ SPP ಇದರಲ್ಲಿ KPID ಆಕ್ಟ್ ಒಳಗೆ 49 and 51. ಅಲ್ಲಲ್ಲ, ಐ ಆಮ್ ನಾಟ್ ಆಸ್ಕಿಂಗ್ ಅಬೌಟ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ಪೆಟಿಷನರ್. ನೀ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ HCGP ನಲ್ಲ ಅವರು ಇವರು ಹೌದು, ಅದನ್ನೇ ಕೇಳಿದೆ ನಾನು. ಯಾಕಂದ್ರೆ ಮತ್ತ ಅದು ಚೇಂಜ್ ಆಗ್ಬಾರ್ದು ಅಂತ. SPP2 ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. HCGP ಬೇರೆ, SPP2 ಅಂತ ಹೇಳಿ ಬೇರೆ ಆಗುತ್ತೆ. SPP2 who is appearing for respondent number 1 state has seriously opposed the bail maintainability of the bail petition and invited the attention of section 16 of the Act wherein an appeal provision is made against any order passed by the special court hence the contention of the learned SPP is that the petition under section 439 of CRPC is not maintainable and remedy for the petitioner is to file an appeal under section 16 of the KPID Act. Third, the learned counsel for petitioners and learned HCGP, learned SPP on maintainability of the application. The learned counsel appearing for petitioners, learned counsels appearing for petitioners would contend that the Act, the KPID Act does not bar filing any petition under section 439 of CRPC, and the petitioners are not challenging the order of rejection of the bail by the special judge. They would further contend that the right of liberty under Constitution is involved, right of liberty under Article 21 of the Constitution is involved, and hence under section 16 of the Act, that right cannot be deprived. Hence, he would contend that this court is having concurrent jurisdiction under section 439 of CRPC. It can entertain the petition under section 439 and the bar under section 16 is not applicable. Next. Per contra, the learned counsel for the learned SPP would contend that the KPID Act is a special enactment and it prevails over general provision, and the provisions of the enactment will prevail over general provisions. He would also invite the attention of the court towards the intention of the legislation in enacting the Act and scheme of the Act. He would further assert that the interest of the legislation is to protect the interest of the depositors. He would also invite the attention of the court to section 618 of the KPID Act, which is having a overriding effect, and as such, he would contend that in view of the overriding effect under section 18, and when there is an alternative remedy provided under the Act, the provisions of section 439 cannot be invoked for grant of bail. Hence, he would contend that the present petition is not maintainable, but the petitioners are required to file an appeal. Having heard the arguments and after perusing the records, it is an undisputed fact that initially the complaint was filed under section 420 of IPC and FIR was issued for the offense under section 420 of IPC. It is in respect of cheating the depositors by a cooperative society without repayment of the deposited amount by the directors of the deposit society. However, subsequently, the investigating officer has submitted a requisition to the court on 18/6/22 for incorporating the provisions of section 9 of the KPID Act along with section 120 of IPC. The document further disclosed that the learned magistrate, by order dated 18/6/22, by exercising his powers under section 155 subclause 2 of CRPC, has granted permission to register the case under the provisions of KPID Act and proceed with the investigation. There is no dispute of the fact that initially the bail petition under section 439 was not barred when the initial offense was only under section 420 of IPC, but the issue has been raised only when the provisions of KPID Act have been incorporated. In view of these contentions, now it is necessary to consider section 16 of the Act, KPID Act. Section 16, for the sake of convenience, section 16 is reproduced here with section 16 statement. Hence, the provisions of section 16 makes it very clear that any person who is aggrieved by an order of the special court may appeal to a high court within 30 days from the date of the said order. Though initially it is argued that the petitioners are not challenging the order passed by the learned special court, but it is evident from the pleadings that they are aggrieved by the order of the learned special court which can be borne out from pleadings made in para number 5 of the petition. Hence, though only the relief is sought is only regarding the bail, but in fact, they are aggrieved by the order passed by the learned session judge, learned special court, bar principal district and session judge. Apart from that, it is also important to note here that the bail is being sought pertaining to offence under section 420 IPC and under section 9 of the KPID Act 2004. Any order regarding KPID Act is required to be passed by the special court alone, whether it is under section 439 or otherwise. This order of the learned special judge is pertaining to rejection of the bail petition for the offence under section 9 of the KPID Act itself. Hence, it is evident that the petitioners are aggrieved by the order of the special court in respect of the rejection of the bail by the special court for the offence punishable under section 9 of the KPID Act. Hence, under section 16, there is a specific bar for challenging. There is a specific bar to entertain any petition other than the appeal. The learned counsel for learned counsels for petitioners would contend that the statutory restrictions under the KPID Act would per se does not oust the jurisdiction of the court under section 439 of CRPC. In this context, he placed reliance on the provisions of on addition of the apex court in 2021 part 3 SCC page 713. And contended that the constitutional courts are having power to grant bail, and the provision of KPID Act cannot oust the ability of the constitutional court. But it is important to note here that the said decision was in respect of statutory restriction under 43D, subclause 5 of UPA Act. The apex court has considered when the statutory restriction is not material, considering the fact of long period of incarceration, unlikelihood of trial being completed anytime in near future, along with right of liberty. But no such facts are forthcoming. And when there was a restriction under the Act for grant of bail, the Honorable Apex Court has held that discretion and the constitutional powers for exercising bail by High Court cannot be restricted. But here, there is no specific bar under the KPID Act to seek a bail, but the remedy was by way of an appeal. But under the UPA Act, no such alternative remedy was available, and there was complete restriction for grant of entertaining bail. But in the instant case, there is under section 16, there is a specific provision for granting the, for challenging the, or any order passed by the special court, and any order includes the order of granting or rejecting the bail. Next. It is the learned SPP would also bring to the notice the provisions of section 18 of the Act, section 19 of the Act, and section 19 has overriding effect over all other laws. Section 19 reads as under section 19. Hence, when any provisions of this Act are inconsistent with any other law for the time being in force, the provisions of this Act will prevail, and this Act is having a overriding effect. Further, section 18 deals with special powers regarding the offenses. Under section 18 subclause 1, the statute stipulates that without committing the matter to the court shall try the case and shall follow the procedure provided under the Code of Criminal Procedure for trial of warrant cases. By incorporating this provision, the legislators have shown their inclination to what extent, to show their inclination as to what extent the provisions of CRPC can be made applicable. The same is again specified in subclause 2, wherein it is held that the provisions of section 438 of CRPC are not applicable to the provisions under this Act, which bars relief under 430 anticipatory bail. But the tone of the tone of section clarifies that the Act has overriding effect over other provisions of law. In this regard, the learned SPP has placed reliance on edition reported in 2008 part 3 SCC page 874 and invites the attention of the court to para number 8, 9 and 15 of the said judgment. In the said case, the Honorable Apex had an occasion to deal with the powers of the power and jurisdiction to impound the passport to be exercised under Passport Act 1967 under section 104 of the said act. Under the provisions of the said act, the Honorable Apex Court has clearly held that though the Section 104 of CRPC authorizes the court to impound a document or thing produced before it, but it has held that the specific provision is being made in a special enactment, the same shall prevail. This issue is again clarified by the Honorable Apex, by the division bench of this court in Criminal Appeal number 1078 of 2020, dated 30th March 2021, wherein a similar issue arose in pursuance of Section 14A, capital A, of Scheduled Caste and Scheduled Tribes PC Act. And the court has held, has framed a point as to whether criminal petition or criminal appeal is maintainable against an order of court, special court or exclusive court in granting or refusing the bail. This aspect has been discussed in detail. The Honorable, by the division bench of this court, has specifically observed that since the SC/ST Act is a special enactment under Section 14A subclause 2, the appeal is maintainable and in view of the available of remedy of appeal under Section 14A subclause 2, it will not be open to the High Court to exercise original concurrent jurisdiction under Section 438 and 439 of CRPC. In the instant case also, there is a remedy available under Section 16 of the Act, and when there is a specific provision of appeal, it is not open for the court. It is not open for the court to exercise the original or concurrent jurisdiction under Section 438 of and 439 of CRPC. The division bench edition of this court referred above Lokesh case covers entire issue which is also involved in the present case and answers the same, holding that it is this the provisions of special court will prevail when there is a specific provision is made by granting an alternate remedy. Under these circumstances, looking to these facts and circumstances, the appeal is not at all maintained. The petition under 438 or 439 is not at all maintainable, and the only remedy is to file an appeal under Section 16 of the KPID Act. Hence, both the petitions does not survive for consideration, and accordingly, both the petitions stand dismissed with a liberty to both the petitioners to file an appeal under section 16 of the Act. I cannot say anything. That is the discretion of the appellate court. You are prosecuting in a different court. That does not take away your right. In fact, this is lengthy order bekagilla that division bench edition has discussed everything. The SC/ST Act is the KPID Act, stay difference. But you can, it is the discretion of the court. Appeal is the discretion is vested with the court because appeal has got having vast powers. Appellate court. Appellate court is having better powers compared to 482 agli, 439 agli, or writ petition agli. Ali compare madidre il power increase ಹೆಚ್ಚಾಗುತ್ತೆ. ಮೊದಲಿನ ಬರ್ಕೊಂಡಿದ್ದೆ ನೋಟ್ಸ್.
ನಮ್ದು ಹಂಗಾಗಿನೇ ಪರಿಸ್ಥಿತಿ ಏನಿದೆ ಅಂತ ನಾ ಹತ್ರ ಹೋಗದೆ ಇದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ಹೊಟ್ಟೆ ಊಟ ಮಾಡ್ತೀನಿ ಬರ್ಲಿಲ್ಲ ಅನ್ನೋದು ಅದಕ್ಕೆ ಮುಗ್ತಾ ಇದೆ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಆರಾಮ
along with the legislation. Along with the ಈ ಕಳಿಸ್ಬೇಕಾ ಮೇಡಮ್ ದುಡ್ಡು? ಮೆಟ್ರೋ ಇದೆ. ನೋಡಿ ಎಷ್ಟು The statement of objections is from 975. From 975 ಅದೇನಾಯ್ತು ರಿಪೀಟ್ ಅದೇ ಅವ್ರದ್ದು ಅದೆಲ್ಲಿ ಹೋಗಿ ಒಂದು 2-3 ನಿಮಿಷ ಬಿಟ್ಟು ಅವಾಗ ನಮ್ಗಮ್ಮ ಅಲ್ಲ ಇಲ್ಲ ಅಲ್ಲೇ ಇರ್ಲಿ
ಮೇಡಮ್ ಒಂದಿಗೆ ರೀತಿ
ಅಲ್ಲ ಸರ್ ನೀವು
ಯಾವ ಡೇಟ್ ಬರ್ತೀನಿ